that?
Why don't we do that? Okay, we're good.
How are you today? Can I hit that mark? Either it will be an A or the other ones are numbered.
Yeah, we'll do that.
Court will come to order, all rise. Circuit Court of Nicholson County is now in session. Now will Judge Nick Thomas presiding.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Good morning. Please be seated. Do we have everybody? Good morning. I understand we're still waiting for Mr. Wilson and
Yes, and
Mr. Hollander.
Mr. Hollander, he's up on 8.
Okay.
You had a plea on at 8:30 in front of Judge Brandon.
Okay.
I do.
Hollander still doing the plea in front of Judge Braining?
Trying to find out right now.
All right.
Said he's just finishing his plea right now.
Okay, thank you. All right, so Mr. Hollander is just finishing up with Judge Braining, so we'll wait until he gets here, and then we'll bring up Mr. Wilson and make him proceed.
Yes, sir. Thank you. Yes. I instructed the doctors to refer to them generically as jail records and leave them at that instead of Department of Corrections records. Just generically as jail records and leave it at that, because if you get any more explicit than that, then the jury's going to make inferences that they shouldn't be making.
What?
Mr. Hollander's leaving 8B. Come down here.
He's in 8B.
He's leaving.
Oh,
right there.
okay, thank you. And Judge Braining started at 8:30? Okay. record reflect, State's President, Defense Counsel, and the defendant are all present.
Good morning, Your Honor.
Good morning.
Sarah Miller and Andreas Gardner on behalf of the state.
Kevin Shirley, Mr. Hollander, and Ms. Perez on behalf of Mr. Wilson.
All right, Mr. Perez, if you'll put your full name on the record for us.
Gwendolyn Perez.
Thank you. And the defendant is present. We're ready to proceed this morning.
Judge, we do just have a few issues we want to put on the record. Mr. Shirley and I spoke. We have all three of our experts sitting in the courtroom. The state has Dr. Michael Herkov over here. The defense has Dr. Hyman Eisenstein and Dr. Mark Mills. When we go through the diagnoses and the records, all of the medical records regarding mental health are from the jail. They cannot be characterized any other way. Defense has agreed with that. So the issue is we've asked the experts to just refer to them generally as jail records or incarcerative records so that there's no mention of what he was in jail for or why. But I just want to put that on the record. That's what we've agreed to. The experts understand that. They're not going to go into great detail about why he was there, but the records are critical in this part of the proceeding.
Okay. Mr. Shirley?
She's absolutely correct.
Okay. So no objection, and you stipulate to that?
Yes, sir.
And Mr. Wilson, you're aware of that as well, and you're okay with
Yes.
that? Okay.
And Your Honor, the other, there is a letter that the defendant's sister wrote. It's not admissible given that it's hearsay. However, she was not flown in for this part of the proceedings, so the state is not going to object through that being admitted through their experts. So I want to put that on the record as well.
So the state stipulates to admission of that?
Yes, Your Honor.
In addition, under 921-141-1, hearsay can be admissible in the penalty phase. So, but we appreciate the state's stipulation.
All right. If the state's stipulating to it, then that's fine.
Your Honor, there is also a proffer Mr. Shirley discussed with me this morning regarding some photos. So I don't know if we want to do that after the state rests in the penalty phase or if we want to do that now.
I would rather do it as we get ready to close our case.
Okay.
If I may.
Explain a little bit more about what you're talking
Yeah,
about.
I've got some photographs of Mr. Wilson in both individually and in a family context as he grew up. We don't have anybody here that was present when the photographs were taken that can say that they're fair and accurate depictions, with the exception of Mr. Wilson himself.
Okay.
Mr. Wilson has the absolute right not to testify. I'm going to proffer them. Mr. Wilson's going to invoke his right. I want them part of the record, but just proffered so that they're part of the file in case post-conviction proceedings come down the pipe. You understand?
I do.
Okay.
All right.
But I don't want to do that right now.
That's fine.
I'd rather just do it at the time that you inquire of Mr. Wilson as to whether or not he's going to testify.
Right.
Okay.
All right. And just, I guess, while we're on that subject, Mr. Wilson, as I stated before during the earlier phase, you have the right to testify or not testify. It's your decision. No one can make you testify if you don't want to. No one can tell you to testify if you don't want to. So it's only your decision. And no one can tell you, and no one can prevent you from testifying if you want to. That's what I meant to say. So just bear that in mind. We'll have that conversation at a later point. Does the state have a copy of the preliminary instructions that were agreed to? And I guess, have they been agreed to first, the preliminary instructions?
Those were the ones that the court provided us last time that we were before the court.
Okay.
The state did not have an objection to what the court had presented to the state. I can print out an additional copy if the court would like.
Yes.
Very well.
And we didn't have any objection either.
Okay.
Yes.
And I know I asked before, but I'll ask again. You want me to read that portion of the instruction related to the defendant's right to remain silent?
Yes, please. You got a mess going on.
If you'll, and actually, Chicago, if you'll show that to the defense, make sure that they're in agreement with what the state's promulgated.
Wait. Yeah, they are. Hold on. Aggravations and aggravating factor. This was added.
This is, okay. It's the updated version.
I'm going to assume this is updated. Yeah. I save it.
Andreas, we just have to eliminate that highlighted line. Other than that, it's fine, thank you.
Can you email those to me so I can make edits? Because I see you still left in some parentheses and other words that weren't taken out, like court deputy, bailiff, those things.
I have to find that letter again.
Also, in among where it says among the mitigating. Wait, never mind. I'm sorry. That's in the final. And yeah, you're going to remove the highlighted section.
What do you mean? I gave you a stack of them.
I already had it marked by the clerk.
Here they are.
Yes, but I already had one marked by the clerk.
Yeah, would you like us to print a copy with the edits made? Yes.
Yes, please.
Thank you. So it was just the bailiff parentheses and
That was-
then that highlighted portion.
I
Those are
believe
the
that's
two
correct.
edits. Okay.
Okay, got it.
Do we have notebooks for the alternate jurors?
Yes.
Okay. So everybody's notebooks are out there. Okay.
This has the parentheses removed as well as the given necessary language.
All right. Any objections to the preliminary instructions, this draft that's been presented to the court as promulgated by the state? Any objections from the defense?
No, it's fine, Judge, thank you.
All right, very well. And then, so we'll bring the jurors out. We've got the alternates back. Everybody has their notebooks back on on their seats. Anything else we need to address prior to bringing the jurors out?
No, Your Honor.
Okay. Let's bring them out.
Jurors entering.
All right, please be seated. Ladies and gentlemen of the jury, welcome back. By a show of hands, was anyone on the jury unable to follow the court's previous instructions about doing any research, looking up anything, or discussing anything about their service as a juror on this case? Seeing no hands, we're ready to proceed. Members of the jury, you have found the defendant guilty of 2 counts of first-degree murder. The only issue before you in this phase of the trial is to determine the appropriate penalty. The penalty for each of these crimes is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it will be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence. The witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. This evidence, along with the evidence that you heard during the guilt phase of this trial, is presented for you to determine whether the state proved beyond a reasonable doubt the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors are sufficient and whether the aggravating factors outweigh any mitigating circumstances the defendant proves by the greater weight of the evidence. Finally, you will decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. At the conclusion of the evidence and after the argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision. The aggravating factors alleged by the state in this case are: 1. Wade Wilson was previously convicted of a felony and was under sentence of imprisonment or on community control or on felony probation at the time he committed the first-degree murder in this case. 2. Wade Wilson was previously or contemporaneously convicted of another capital felony or a felony involving the use or threat of violence to another person. 3. The first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to, or even enjoyment of, the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was consciously or pitiless and was unnecessarily torturous to Kristine Melton or Diane Ruiz. 4. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation, demonstrated by a substantial period of reflection, is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. Once the state has presented evidence of the existence of aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. Mitigating circumstances. A mitigating circumstance can be anything that might indicate the death penalty is not appropriate for the defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law. After the final instructions are given, the alternate jurors will be released and you will begin your deliberations. You should not form any definite or fixed opinion until you have heard all the evidence, the argument of the lawyers, and my instructions on the law. Until that time, you should not discuss the case among yourselves. Your decision must be based solely on the evidence or lack of evidence and the law. During the penalty phase, the court may take recesses, and you would be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may not use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double-check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. The penalty phase must be tried by you only on the evidence presented in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned or use the internet to look at maps or pictures to see any place discussed during the penalty phase. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. Do not let even the closest family members make comments to you or ask questions about the penalty phase. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. From the exercise of the defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or an appropriate sentence, and the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. The attorneys are trained in the rules of evidence and the trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer. It may be necessary to confer with the attorneys out of your hearing to discuss the matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted to consume as little of your time as is necessary. Can I have counsel approach? Ready to proceed?
Yes, Your Honor.
And Ms. Shirley, is defense ready to proceed?
Yes, sir. Thank you.
All right.
Good morning. A little bit over a week ago, when we first met, the defendant was unknown to you, and he was presumed by every one of you to be innocent. That's now changed, because collectively, unanimously, you all have heard the horrific, graphic facts of this particular case and determined him to be guilty of each of the charges with which we've charged. The phase of this trial is penalty. The state of Florida is asking you to sentence the defendant to the ultimate penalty, and that's death. Not all murders are first-degree murders, ladies and gentlemen. Not all first-degree murders warrant the death penalty. It's only those murders that the state proves beyond an exclusion, and to the exclusion of every reasonable doubt, whereby a first-degree murder is aggravated, that death is warranted. Now, a little bit over a week ago, the burden was on the state to prove the first-degree murders beyond a reasonable doubt. And this week, it's our burden to prove the aggravation of those first-degree murders beyond a reasonable doubt. In this phase, we're going to focus on what makes this first-degree murder aggravated. Now, as the court instructed you, before there is a sentence of death, you must unanimously agree that at least one aggravator, just one, has been proven beyond a reasonable doubt. We are submitting to you four aggravators. 4 aggravators for one of the first-degree murders and 4 aggravators for the second first-degree murder. Ladies and gentlemen, 3 of which, on each, you've already decided. It was inherent in your verdict. 3 of which have already been proven. 1 you're going to hear about shortly here today. The first 2 I want to talk to you a little bit about. One is called cold, calculated, and premeditated. The second one is referred to as heinous, atrocious, and cruel. Now, these might be aggravators that you may have heard about over the course of your life, but I want to go through them with you. The first one is called cold, calculated, and premeditated. Now, what this factor forces you to do is it forces you to essentially consider what his plans were and what his intent was at the time of the killing. Okay? The aggravator forces you to consider what he went through for the killing. Okay? And the evidence that we've presented to you during the course of the trial already proves this factor. It involved 3 things, ladies and gentlemen. And I would submit to you, he selected, he secluded, and then he strangled. That's what he went through to establish cold, calculated, and premeditated. Remember what he said. He was a lion. They were his prey. He could sense it. It just took him 2 minutes. They wouldn't scream. They wouldn't yell. He wouldn't get hurt. He wouldn't get scratched. They couldn't get away. Even if they wanted to, he was too strong. Those were the people that he went after. On the 7th of October of 2019, he went after Kristine Melton. It started at the Buddha, right? He calmly befriends her. He goes up to Miss Johnson, who's your friend. he introduces himself as JR. He doesn't, introduce himself as Wade Wilson. No. He introduces him as JR. He gives a fake name. He calmly befriends them. He's selected Miss Melton. That's who he was going after. He gains her trust. They go outside. He could have gone home with Miss Montanez. No. He chooses to go with Miss Melton. Where? To Mr. Shepard's. Where they become intimately involved. Where they subsequently leave and they go back to Miss Melton's apartment. And what does he do there? He waits. He waits for Miss Johnson to check with Miss Melton. Are you okay? You good? Yeah. Good. Why? Because Miss Melton has put her trust in this person. She's been intimately involved with this person. He's waiting. He has selected her. Miss Johnson leaves. There's no cause for concern, and no triggers, no red flags. Why? Because he's charming, right? 9 times out of 10, it works. It's worked here. Now, he's got Miss Melton all to himself. He's managed to seclude her like a lion with his prey.
Can I have counsel approved for just a second, please?
Once again, the evidence during the course of our guilt phase showed you. He waited. What did he tell his father? He waited for her to fall asleep. And then what wound up happening? Well, he waited because he told detectives he doesn't get scratched, doesn't get hurt, quiet, they don't yell, they don't get away. He's too strong. What does he do then? He goes ahead and inflicts blunt force trauma upon Miss Kristine Melton. And then he goes ahead and places his hands around her throat, applies pressure until she is dead. Remember the broken nails? Ladies and gentlemen, the long, drawn-out nature and circumstances surrounding Miss Kristine Melton's death is cold, calculated, and premeditated. He selected her, he secluded her, he strangled her. Cold, calculated, premeditated also applies to Miss Diane Ruiz. Remember what he told detectives. I've already done it I'm going to do it again. That's what was going through his head. Cold, calculated, premeditated. Hours later, that same day, he's in Miss Melton's car. He comes across Miss Ruiz. He tells detectives the way he approaches her is he asks her, "Where is the school?" He calmly befriends her, manages to get her in the car. What does he say? He says, "We drove to the school?" I was going to drop her off, but in my mind, I knew that I wasn't. And as soon as she was going to get out, I grabbed her by the neck and choked her. She came back to life 3 or 4 times. He didn't do that until he secluded her, ladies and gentlemen. He selected her, secluded, and then strangled. Not once, not twice, not 3 times, but according to him, she came back to life 4 times. And he told you he was not going to let her go. He told detectives, I was going to drop her off, but I knew in my mind I wasn't going to. That's cold, that's calculated, that's premeditated. Heinous, atrocious, and cruel. The law says it is one that is accompanied by additional acts that show the crime was conscienceless, pitiless, and was unnecessarily torturous to Kristine Melton nor Diane Ruiz. It focuses on the means and manner in which the death is inflicted and the immediate circumstances surrounding the death. Ladies and gentlemen, the reason why we submitted those photographs of those injuries, okay, in addition to the medical examiner's testimony, is because those pictures demonstrate what words can't do justice to in terms of heinousness, atrocity, and the cruelty of these murders. Both Kristine Melton and Diane Ruiz endured a high degree of pain, utter indifference. It was outrageously wicked, vile, and shockingly evil, according to the jury instructions. With regards to Kristine Melton, what did you learn? She had a large number of bruises around her body and on her face. She had swollen eyes. She had contusions. She had bruising all over her torso and her arms. She had hemorrhaging on her neck. She had scalp bruising all over. When they removed it, all over. Dr. Coyne described that the blunt force trauma that was inflicted upon Miss Melton was so significant that the force that was directed towards the outside of Miss Melton went to the inside. Okay? All the forces went inward to her body. And what did you hear? You heard about contusions to her lungs. You heard about her liver. You heard about her bladder. You heard about her colon. You heard about her brain swelling, ladies and gentlemen. Remember the brain swelling? The doctor specifically said that didn't happen after the strangulation. That happened before. And that's all prior to the strangulation itself. That's before he puts his hands around her throat, applies pressure to the point where her life leaves her body. High degree of pain with utter indifference. Beat her, strangled her. He didn't care whether she lived or died. That is utter indifference. We get to Diane Ruiz, right? What do we know from her? Fracture of the nasal bone. Bruising on both sides of her body. We know about bruising to the back of her forearm, the back of her left hand, the broken finger. We know about, contusions on her upper back. We know about the hyoid bone broken. We know about the tracheal cartilage also being injured. We know about the multiple rib fractures, not only in the front, but also in the back, from significant compression. And then we learn about the hemorrhage to the back of her neck, right? Ladies and gentlemen, we learned that the struggle was so intense that Dr. Coyne said, when we looked at the autopsies of both women from the internal and the external examination, he learned, and now you, that their struggle for the last moments of their life was intense. And we know that he showed utter indifference. So, ladies and gentlemen, we are not going to be putting on evidence today with regards to cold, calculated, and premeditated. We will not be presenting you with any further evidence of any heinous, atrocious, and cruel, because quite candidly, the evidence is already before you and is in a matter of the record. Now, the court is also going to give you an instruction that says you're going to hear about the defendant was previously or contemporaneously convicted of another capital felony or a felony involving the use or threat of violence to the person. Ladies and gentlemen, this too is inherent in your verdict and has been proven by the evidence because of the contemporaneous convictions for first-degree murder involving both Miss Diane Ruiz and Miss Kristine Melton. When you found for one, you also found for the other and vice versa. Let me explain. He was contemporaneously convicted of a capital felony. Capital felony is first-degree murder. You found him guilty of first-degree murder, not once, but twice. Met that portion of it. Or it's a felony involving the use or threat of violence to the person. First-degree murder, ladies and gentlemen, is a felony involving the use of violence, the threat of violence to the person. So as you can see, you've already found that as well. The one you're going to hear about today is that the capital felony was committed while a person previously convicted of a felony or under a sentence of imprisonment or on community control or on felony probation. You're going to learn that the defendant was on probation for a felony out of Palm Beach. He was sentenced on September 18th, 2019, just 2.5 weeks prior to these murders. Lastly, ladies and gentlemen, you're going to hear victim impact. You're going to hear and that it's not evidence of aggravating factors. Okay? What it does show is it does show the uniqueness of Ms. Melton and Ms. Ruiz and the resultant loss that their death caused the community. Now, the judge is going to instruct you in this trial about the process that you'll have to undergo, okay? And process you have to undergo to determine your sentence is that there's no mathematical equation, ladies and gentlemen, okay, that you have to understand. It's just a weighing process. It's where you get to determine the weight, the substance of the aggravation, and you get to compare it with the mitigation. That's it. And during the course of this case, you may have been thinking, you know what, I'd like to know a little bit more about Mr. Wilson. And what we expect you'll hear is that you'll hear from some doctors, and we expect that the defense will put on and tell you that the defendant has some mental health issues, and we expect that they'll blame some of his history, and they'll be offering this to you. We expect as mitigation for the murders of Ms. Kristine Melton and Ms. Diane Ruiz. Now, the law that you will hear and that you heard during jury selection and that you're going to hear again after, you're going to be instructed that this doesn't compel you, okay, or require you to determine that the defendant be sentenced to death. It does neither of those things, okay? The question before you, ladies and gentlemen, is whether the aggravation, once fully proven, is whether it's sufficient to warrant the death penalty. And ladies and gentlemen, on behalf of the state of Florida, I submit to you, it is. Thank you for your time.
Sure.
Thank you. Good morning. I haven't had an opportunity to talk to you since jury selection, so I've looked forward to this. I'm sorry, Judge. I'll take it up with him when I get back to Charlotte County. Thank you. This is an opening statement. I want to caution you on one thing. Anything that the state says, anything that I say in either opening or closing isn't evidence. We're going to have remarks to you. We're going to have a lot more remarks to you in closing argument, because that's what it is. It's argument. But please, we're not trying to deceive you or mislead you or anything. We're sitting here listening to the witnesses. We're taking notes. And you know, maybe we heard it different than what you heard it. There are some remarks that Mr. Gardner just made to you with regard to evidence that came to your attention. I dispute some of those, but we're going to argue those later in this particular proceeding. You use your recollection. You've been taking notes. You get to take notes again during this part of the proceeding. You get to rely on other jurors' recollection of the facts and circumstances as they were presented to you that resulted in the conviction of Mr. Wilson, and you rely on those. Don't rely on the state or I to be 100% factually accurate in all of our representations to you. On behalf of myself, Mr. Hollander, Ms. Perez, more particularly Mr. Wilson, We want to extend our appreciation. What we're going to be asking of you is probably going to be one of the most difficult decisions you'll ever have to make during your lifetime. We know that. We appreciate it. You might be a little bit, confused wouldn't be the right word, because as you sit here, you know there's only two possible penalties. One is life in prison, which means Mr. Wilson would go to prison for the rest of his life. Mr. Wilson will die in prison, or the death penalty, in which case Mr. Wilson will die in prison. The state has told you that they're going to primarily rely on evidence that's already come to your attention. Well, we're going to do that too when we're arguing against the aggravating factors. I'll tell you right from the start, the state has one aggravating factor. I'm not going to argue against it. The fact that there were two homicides that were committed contemporaneously, that's one of their aggravating factors. To argue against that would be ludicrous, and I wouldn't want to try and mislead you. The other one is the fact that Mr. Wilson was on probation at the time that this offense was committed. The beauty of this particular law is that you get to determine what weight you're going to give to these aggravating factors versus the mitigating circumstances. Obviously, we dispute the cold, calculated, and premeditated. The judge has already read the instruction to you. I'm not going to read the instruction in its entirety because this isn't that part of the trial. But please keep in mind as you're contemplating these things that it requires a heightened level of premeditation demonstrated by a substantial period of reflection. This isn't just a spur-of-the-moment type of thing. Oh, something pops into somebody's head and they act upon it. It requires a substantial premeditation. We'll get into the argument on that later, and I'll be able to show you examples from the record. The other is with regard to heinous, atrocious, and cruel. That isn't the jury instruction. The jury instruction is especially heinous, atrocious, and cruel. And the judge has already given you instructions on what heinous, atrocious, and cruel means and given you examples in the instruction. But the judge doesn't give you and is not going to give you an instruction on especially what makes this particular offense worthy of even your consideration of the death penalty. Why is this that one case that stands out? And you're going to have to make that decision, and that's the big decision with regard to that aggravating factor. Now, you're going to hear some mitigating circumstances, and we've already talked about this. We talked about it in jury selection. The reason they're called circumstances and not factors is because they don't have to be proven beyond every reasonable doubt. They only have to be proven to you by a greater weight of the evidence, a little bit more than not, as we talked about in jury selection. Among the mitigating circumstances, Mr. Gardner even alluded to it. You can take all kinds of things in Mr. Wilson's life and treat them as mitigating circumstance. The few things that you've heard about him from the record seem horrendous. But if you go back and you recall the testimony of witnesses, and this evidence has already been shown to you, when the witnesses were questioned about what Mr. Wilson was like when he's not on drugs, he's charming, he's polite, he's cool. I didn't know they still use that phrase. He's in a good mood, he's friendly, he's outgoing. These are all mitigating circumstances that you can take into consideration when you're weighing them against aggravating factors. The other type of mitigating circumstance that you can use is mental illness. Now, we have two doctors that are going to testify before you here shortly. Dr. Hyman Eisenstein, who's seated over there, he is a neuropsychologist. He will tell you what a neuropsychologist is. He'll tell you what his education is. He'll tell you what his experience is. He'll tell you why he is a person that can make judgment decisions and give you his opinion as to somebody's mental status. He will tell you that he met Wade Wilson, went and sat with him on a couple of different occasions. He'll tell you the batteries of tests that he had Mr. Wilson perform. He'll tell you, well, he'll describe what the tests are and what they're designed to do. He'll tell you how Mr. Wilson did on each of these tests, and then he'll tell you what his conclusion is. I'm not going to tell you, but I expect you to sit and listen. And I apologize in advance. Some of it may not be exciting stuff like some of the things that you've heard. It may be closer to that testimony like DNA evidence, but I know that you're going to pay attention because this portion of the trial is critical. It's critical to you, and it's critical to Mr. Wilson. Then we're going to have Dr. Mark Mills testify. Dr. Mills is a psychiatrist. He met with Mr. Wilson on a couple of occasions. They didn't get to perform any of the tests that Dr. Mills wanted Mr. Wilson to perform. But he, like Dr. Eisenstein, did a lot of background research, contacted relatives of the defendant, that went over the discovery, went over numerous records from other sources, and he will tell you what his opinion is with regard to Mr. Wilson's mental status and why. Now, we anticipate that the state is going to provide another doctor, Dr. Herkov, who likewise is going to get up there and tell you that he met with Mr. Wilson and he has reviewed documents prepared by my two doctors, and he'll tell you what his conclusion is. And then you're just going to have to decide which one of the doctors you're going to give the greater weight to as far as formulating your opinion. But I want you to be able to sit and write this down when you hear from these doctors, the different terms that they're going to use. We anticipate they're going to use terms like schizophrenic and bipolar, hallucination, adjustment disorders, suicidal, paranoia, delusional. They're going to tell you what those things mean. Then you're going to have to figure out whether or not Mr. Wilson's mental status rises to the level of your consideration to allow him to live. We're going to try and display to you what the thought processes were that were going through Mr. Wilson's head when these events occurred, why they were exacerbated by the consumption of controlled substances. This isn't an excuse for what happened. You've already decided that he killed these two women. We're not trying to excuse his conduct. We're trying to explain to you why somebody who's charming, polite, and cool would have done this. And it was something other than taking drugs that made it beyond Mr. Wilson's control. We believe that after you've, and there's a letter you're going to have an opportunity to read, a letter that was drafted by Mr. Wilson's sister that was provided to both of our expert witnesses, that they took that into consideration. They had a chance to talk to his sister. They had a chance to talk to his mom and dad. They got background information that I don't know that Dr. Herkov has, but nevertheless they have it. And along with the other documents that they've reviewed, they'll tell you how they took that information into consideration. We believe that after you have entertained our mitigating circumstances, you will go back there, you'll do what you need to, have discussions amongst yourself, you'll figure out what facts are really facts and which recitation and closing argument is a variation of the facts. We believe that you will come back, you will return the only recommendation that you can once you finish that weighing process, and that would be the recommendation of life in prison where Mr. Wilson will die. Thank you.
State.
So we'd like to call Ms. Lisa Lansky.
So just face the clerk, raise your right hand, she'll swear you in.
You solemnly swear at law firm that the testimony you give will be the truth, the whole truth, and nothing but the truth. I do.
All right, take the stand.
Good morning, ma'am.
Morning.
Please introduce yourself to ladies and gentlemen of the jury by telling them your name.
Lisa Lansky,
And Ms. Lansky, where do you work?
the Cape Coral Police Department.
And what do you do for the Cape Coral Police Department?
I'm a forensic specialist. I mostly do latent print examination.
And how long have you been a forensic specialist?
24 years,
How long have you been doing latent print examinations?
about the same time, 24 years.
What training have you received as it relates to latent print examinations?
Well, I've got a number of continuing education credits in latent print examination topics, and I am certified as a latent print examiner by the International Association for Identification.
Approximately how many latent print type of comparisons have you conducted over your time with the Cape Coral Police Department?
Wow, I don't know if I could even estimate that. Thousands upon thousands.
Have you ever had occasion to testify regarding the identification of persons based upon fingerprint comparisons?
Yes,
Can you tell us approximately how many times there?
maybe 30.
Now, did you have an opportunity to review any prints in this particular case?
Yes.
Judge, let the record reflect, I'm showing defense counsel producing marked states exhibit number PP1 and PP2.
All right.
May I approach, Judge?
You may.
Lansky, I'm handing was producing marked states exhibit number PP1 and PP2. Do you recognize those items?
Yes.
And what exactly is State's Exhibit PP1?
PP1 are the in-court rolled prints of Wade Stephen Wilson taken regarding case number 19 CF 000568 on June 12th, 2024.
And do you also recognize State's Exhibit number PP2?
Yes.
And what is that?
That is a copy of in-court rolled prints of Wade Stephen Wilson taken regarding case 502019 CF 000466AXXXMB on I don't know, but the copy, the certification is June 3rd, 2021.
But that's a certified copy of the actual judgment sentence itself?
Yes.
And it also contains a order of probation that's attached to it?
Yes. Yes.
And that is a court-certified record, is that right?
Yes.
Can I approach, Judge?
You may.
And Ms. Lansky, this also reflects that this judgment sentence was done and ordered in open court on the 18th of September of 2019?
Yes.
Okay. And this would have been in Palm Beach County, is that correct?
Yes.
Judge, at this time, State Exhibit number 1 and 2 evidence at this time is self-authenticating certified records.
You object?
Your Honor.
Be admitted.
Now, Ms. Lansky, directing your attention to State's Exhibit number PP1, that is the court-certified copy of Mr. Wilson's prints that was taken probably a week and a half ago, is that right?
Yes.
And what are you looking for in that particular document?
I use this to compare to the set of prints on the other exhibit, and we examine the friction ridge skin information, the impressions of the fingerprints.
What exactly are impression ridge examinations?
Well, the palms of the hand and the soles of the feet have friction ridge skin, and this skin forms patterns where the ridges end, divide into two, have activity. I'm sorry.
We'll stipulate that Mr. Wilson
Go ahead.
State will accept that stipulation at this time, Judge.
Okay.
And just one quick question. Ms. Lansky, when you compare the certified prints with the prints on the certified judgment and sentence, you made what conclusion?
That they had the same source, that they came from the same person.
That would have been Mr. Wilson?
Yes.
Okay. No further questions for this witness, Judge.
Is that submitted for evidence?
Yes, Judge. We move those into evidence.
Any objection?
No, Your Honor, and I have no questions of this witness. Thank you, ma'am.
It'll be admitted, and you can step down.
Permission to retrieve the evidence, Judge?
Yes, sir.
The state calls Samantha.
Okay, if you'll just face the clerk and raise your right hand.
Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
You can take the stand.
May I inquire, Your Honor?
You may.
Good morning.
Good morning.
You could just speak up so the
Good
jurors
morning.
can hear
Good
you.
morning.
Please state your name.
My name is Samantha.
And Samantha, do you have someone standing next to you in court?
Yes, this is my husband.
How did you know Kristine Melton?
She was my best friend and my cousin.
Now, did you prepare a statement about what Kristine meant to you and your family?
Yes.
And before you read that statement, I want to direct your attention to the screen. Did you send some photos to the state that you would like the jury to be able to view?
Yes.
And these have previously been stipulated to?
Yes, Your Honor.
Is that correct? The defense? Hold on. Yes.
That's fine, Judge.
No objections?
No objection.
All right. And is there an exhibit number for these or anything?
Yes, Your Honor, it'll be PowerPoint States Exhibit 4.
Okay. No objection to that PowerPoint then being admitted into evidence and published?
That's correct.
All right.
Judge, if we could get the bailiff to tap the screen. Thank you.
Just the first one. Okay, and Samantha, who is this a photograph of?
That's Kristine Melton
Okay.
and my daughter wearing outfits that they got for Christmas to match.
And what did the shirt say?
Do good.
Samantha, would you please read the statement that you prepared to the jurors?
Yes. Kristine Melton was my best friend and my cousin until October 7th, 2019. It is my task to describe this beautiful human and to somehow capture Kristine in a way that 12 strangers and 2 alternates can understand, using only my words. And I will do so sitting no more than 20 feet from the convicted, who beat Kristine, murdered Kristine, and threw her away like garbage. I hope you will understand this is not the ideal scenario to be sharing personal stories, although you would have loved them. There are no words to describe the absolutely lovely Kristine Ann Melton, but I will try. She was precious, not just to me, to everyone who knew her. She was a daughter, a sister, an aunt, a niece, and a cousin. She was loved, and her life had value. Kristine was remarkably funny, had a quick wit, and an entirely unique personality. If you were with her, you laughed. We laughed every single day. When you were with her, you felt safe and understood, never judged. She was a relief to your soul just to sit next to her. She had a way about her. Children loved her because Kristine was good and they could feel it. She wasn't an aunt. She was the aunt. Kristine was the godmother of my son, and it was her greatest honor and one that she deserved. Our children miss her in ways I could never articulate, and it is gut-wrenching to see them so destroyed. They were robbed of her. Kristine will never experience motherhood, a role she was born to play. Kristine was strong, brave, independent, and loyal. She was the friend you wished you had. She was the friend who got more fired up about your problems than you did. She was fiercely protective and always on your side, even if you were wrong. Kristine loved traveling and exploring the world. She would buy plane tickets and figure out the rest later. She loved camping and concerts and Halloween and a themed party of any kind and celebrating life and accomplishments. Kristine adored her mother and loved being with her. They were two peas in a pod. They were the same and different in all the most beautiful ways. They lived less than 1 block apart in 2019 when this occurred. Every relationship or friendship she had was special because she was part of it. She was a cheerleader to us all. She loved us unconditionally, completely, and with her entire being until October 7th, 2019. Kristine's mother has not been at this trial. Once Kristine was murdered, she was never the same. How could she be? Her health declined quickly. She left Florida and is now cared for her son in Maryland. Kristine's mother is my godmother. She is special just like Kristine. When she left Florida, she made me promise to see this trial through, and I have kept that promise. We all have. We have sat through graphic testimony and heard all of the positively gruesome details of how our girl met our end. And I sit here today and I listen because that's what Kristine would have done. She would have sacrificed her sanity to see justice done, and so I have done the same. Losing Kristine has been like loving Kristine. It's changed the courses of our life forever. The loss of Kristine is a wound that will never heal, ever. Losing Kristine is like losing the sun. It encompasses you and swallows you whole. Death is difficult, loss is difficult, but losing someone to murder is foul and vicious and soul-crushing. With one exception, I would not wish it on my worst enemy. The prosecution has won this trial, but I assure you, the family, friends, and loved ones of Kristine Ann Melton have only lost.
Samantha, now I just want to go through a few of the pictures.
That's my godmother and Kristine. At Christmas, they always wore matching aprons. Kristine loves Halloween. This is her and some friends as the Golden Girls.
Is Kristine on the top right?
Yes, in the yellow, yes.
Right.
That is my Kristine and my son, her godchild. It hangs in his room so that he remembers what she looks like. That is a group of us. We went to concerts every year for probably 20 years.
The top photograph, is that Stephanie in the background, Stephanie
Yes,
Johnson?
ma'am. Yes.
And then the one right behind Kristine Melton, is that your sister?
Yes.
All right.
That's Kristine and Monty.
Is
That was her cat, the one who sat next to her crumpled body.
And is Monty the fat cat we saw in the crime scene photos?
Yes. It's Kristine's family, her brother, her mom, her dad. That's her on the bottom, blonde and jumping. It's Kristine on Easter, with bunny ears on, with another child who loved her and who will never see her again. That's our family. It's me and my sister, Kristine, our grandmother, and our aunt. There she is. Look at her. Look at her. You can see it. I know you can.
Thank you, Samantha.
Thank you. You can step down.
Judge State would like to call Zane Romero.
If you'll just face the clerk and raise your right hand, she'll swear you in.
Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
You can take the stand.
Interested.
Good morning.
Good morning.
Please introduce yourself to ladies and gentlemen of the jury by telling them your name.
I'm Zane Romero.
Do you know, or did you know, a young lady by the name of Diane Ruiz?
Yes, that was my mom.
And is there anything that you would like for the jury to consider here today as it relates to this matter?
I wrote a letter.
Will you please be so kind?
My name is Zane Romero. I'm a 19-year-old college student going for my bachelor degree in graphic design. I'm Diane Ruiz's youngest child. I was only 14 years old when she passed. Just starting my freshman year of high school, she was so excited to see me grow up. And so proud of what I was growing into. She supported me in all my dreams and only tried to help and uplift me when taking on new risks and challenges. My father unfortunately passed away when I was only 11 years old. My mother was all I had left. I was barely 2 months into my first year of high school when she passed away. I was in marching band, and the week prior, she was telling me how excited she was to go and watch me perform at that weekend's football game. She would have been her first time seeing me perform because that was my first year in that marching band. She never got to see me perform, and I never got the experience of seeing her in the crowd. My mother supported my dreams and only ever wanted me to succeed in life. She always reassured me that my life wasn't going to end if I got a C in math. She always made sure that all the hard work I was putting into my education wasn't going unnoticed. She would always show up with random gifts that helped me and succeeded in my life for what I needed. When I was younger, I originally wanted to be a photographer. My mother went out of her way to find me a professional beginner photographer. She knew I wanted to print my photos, and she bought me a printer with photo paper. I no longer have those dreams, but I still constantly use those items. She was raised in a tough home environment and only ever wanted to give me and my brother nothing like that. She wanted us to grow up in a loving home and for us to be happy. My mother was a single mother who only ever wanted not only for her family but everybody around her to be happy. My mother's life dream was to be able to get married and raise her family. She was so close to getting everything she wanted. I was forced to move states to better accommodate for what I needed for my education. I moved far away from Florida because I grew up everywhere with my mom just to have her be stripped away on a random weekday. I tried my best to avoid going back. She was really excited for my future because she knew I was going to achieve big things, and I refused to disappoint her, even in death, because it helps me push on every day. I would like to share some achievements I've been able to accomplish. I did 3 years of marching band. We achieved superiors in the Blue Ribbon all throughout high school. My senior year, I achieved my high school's most principal award. Sophomore year, I won my first scholarship based off of my art portfolio. I graduated high school. I got accepted into all the colleges I applied and also received a full ride scholarship from one. My senior year, I received the John Philip Sousa Award for marching band. I got my driver's license. I received my first car. During COVID, I ran a whole jewelry business for 2 years at 16. I got my first job. I'm getting my first apartment July. I'm a year ahead in my college education, and I have my first internship as a graphic designer. I only listed 13 out of many, both big and small, achievements. All 13 of these achievements my mom didn't get the chance to see me accomplish. My mother will never get the chance to see me get married, get to see me graduate college as a first-generation graduate, get to see me get my first real job. During college, I was sent to the ER for the first time. I got into my first car accident, and the only person I wanted to call was my mom, or how she went missing. I trusted my gut so much. Everything told me that she was coming home, and I haven't been able to trust her again. Or how when I was told she was missing while walking home from my bus stop, or how everybody in my town knew that she was dead before me, or how on my 15th birthday I almost killed myself because I couldn't bear the idea without turning 15 without my mom. I lived 5 years without her, and not a single day has gone by where I haven't been able to not think about her. My mother only had love in her heart, only wanted the best for me, and nothing that happened to her was ever deserved, and she just wanted to live a normal life.
Did you know where your mom was walking to that morning?
Yeah, to work.
And where did your mom work?
The Moose Lodge.
Okay. And how long had your mom been working at the Moose Lodge?
Like 3 years.
And did you know what your mom did for the Moose Lodge?
She was a bartender.
Did she also volunteer at the Moose Lodge?
Yeah.
Did you know whether or not they performed any benefits?
Not any benefits. She would just be there for fun.
Okay. And did you know that the Moose Lodge was for the concern of children and for the elderly?
Yes.
Okay. And your mom was very active in that particular community, is that right?
Yes.
Have you had an opportunity to see a series of photographs in this particular case?
Yes.
And you're familiar with those photographs?
Yes.
I'd like to direct your attention to the screen there at the
Had these
right.
been admitted?
We are moving states exhibits PP3, PowerPoint 3 in evidence at this time, Judge. They've
Any
been
objections?
discussed with defense counsel.
No, we have no objection.
All right, to be admitted.
Thank you, Judge. Merrill, what are we looking at in this photograph?
That's me and my mom at the Moose Lodge on Mother's Day. I don't like pictures taken of myself, and that was the only picture I let her take as a Mother's Day gift.
Very well.
That's my grandpa and my mom when she was a kid. That's my mom when she was younger. That's my mom and my brother while they were at Disney. That is my mom working at the Moose. That is my mom. I'm gonna assume at a bar, I don't know where. That was a picture I took of my mom working an event with her at the Moose.
You say working an event, what do you mean?
It was for something, the camera she got me, she asked me to take pictures, and I just went to go take them. That's my mom and my mom and my brother. I took that picture of my mom and her boyfriend on this trail we went on. And that's my mom at the Moose.
All right, sir, you can step in.
Judge, at this time, the state would rest.
All right. Ladies and gentlemen, I'm going to take a break. Let's send you back to the jury room for a few minutes.
All rise.
let the record reflect State's President, Defense Counsel, Defendant are all present.
Yeah, I don't, Judge, I don't know if the state thinks it's necessary, but with the experts, it's a little bit unusual because they can all be in the courtroom while the other one's testifying. I don't know if you need to tell the jurors that's all right because none of the other witnesses, they've had to go out and call the other witnesses in here.
I wouldn't ask for any kind of instruction or.
I mean,
That's fine.
it's up to you. I mean, if you're asking for an instruction on.
I don't really, I just thought I'd bring it up. I don't
Okay.
know if it crossed the state's mind or not, but that's fine.
Okay. So the rule of sequestration is still invoked, though, correct?
At this time, it doesn't matter because our experts are able to sit.
Right.
and listen, so.
Right.
I'm just saying.
Those are the only witnesses.
Those are the only witnesses that are left. Okay. And then you can be seated. Go ahead. I'm sorry. So what, scheduling wise, two things. One, I need to have that discussion with Mr. Wilson about whether he wants to testify or not testify. I'll do that in a minute. And then second of all, how long do you think your presentation will be with your experts? Will we go past the lunch hour, in other words?
Oh, yes.
Okay, very well. And then do you think we'll get through one witness prior to lunch, and then we can break for lunch and come back and do another, or?
Yes.
Okay.
That's what I anticipate.
Okay.
And then they have a doctor,
Certainly.
Dr. Hercott.
Certainly. When do you want to do a charge conference on the final instructions?
When do we want to do that?
I think after our expert testifies.
Okay. All right then. Are we ready then for the defense to begin their presentation?
Yes, sir.
All right. And state's ready? All right. Ready to bring the jury then? Go ahead.
Yours entry.
Please be seated. And Mr. Shirley, you may proceed.
Thank you. We would call Dr. Eisenstein to stand.
If you'll just face the clerk, raise your right hand, she'll swear you in.
Do solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
I affirm.
Thank you.
Please, what's your step?
Good morning.
Good morning.
Are you all set up?
Yes.
Okay. Please tell us your name.
Dr. Hyman Eisenstein.
You said Dr. Eisenstein. What is your profession?
I am a licensed clinical psychologist, PhD.
Do you have a specific area of psychology that is the primary focus of your employment?
I'm a clinical psychologist with a specialty in clinical neuropsychology and forensic neuropsychology.
Would you please tell the jury what neuropsychology is?
Neuropsychology is the study of brain behavior, what the brain is capable of doing, normal, abnormal, the functional, it's the behavioral cognitive assessment of brain functioning.
How does that differ from just regular psychology?
So regular psychology studies abnormal behavior, doesn't specifically study brain functioning, so this really just zeroes in on brain functioning.
Okay. What, can you give us a brief background of your education that was required of you to become a neuropsychologist?
So my PhD from the University of Health Sciences, Chicago Medical School. I graduated in 1982. I completed an internship at Fairfield Hills Hospital, which was a large state psychiatric hospital in Newtown, Connecticut. After that, I completed a one-year postdoctoral study at Yale in the West Haven VA, the seizure program that specialized in neuropsychology. I continued to working at Fairfield Hills Hospital. I was on the forensic unit for the next 4 years. That was an all-male forensic unit. We moved to Florida in 1986. I was the head psychologist of the head trauma program at Sunrise Rehabilitation Hospital. After that, I went into private practice. I worked on staff hospitals as a consultant. Several hospitals have closed, but Mount Sinai Hospital has remained open, and I've been on staff for almost 40 years.
Are you licensed by the state of Florida?
Yes, licensed in the state of Florida. And I also have my diplomate from the American Board of Professional Neuropsychology.
All right, educate me. What does that mean?
So diplomate status means that amongst one's colleagues, you're considered to be proficient at the highest level possible, and this is in the area of clinical neuropsychology, again, the study of brain behavior, and it's an assessment and validation with the highest level in terms of clinical achievement.
Is that a state award or is that a national award?
That's a national award.
And do you have any idea how many people have achieved this level of competence?
I think about 1,500.
Occasionally, are you retained to do examinations and provide opinions in cases such as this?
Yes.
And how many times have you done that?
I've probably evaluated about 150 individuals on capital cases, maybe a little more.
Okay. Have you also worked in the federal system?
Yes.
And in what capacity?
I've also evaluated individuals in clinical forensic neuropsychology in the forensic area as well, in the federal area as well.
Okay. Now, you were retained or you were appointed to assist the defense in this case, were you not?
Correct.
And you agreed to work under the rates promulgated by the JAC, a state agency, is that correct?
That's correct.
So how much are you being paid per hour for the work that you've performed on the case?
$300 an hour.
And that's what the state agrees to pay you, is that correct?
That's correct.
And you're willing to take that?
Correct.
Do you know about how many hours you've devoted to this particular case?
Well, I've billed so far 31 hours, but additional hours have been spent in this case.
Have you always been retained by the defense in these types of cases?
Yes.
How did you first become involved in this case?
I was first, there was a request for an order by the previous lawyer, Mr. Jaffe. This goes back over a year. And Mr. Jaffe was going to appoint me, but the order was never signed by the judge. At that point, he withdrew, and then new lawyers came on the case. So new orders have to be assigned. So that's when you and your Mr. Hollander got involved in the case.
And Ms. Perez.
And Ms. Perez, correct.
Did you have a chance to go over any materials generated by either a law enforcement agency or another investigative agency to bring you up to speed as to what the allegations were against Mr. Wilson?
Yes.
And what did you review, if you recall?
Well, there was the criminal investigation reports, basically interviewing individuals in terms of the background and connection, affiliation with this particular case.
Okay. Did you have a chance to ever meet with Mr. Wilson?
Yes, I did.
How many times have you met with Mr. Wilson?
So I met with Mr. Wilson on 3 occasions, June 18th and 19th, for a total of 7 hours.
Okay. Were you able to obtain other background information pertaining to Mr. Wilson, such as jail records or other medical records?
Correct.
And do you know how many pages you had the opportunity to review?
There were hundreds and hundreds of pages from the Department of Correction, mental health, jail records that I reviewed.
Okay. And is there anything that you specifically recall at this time having read that indicated to you that Mr. Wilson may have mental health issues?
The records going back over 10 years were indicative that Mr. Wilson presented with numerous psychiatric, psychological symptomatology. He was on a variety of different psychotropic medications. They tried many, many medications. He currently is on medication, lithium and Celexa. Both those are psychotropic medications.
What do you mean by psychotropic?
Psychotropic are medications that deal specifically with major mental illness, either psychosis or depression or a combination of both. He's been treated for these conditions for over 10 years, reflective in the records.
Do you recall any specific diagnoses, medical diagnoses?
He's been diagnosed with several different bipolar. He's been diagnosed with depression, anxiety. He's been diagnosed with schizophrenia. He's been diagnosed with antisocial personality disorder, adjustment disorder. There's a variety of different diagnoses that have been offered in the records.
Okay. Did you have a chance to talk to, in enhancing your background information, did you have the opportunity to talk to any other individuals related to Mr. Wilson?
Yes.
And who was that?
So I spoke to his mother and father, Mr. Steve and Miss Candy Wilson, and I also spoke to his sister, his oldest sister, Dr. Wendy Wilson.
Okay. As a result of your conversations with these individuals, did you obtain any background information as to Wade Wilson's progression through life?
Yes.
And what information did you obtain that you felt was useful in reaching your ultimate diagnoses?
Mr. Wilson was adopted by Steve and Candy Wilson almost after birth. Both the older sisters, Wendy and Whitney, are the biological daughters of Steve and Candy Wilson. And through a church gathering, they found out that Mr. Wilson's mother, biological mother, was 14 years old, had mental illness, had medical issues, and was unable to care for Wade Wilson. Shortly thereafter, they adopted him and became part of the family, the unit of the two older sisters and Mr. Wade Wilson, the youngest.
In Mr. Wilson's younger years, were there any, did they express any concerns about his mental health, or was he average?
So throughout his younger years, up through puberty, he was functioning fine. He was active in sports. He was part of the family.
He went to church?
He went to church on a regular basis. And for the most...
How was he as a student?
He was a good student.
All right. What happened after puberty?
So they found that there was a dramatic change that occurred in puberty. His mental health changed. His behavior changed. He became reclusive, paranoid, mood swings, very aberrant behavior. He would sometimes think that there are people aliens out to get him. Very concerned about the family, the parents, and he became very disruptive and very, very difficult to manage.
Did he start experimenting with controlled substances?
Yes.
What type of help did the family try and get for Wade Wilson when they first started noticing these behaviors?
So they tried to get mental health treatment. They sought out psychologists. Mr. Wilson was not cooperative and very difficult in terms of trying to get him the help that they sought. And unfortunately, it was only through the police, when his behavior became destructive, that intervention finally occurred.
There's a terminology in our system called the Baker Act, where people are involuntarily placed in a mental health facility. Was that process utilized for Mr. Wade Wilson?
Yes.
And how old he was when that occurred?
I think he was about 15 or 16, and he was Baker acted.
Did that term of involuntary placement, did that result in any corrective action of his behaviors?
No.
Do you recall reviewing anything else in order to assist you with your ultimate determination and diagnoses?
I did review a letter from Dr. Wilson.
May I approach the witness?
You may.
Let me show you what's been marked as our Exhibit A, just for purposes of identification at this point. Do you recognize that document?
Yes.
Is that document an accurate reproduction of the letter you received from her?
Correct.
Now, let's get to the testing of Mr. Wilson. You're armed with this information, and you go to see Mr. Wilson, and your profession utilizes testing, does it not, in order to assist in diagnosing a mental health issue?
Yes.
All right, let's go through the tests that you asked him to perform. What was the first test you did?
So the first test I gave him was it's called the TOM, Test of Memory Malingering.
What's the term malingering?
Malingering is a state where somebody tries to fake, they try to embellish, they try to give responses that are not true responses, not accurate responses, not honest responses. The term that we use is malingering, or faking, or lying. So as neuropsychologists, we want to make sure that every test that we're giving, the individual's really trying their best. They're giving their best performance, their optimal performance. So we have now utilized several different what's called malingering measures to test to see whether or not the individual is really putting forth full effort.
And can you, excuse me, can you, excuse me, can you describe the test itself?
So this is one test. Again, there are several malingering measures that were used. This is called the test, again, of memory malingering. The individual is shown 50 pictures, and then they have to, another set of 50 pictures are shown, one of the 50 pictures that they just saw, and an extraneous picture. And they have to identify the picture that they saw.
Let me interrupt you 1 second. All of the tests that you asked him to perform, are these tests that are accepted industry-wide amongst neuropsychologists?
Correct. These are all standardized tests. There's norms meaning that each test, the number are based on the averages. They're based on if they're above, below average. It's called standard deviation. Again, how much these scores deviate from the mean, the average. So yes, every single test is based on normative data.
Okay, you didn't design any of these tests yourself?
No, I did not.
Okay. I interrupted you, and I'm sorry. How did he perform on that first test?
He did perfect. The test was given 50 items. He recalled all 50 items. Again, the 50 items were shown. Again, then after that, 2 items were on the next 50 cards. He chose all 50 correct. And then half hour later, without repeating the 50 items, but with 2 items on the cards, again, his score was perfect, 50. So he got 50, 50, 50, perfect scores.
What did that tell you about how he was trying to do on the tests?
So it was my understanding that that Mr. Wilson was really trying to perform his best. He wanted to show me how well he can do on these tests, and that was certainly, I complimented him. I told him that his performance was very good. He was putting forth full effort, and that's exactly, as a neuropsychologist, one wants to assess that they're honest and they're putting their full effort. And after the battery of tests, then I can make a determination where there's strengths and weaknesses, there's high points, there's low points, and what deficiencies may exist.
Before you started the first test, did you have some concerns as to whether or not he was going to take any tests or how he was going to perform on the malingering tests?
Yes. So knowing a little about of some of his background from Ms. Perez, it was questionable whether or not Mr. Wilson was actually going to be willing to participate. Initially, we met in a room, an open area. There was a desk and chairs, and the officers stated that they have to remain in the room the entire time. 2 officers have to remain in the room the entire time. Mr. Wilson raised issues of confidentiality. One of the issues certainly with taking any type of psychological, neuropsychological test is that it's performed in confidence. I agreed with him. I said, you're right. There's no reason why the officers need to be here. So then Ms. Perez came up with the idea that let's go to the attorney interview room where there was a glass separating Mr. Wilson and myself.
Okay. Now, in order to perform some of these tests, does Mr. Wilson have to actually be able to access the documents that you're referring to?
Yes, he does.
And the new room, was that able to accommodate you in your effort to have him have actual contact with these documents?
So fortunately, there was a 2-inch slit at the bottom of the glass that I was able to pass through different items, different material that he was able to respond or to take in order to participate and fully evaluate his ability to take the various different measures.
But that small gap doesn't necessarily accommodate the materials in every test that you would want him to perform. Is that correct?
That's correct.
Okay. And were you also familiar with Dr. Mark Mills?
Yes.
Were you aware that Mr. Mills had gone in to see him before you?
Yes.
Okay. You told us about the first test. Talk to me about the next test, please.
So on June 18th, I also performed the Dellis-Kaplan Executive Function System, the trail making test, 1 through 5. What is noteworthy on this test, and I think this is part of his mental status, how Mr. Wilson, how his mind works. He's very impulsive, he's very fast, and he has accuracy at the beginning, but it very quickly waxes and wanes. So on these tests, which are time...
Is there a term that you attribute to this, like perseveration?
Right, so perseveration.
Perseveration, thank you.
Right, so that's a test that I'm going to be talking about, which I performed on the second day.
Okay, I'm sorry, you go ahead then.
But what's noteworthy is on these measures, he scored all within the normal limits. These are very short in terms of 1 minute, maybe a little more. But he's able to focus his attention for very short periods of time. And he did well on these tests, but on other tests, even given the same day on fluency, he starts out okay, but he rapidly declines.
What do you mean by fluency?
So the fluency test was 3 different measures that asked him to do either letter fluency, or category fluency, or switching.
I think the jury might want to hear exactly how the test is performed, because these terms keep coming out and they need to hear physically what you're having him do in order to complete the test.
Okay, so just going back for a second for the trail making test, the first condition was just to cross off the 3s on the sheet, and he did fine. He completed this in 15 seconds, very fast. The second condition was to follow numbers in sequence, and again, he completed this in 30 seconds. Again, his performance was fine. The third was letter sequencing. Again, just the letters in order, and again, he did this in 26 seconds, very rapidly. The third was switching between number letter, which is a complicated task, and he went back and forth through some of the same numbers, but he completed this in 49 seconds. Again, very rapidly. And the third was just going through following the dotted lines. Again, he did rapidly, 18 seconds, he completed the task. So he did quite well on these conditions of very rapid, quick abilities. The next test was letter fluency, where I asked him to tell me as many words he could generate with the letter F. And this is again in 60 seconds. And he got 12 words. With the letter A, he got 13 words, and the letter S, he got 16, and then this task was within the normal limits. The breakdown came on the next, which was category fluency. He did okay in the first 15 seconds, the second 15 seconds, but by the third 15-second segment, he only came up with 1 word, and then his mind went blank. No more responses. And similar with boys' names. He was able to do okay in the first, the second, and even the third, but it tapered off. And by the fourth 15-second segment, again, his mind went blank, and the total score here is in the borderline range.
What do you mean by borderline?
So borderline is a score that is equivalent to an IQ of 70. It's already the lower percentile in terms of one's functioning. So one sees over here that there's some major decline in terms of how his mind is able to process information.
Okay.
And then on the last test, which is category switching, again, the first 15 seconds he was okay. It diminished the second, the third, and then by the fourth 15 second, again, no response. Again, this is a borderline 75, where, again, there's a diminished capacity over time.
Do you think he was malingering on the last test, on both of these categories, and that he did so poorly?
So one may have suspected that that could have been a possibility. However, throughout his performance on the entire battery, it came to a point where he did quite well in the beginning, and then over time, he just couldn't respond, didn't respond, and was not able. So that was a pattern that was throughout the testing. So I do believe that he tried, and yet somehow his brain is able to go like, in a car, he could go like 0 to 70 in a few seconds, but then he couldn't sustain that. He couldn't keep that level up, and then rapidly went back down to 0.
Okay. Did you have him perform any other tests?
That was what I completed on the first day of testing
All right.
on June 18th. On June 19th, the next day, it's Wednesday, last Wednesday, I did another malingering measure to start out with. This was called the word choice. The individual is shown 50 words on a card. Each word is repeated. I say it out loud. And they have to respond whether it is either natural or it's man-made or it's natural. That's the instructions on the test. After the 50 words are presented, then the individual is given a card with 2 words on it. One of the words was the correct, and the other was an incorrect word, and they have to correctly identify the word that was stated.
All right, now I'm a little confused. What do you mean by one was a correct word and one was incorrect? Was it spelled incorrectly, or was...
No. So, for example, one of the words, let's say, was bird. And then he would respond, is bird natural or is that man-made? So Mr. Wilson said, bird is natural. Let's say another word, lightning. Again, it's on a card. I say lightning, and then he has to say, is it man-made or is it natural? And he would say, it is natural. Another word, just to give an example, game. And he would say, and I would say game, and then he would say that's man-made. So 50 words like that are presented. After the 50 words are presented, then he's given a card. On the card, it has 2 words, crib and bird. And he responded the correct word by saying bird, which was one of the words that I said. And you go through, there's 50 words. His score was 48 out of 50. He made 2 errors, but still that is considered to be in the normal limits, and again, indicative that he's not malingering. He's not looking to say the wrong word. He's not looking to fake and to be disingenuous or try to say the incorrect word.
Okay. Continue with, how did he do on that test?
That was fine. That was
the 48 out of 50?
Right, correct.
Okay.
The next test that I gave him was the array complex asterisk figure. He had to copy a figure. The figure is a complicated design.
I could tell the jury what it's comprised of. I mean, is it a log cabin? Is it a deer? What is it?
So this is what the picture looks like. It's a little small, but obviously without the numbers. This picture is given to the individual. They have to copy the picture.
Do they get to copy it while they're looking at it?
That's correct.
Okay.
And this is his copy. So his copy, as you can see the difference between the original and the copy. The copy is right in front of him. This is a copy that has many distortions. what's called graphic distortions. The copy is inaccurate. It reflects what's considered to be a right hemispheric parietal occipital lobe impairment. When you see this type of picture in terms of the inability to copy something to such an extent with such major distortions, it raises issues in terms of the graphic, the motor, the visual, the sensory. There are many, many skills involved, and the picture is just a distortion in many ways of the original. And this is moderately to severely impaired in terms of when it's scored on normative data. Again, there's individual scoring in terms of getting.
Yeah, and how do you score something like that? Is that subjective? Is there an objective standard?
So there's an objective scoring. For example, there's 18 different elements, and for number one, cross upper left corner outside of the rectangle. So there's very specific criteria how you score it. It's either scored 2 points, 1 point, half a point, or no points. So again, based on his performance, he got 23 out of 36 possible points.
Where does that put him on the scale?
So that was 2.4 standard deviations below the mean.
Okay, now you're going to have to explain that. Well, maybe not. Maybe you just need to explain it to me. What's the mean?
So the mean on every test means the average. That means the average would be how many people would score in this particular range, in the average range.
You said he was 2.4 deviations below that?
That's correct.
Okay, so what percentage of the people testing would that put him into?
Well, that would put him very low, the lower percentiles. We can talk about psychometric equivalence. We're trying to just compare, to simplify apples to apples. In other words, 100 is the average. Each 15 points, and I'll talk about that soon in the IQ, it goes 1 standard deviation above and below. And the same thing in any other measure. We talk a standard deviation means that there's a certain percentage of the population is below. 2 standard deviations would be like a 70, which is borderline, and below that is even lower. We're talking about the very low end of the population.
And you said that it indicated to you what could be an issue with what part of his brain?
Well, usually the right brain, which is the nonverbal brain, and that would be considered the occipital parietal lobe. Again, sensory ability, graphic distortions, and this type of performance in of itself, I'll never make any conclusions based on one single test, but it's accumulation of all the tests, all consideration, the entire profile. But certainly this is a red flag in terms of there's something really deviant about his ability here.
Okay. Now, you use the term deviant. You mean deviation as not deviant as in evil or something like that?
That's correct.
Okay.
Yes.
All right.
And then I gave him the half-hour delay recall, which was missing elements.
So was that drawing supposed to have been done based upon the original drawing that you showed him that you just showed the jury?
That's correct.
But that had the element of memory in it because he didn't have the original drawing in front of him.
That's correct.
Okay.
Right.
All right. And what were his results in that test?
So because one expects that one will not remember over a half hour, there's going to be a memory decline. So it was only 0.75 standard deviations. It was less than 1 standard deviation. So on a relative norm, this performance was better compared to the original, although it's missing elements. But at least what he did remember wasn't as distorted. So there's elements here, I mean, there's some distortions, but still he was able to get the main, mostly the main items. I mean, not all, mostly he didn't. He got only 10 out of the 36 in terms of scoring, and yet, again, there's consideration given because there's a half-hour delay.
Okay.
The next was the IQ, the Wechsler Adult Intelligence Scale, 4th edition.
Some of these tests are like a 4th or 5th edition. Obviously, as time goes on, do they make modifications to the testing procedures?
Right. So the WACE, the Wechsler, has been modified 4 times already, maybe 5 times, every 10 years or so. And I'm sure they're in the process of redoing the test. The norms are updated. There's new questions. The test becomes more sophisticated in terms of statistical analysis. So it's an upgrade each 10 years or so in terms of the performance on the test.
I think you've already told us that all the tests you asked him to perform are widely accepted in your field.
Right. So the Wechsler Adult Intelligence Scale is the gold standard. I can mention that in the jail records, the DOC records, they gave him the Beta, which was a screening device. His IQ came out always around 100, maybe a little low, 98. That was done a few times. But the Wechsler Adult Intelligence Scale is the gold standard for intellectual assessment.
Okay. Now, it tests several areas, does it not?
Correct. So the test is divided into several different subtests. His performance is both on the verbal and the performance. There's attention, concentration, processing. It's broken down into, again, different elements, and ultimately there's the full scale is obtained. As I mentioned before, Mr. Wilson did okay in the beginning of every single test, but then as it became more difficult or as it became more complex, he said he couldn't do it. And even though I tried to encourage him, sometimes I was able to encourage him to do more, sometimes I was not able, and the complexity of the test made it difficult for him to do it, even to try, and that's when he said, I can't do it. So that happened many times throughout this IQ test.
Okay. What were the final scores or results?
So the full scale IQ is 92. 92 is the 30th percentile. It's the lower end of the average range. The average range goes between a score of 90 and 109. So this score is really a composite of 4 different subtests.
Did he express or did he score lower on some sections than others?
Yes. So the highest was verbal comprehension. That was just verbal, which is his strength, and that was a score of 98. That was at the 45th percentile.
That would be the left hemisphere.
That's correct.
Okay.
More or less.
Okay.
On perceptual reasoning, which is the nonverbal, he scored 77, which is in the borderline range, at the 6th percentile, and a 21-point split between the verbal and the perceptual, which is significant. That's statistically significant, a 21-point split, a discrepancy. Working memory was 95, that's average, and processing speed was 108. That was his highest score. That was in the upper end of the average range at the 70th percentile. So a few things. First of all, the fact that he had done so well in processing, which again is quick, fast, repeating digits, forward, backwards, he did very well. And short, very short items, very quick, Mr. Wilson is very good. Gave me his full performance, his best performance. But the discrepancy between the processing speed and perceptual reasoning is 31 points. That's over 2 standard deviations between these two scores. And I refer to discrepancies in IQ as cognitive dysregulation. And
What does that mean?
what I mean by that is one expects that IQ, when it's given, both right and left hemispheric skills should be more or less equal. One expects there shouldn't be such discrepancy between different skills. One should be able to do both of them at their best ability. And when there's such discrepancies between different skill levels, one suspects that there may be something that is going on in terms of their brain functioning that could explain why is it that on some areas he's functioning quite well, and other areas he's quite poor. So that's what I refer to as cognitive dysregulation. Again, statistically, this is significant in terms of the differences, and these discrepancies are to be noted in terms of the overall analysis as to why this is occurring.
Okay. Did you ask him to perform any other tests?
Yes. So I asked them also to conduct the Wide Range Achievement Test, 5th edition. It's an achievement test. And his scores were basically normal in the average range. Word reading was 104, spelling 100, sentence comprehension was 110. That's all greater than the 12th grade level. So consistent with the fact that he completed high school, he obtained his GED. These scores are all consistent. Math computation was the lowest, 87. He has difficulty with math, and that was at a grade equivalent of 6.1. And that's consistent with, again, his transcripts and records in terms of his math abilities. Now, probably the most significant test in terms of neuropsychological functioning was the Wisconsin card sorting test.
Yeah, explain to the jury what that test is.
The Wisconsin card sorting test is a test of executive functioning.
What do you mean by executive function?
So frontal lobe ability, the front part of the brain, right here. This is the frontal lobes. If you put your fingers right over here, this covers the whole frontal lobe. The frontal lobes are the executive functioning that we all have in terms of decision-making, problem-solving, ability to stop and to consider different options, to think. Every one of us needs our frontal lobes on a daily functioning. Very simple example, like you're sitting and you're crossing the street. There's a red light. The red light tells you to stop. The green light tells you to go. So you have to use your frontal lobes to understand and recognize that red means stop, green means go, and to figure out that that is for one's safety, and one should wait until it turns green, whether you're driving or walking. Again, that's a frontal lobe activity, simply to process information, to weigh it, to look at it, and to understand, obviously, the benefits and figuring out that how that can ultimately be beneficial for the individual. That's on a very simple level. But the frontal lobes are needed for every activity that we do in our daily lives.
Okay, and how does this test measure that?
So, so this test, the individual is given a set of cards, and they have to match the cards to either the color, the form, or the number. They're not given any instructions to how to do the test, but they simply have to, the examiner, myself, will say either you're right or wrong. They have to first complete 10 cards in a row with the color scheme, followed then by 10 cards in a row with the form.
What do you mean by form?
So it could be a cross, it could be a triangle, it could be a circle. Again, one has to match the card to the same form of the 4 cards that appears. And finally, the number, how many numbers of items are in the particular card, whether it would be, again, circles, there'd be 4 circles or three triangles. Again, one has to follow that pattern. Now, individual is told that they're right if they complete the set. And of course, again, the instructions are not given other than I'll tell you if you're right or wrong. So he got the first 10 right about color. He understood that almost immediately. The next was form. And what happened is he starts to get it correct, but then he's unable to sustain the mental processes to continue with the form. And then he goes back to an incorrect response. And this goes on and on. And that's what's called a perseverative response. Perseverative means that you perseverate on the wrong answer. There's a sequence that is required. The individual has to follow the same pattern in terms of their mind, in terms of their mental abilities to sustain the same answer in order to get it correct. And that's where he has, there's a breakdown in terms of the mental functioning, and that's perseverative errors. He doesn't get 10 correct until almost half the test is completed of the form. So all the time, he keeps on getting wrong answers. And then if he gets correct, then he gets wrong. This goes back and forth.
Okay. And now you had color, you had form, and what was the last one?
It was color, form, and number.
Oh, and the number. You've already told us how he was doing on all 3 then.
Right, right. So the number, he did not get the number correct until almost the end of the test. He got that correct, so he got 3 total categories. But after number, it goes back to color. Mr. Wilson never got that concept. He couldn't figure out that you have to go back to color again. And at the end of the test, he committed 19 perseverative errors. So that was, at the end of the test, it was even worse than at any point of the test. The cumulative perseverative errors of 43 was 7.15 standard deviations below the mean.
And what did that signal you?
So this was profoundly impaired frontal lobe executive functioning skills. Just to give you an idea, the mean is approximately 7. It's a little below 7. In other words, 7 perseverative errors would be the mean. So his score of 43 was 7 times that number. This is a very aberrant score. This shows how his mental processes, how they break down. They are very impaired. His thinking processes are compromised. Again, information processing, the ability to profit from feedback, the impairment in terms of his ability to see through correct solutions to a problem. This is, again, a neurobehavioral, a cognitive, and processes that is so way beyond the norm.
If Mr. Wilson were under the influence of a controlled substance, would you expect the results to be even worse?
Yes.
All right. Did you have him perform any other tests?
So the last test was the Wechsler adult, the Wechsler memory scale, 4th edition. This is a complicated test of memory. Again, it has visual and verbal memory. The test is very challenging, very difficult.
Based upon his prior test results, would you have expected him to do better on the verbal?
Well, maybe, but it's so complicated that even on this part, because there's a memory component here. So the memory component, for example, requires the individual, you read a paragraph, it's about 4 or 5 sentences, and then he has to repeat it. That was fine. He did the first paragraph somewhat okay. But then the second paragraph, again, the second story, the cognitive processes were overloaded. Nothing went in. In order to get something in terms of cognitive processes, you have to first get it in to your mental processes, and then you're able to rehearse it, get feedback, and have an output. There was no input whatsoever here.
And try and, if you can, describe to the jury what Mr. Wilson looked like or how he was acting during this process.
Well, he was very interactive. Again, as I mentioned, it was through a glass, but he stood up on the ledge. He made sure that I heard him. He was very attentive. He really tried his very best.
But I'm more curious about this last test.
Okay, well,
it's like he shut down completely.
Right. So yeah, right. In terms of that, yes. The first paragraph he was fine. The second paragraph he was totally shut down. No response. The same thing came in terms of asking him to draw pictures. Initially, he was okay. I showed him 5 different pictures, and he was able to do more or less, 4 out of the 5, and came to a half-hour delay recall. He only got 2 out of the 5, and then as the test progressed, the last one was a very complicated task of paired associates. You give a list of 14 words. They have to, you give 1 word, you go through a list of 14 pairs, and then they go through 1 word. Please give me the word that I just said. That's it. He was done. He was shut down, and he said, I can't do anymore. So this.
Did you draw a particular conclusion from his total inability to finish that test?
So what I was able to score all falls within the borderline range, very, very low. This just to show, this is a bell-shaped curve, just to give some idea of what we're talking about. The average is here 100.
That's the median?
That's the median. 70 is the lower percentile, the lower 2 to 3 percentile of the population. So this is where he falls on this particular test. Again, it's indicative where the task becomes more complicated, more complex. That's where there's a breakdown. So the breakdown is in terms of things that is somewhat easier or more manageable in terms of his mental processes, and then where it's more complicated and more sophisticated and certainly requires more cognitive, frontal lobe, executive functioning ability, that's when there's a complete total breakdown.
In doing your research and interviewing Mr. Wilson and others, were you able to determine whether or not Mr. Wilson had sustained any head injuries during his lifetime?
Yes. Mr. Wilson has a whole series of head injuries. Mr. Steve Wilson, the father, reported that at age 10, while playing baseball, he was running to catch a ball and smashed into a metal fence. His front tooth cracked, and he had a lump on his head. And he was a very good sports player. At age 11, playing football, he caught the ball from a kickoff. He was a safety return. He played many positions, but this time he was a safety return. And he was hit so hard that he was woozy and had a concussion. Then again, that was from his father. He played tackle football for 4 years, and he was hit hard, very hard. many times. He also played basketball. At age 18, he had a motor vehicle accident. He was sitting in the back seat without a seatbelt, and the driver ran into a big tree. Mr. Wilson said, "I remember waking up and it looked like everyone in the car was dead." He suffered a loss of consciousness and his head hurt, but he did not go to the hospital. At age 21, he had another motor vehicle accident. He was sitting in the passenger seat without a seatbelt, and the driver hit a big oak tree. He blanked out for a few minutes and was taken by ambulance to Tallahassee Memorial Hospital. He signed out of the hospital AMA against medical advice. This was confirmed by both his father and his sister. His sister called the hospital and found out that they performed a CT scan of the brain and there was no bleeding. The mom reported that at age 20, Mr. Wilson overdosed on drugs and he had a grand mal seizure. An ambulance came and took him to the hospital. Again, the CT was performed, and the sister again reported there was no bleeding. The DOC records on 6/3/18 reported that he was jumped by 3 inmates and suffered a loss of consciousness for 1 to 2 minutes. The DOC jail records have what is called a head trauma protocol. They performed this protocol, suspecting that he had loss of consciousness, and that is in the jail medical records.
Now, you're, oh, I'm sorry.
I'm just trying, just one final. The DOC records in December of 2021, Wade complained of chronic migraine headaches, and they performed another CT scan. So this is more recent.
Okay. Obviously, you're a neuropsychologist and not a neurologist, but after you had him perform all the tests, you interviewed all of these individuals, you compiled the information. What was your ultimate conclusion?
So my ultimate conclusion is that Mr. Wilson has neurocognitive brain impairment. Most likely right hemispheric and also frontal lobe involvement. There's enough data to support that his brain is not functioning like a normal, healthy individual. It's supported by the fact that he has multiple head injuries, and this is a synergistic effect. Each one is adds on in more than just a cumulative, but it's in exponentially, it's worse. And throughout his life, he's had multiple head injuries. And brain scans have been performed, although these are just CT scans, nothing more than that. This is also complicated, certainly by his drug usage over his life, as well as psychiatric conditions, which are numerous. And currently he's on medication. He's been on medication for many, many years to quiet his brain, to have his brain functioning, to try to have him at least at a state of ease in terms of his brain functioning, which he recognizes, and certainly the family recognizes, is abnormal.
But the efforts of Mr. Wilson, and more particularly his family, to correct this have been minimal.
That's correct.
I don't have any further questions. Thank you, Doctor.
Yes, Sharon, thank you. Good afternoon, Dr. Eisenstein. I guess good morning for one more minute. Sir, I want to go through your background for a few minutes before we get into your opinions. You worked in a forensic unit for 4 years directly after completing your internships, is that correct?
Correct.
And during that time, you were mainly doing forensic work, so evaluations, finding if people are competent?
Well, this was a treatment unit, so it wasn't questions of competency, but it was more treatment.
Okay. Now, after that, you moved down to Sunrise, Florida,
Correct.
and that's where you were employed by a rehabilitation center.
That's correct.
During that time, you actually you were only employed by them for 1 year.
That's correct.
Then after that, you started doing contract work.
Correct.
You mentioned Mount Sinai Hospital, being with them for 40 years, but they don't employ you, correct?
That's correct.
So actually, all your work after you left that 1 year of employment was contract work.
That's correct.
So you would go to maybe a rehabilitation hospital, do an evaluation for them or some work for them, and you bill them by the hour.
Correct.
Now, at some point, you actually conducted an evaluation, and the defense attorney noticed your evaluation and asked you to testify in a capital case.
Correct.
And that was in the late 80s.
Correct.
Now, after you took that first capital case, you then started to take on more of those cases.
Correct.
And that became the bulk of your work.
Correct.
And so now it takes up 99% of your work, capital cases.
Well, no, not 99%. I would say maybe more like 80%.
Okay. What's the other 20% then?
Well, as I mentioned, I do independent medical examinations. I work for insurance companies. I have a small psychotherapy practice, so it's a variety.
In your small psychotherapy practice you have probably 4 patients or 5 patients right now?
That's correct.
Now, you have testified over 150 times in capital cases?
Correct.
And always for the defense?
Correct.
Never once have you been hired by the state of Florida?
I was hired once, but that was after the defense. That's correct. But it's mostly for the defense, correct.
And in almost every single one of these cases you testify in, you diagnose them with some sort of prefrontal cortex damage or some sort of brain damage, correct?
Correct.
And that's your main diagnosis in this case.
Correct.
Now, you began reviewing this case on June 4th of this year.
Correct.
You bill at the rate of $300 an hour.
Correct.
Now, prior to meeting with the defendant, you actually had gone through $10,000 worth of money. Is that correct?
No.
Okay. Well, didn't you have to actually request an additional $10,000 because you had already billed for $10,000?
Well, that's up until this point.
Okay. So you had billed up until this point for $10,000.
That's correct.
And you needed additional hours.
That's correct.
Now, if I did my math correctly, $10,000 divided by the $300 JAC rate means that you spent 33 hours and needed more hours, correct?
Well, it was 31 hours, and there was also travel time.
Okay. So you did 31 hours. Is that prior to testing?
No, that's including testing.
So 7 hours of testing.
Correct.
And 24 hours of review.
Well, yeah.
Okay. So you spent 24 hours reviewing in addition to the testing.
Well, yeah, it's broken down to both the testing, the scoring, the analysis, the review of records.
Okay, well, prior to testing him and doing your work after the testing, you had already billed 31 hours, correct? Or you had 31 hours that you had performed?
Correct.
Okay, so 31 hours leading up to this point where you have to now test and analyze him.
Correct.
Now, you would agree that the review of the materials is important.
Correct.
Background information is important to the work you do.
Correct.
Now, you're not a medical doctor.
Correct.
And you're not a neurologist.
Correct.
So you don't deal with really doing CT scans or analyzing those types of brain scans that a neurologist may do.
That's correct.
Now, would you agree that part of the reason that it's important to review these materials and be familiar with them is to see how they mesh with your testing, to see if there's consistencies between everyday life and the testing you perform.
Correct.
So for instance, if you performed IQ testing on someone and they score 65, but you know from their school records that they're an AP honor student getting all A's, that would raise some red flags.
Correct.
Because someone who's doing that well in school shouldn't have a 65 IQ.
That's correct.
Now I want to go through the records you reviewed for this case. You mentioned you reviewed the medical records, which contain the mental health records of the defendant.
Correct.
Now, there are 10 years worth of records that you've reviewed.
Correct.
And no records are from any private psychiatrist or psychologist that outside of the jail setting.
Correct.
And in fact, you talked to the parents and you were unable to obtain any psychological records from them.
Correct.
In fact, it was just a 4-page, very brief synopsis of mental health issues that their son had.
Correct.
Now, in those jail medical records, you talked about how he's got all these diagnoses. I think you said, I'm not going to get all of the ones you said, but I want to just go through some of them. You said he was diagnosed with depression,
Correct.
anxiety,
Correct.
schizophrenia,
Correct.
adjustment disorder,
Correct.
bipolar,
Correct.
schizoid affective.
Correct.
All right, did I get them all?
I believe so.
All right, so let's talk about depression. Would it be likely that someone who's incarcerated, especially for first-degree murders, may feel a little depressed?
Correct.
Is it common that someone who's incarcerated in that type of setting may feel anxious?
Correct.
And as far as schizophrenia, where in the records did you see that he had a diagnosis for schizophrenia?
You're correct. I'm sorry. It was schizoaffective.
Okay, so no diagnosis for schizophrenia.
Correct.
Okay. And you would agree that almost everything in the records is self-reporting by the defendant.
Well, it's the self-report and the analysis by the professional staff in the jail.
Okay, what analysis did you see by jail staff listing out symptoms and a basis for a diagnosis?
Again, I'm not sure that there was a listing of symptoms, but certainly there was a diagnosis, and there's been medication that has been throughout the 10 years, a variety of different medications. And medications are not given to every single individual in the jail system. So I think that one can look at the fact that there is medication is indicative of the fact that they acknowledge that there's certain conditions that warrant giving of the medication.
So you reviewed as part of these medical records, when a patient comes into the jail, they go through an intake process.
Correct.
And at that intake process, they're asked if they have any mental health conditions.
Correct.
And at that point, they can say, I have a diagnosis for depression.
They report it, and then the staff, whether it's the staff, if it's the psychiatrist on staff or the other qualified staff in mental health, they make that assessment.
I want to ask you about the DSM-5. Are you familiar with the DSM-5? I think there's a newer version out, maybe the DSM-5 TR.
That's correct.
You're familiar with this?
Yes.
And what is the DSM-5, doctor?
That's the diagnostic manual in terms of different psychiatric conditions and the basis to make a diagnosis.
And it's recognized and used by psychologists all over the world.
And psychiatrists, yes.
Now, in this DSM-5, there are very specific criteria that must be followed and must be present in order to make a diagnosis.
Correct.
And anywhere in the records, did you see a diagnosis in conjunction with the factors needed to make that diagnosis that are stated in the DSM-5?
No.
Now, you also mentioned that you reviewed investigative reports.
Correct.
Now, those were created by an investigator hired for the defense.
Correct.
And actually, in that investigative report, the defendant told the investigator that he was a heavy drug user.
Correct?
And he had a diagnosis of attention deficit disorder.
Correct.
And you would agree attention deficit disorder affects the prefrontal lobe.
Correct.
You also mentioned that you reviewed his school records.
Correct.
It's a one-page document.
Correct.
It's a transcript of his high school years.
Correct.
And so this transcript of his high school years would be after he's having these problems with drugs and allegedly with mental health.
Right. During that time.
Because he started at 13, according
Correct.
to his parents. All right, so let's talk about his school records. You would agree that he got mainly A's, B's, and C's, but consistently struggled with math.
Correct.
And you would agree that in 12th grade, he got a B in math.
Correct.
And he got a couple C's, but the rest A's and B's.
Correct.
Now, doctor, you wouldn't say those are awful scores, correct?
No.
And in fact, did you see what his class rank was?
Yes, it was like about, he was half.
He was 133 out of 260, right?
So he's a little below half.
Okay, so close in the middle.
That's correct.
Now, you also indicated that you reviewed a letter from his sister, Dr. Wendy Wilson.
Correct.
She's a radiologist.
She is a pediatric radiologist. Correct.
Okay? And so I assume was a radiologist and then got her subspecialty in pediatrics.
Correct.
Now, she's trained as part of being a radiologist to review x-rays, CT scans, and other types of imaging.
Correct.
And you spoke to her.
Correct.
And you spoke to his adoptive parents,
Correct.
loving people,
Correct.
loving home,
Yes.
close-knit family,
Correct.
did everything they could for him.
Absolutely.
But they're unable to actually give you any details regarding his diagnoses from specific doctors or much detail surrounding his mental health.
Correct.
And they talked about this dramatic change when he was 13 where he became withdrawn, uncooperative, moody.
Correct.
Those also things that you might see with someone who begins using drugs.
Correct.
You also mentioned that he was Baker acted.
Correct.
And in all of the records you reviewed, and in all of your conversations with his family, he was only Baker acted one time.
Correct.
And that one Baker act was related to his father finding drugs.
Correct.
And when his father found drugs, he called the police. Police came. Defendant ran from police. Subsequently gets Baker acted.
Correct.
And he actually is Baker acted not for multiple days. He's released the next day, correct?
Correct.
Now, did you review the statement made by Joshua Lukic, who called 911 regarding the defendant telling him he had just killed 2 women?
No.
Did you review the 911 call?
No.
So you weren't able to gauge whether the defendant had difficulty remembering the events of October 7th of 2019 when he talked to Joshua Lukic.
I did not review those.
And you weren't able to gauge whether he exhibited any signs of prefrontal lobe damage during that time when he was with Joshua Lukic.
Correct.
Did you review the statement of Stephanie Johnson, who was with the defendant throughout the evening and morning of the murder?
No.
And so you wouldn't know whether he was acting appropriately.
Correct.
And you don't know whether he was acting as someone who might with prefrontal cortex damage.
Correct.
Now, did you review the statement of Melissa Montanez and her interactions with the defendant on October 6th and 7th?
No.
Do you know who she is?
No.
She was the victim of the battery that survived? Okay. So you don't know whether he was acting as someone might with prefrontal cortex damage in his interactions with her?
Correct.
And you don't know whether he was exhibiting any signs of memory impairment in his interaction with Melissa Montanez?
Correct.
Now, did you review the witnesses' statements who viewed the battery that he committed on Melissa Montanez, either Shayna Williamson, Don Griffin, Amy Sablazian?
No.
So did you review the statement he made to Timothy McCormick after the defendant murdered Diane and Kristine?
No.
Did you watch the video of his interaction with the officer?
No.
Don't you think his interaction with the officer might be important to gauge whether he was having memory issues or exhibiting any type of prefrontal lobe damage at the time?
Correct.
But you didn't watch that.
No, I did not.
Now, you also mentioned in your testimony about your prefrontal lobe helping you determine whether if the light's green, then you know you need to go. If the light's red, you know you need to stop.
Correct.
Correct? So if somebody was getting stopped by a police officer who had just committed 2 murders, they might think, it's time for me to go. Would that be a logical step potentially in someone who has just been caught for murder?
Perhaps.
Would you also agree that someone who is able to back into a parking space, that they would need their prefrontal lobe to be able to make that decision and then be able to do that?
Correct.
Now, did you listen to the defendant's statement where he confessed to the murder?
No.
And you agree that a detailed statement recounting the murders from 3 days prior would be difficult for someone to do who scored in the 2 to 3% range from memory?
Perhaps.
You think it might be important to listen to a statement the defendant made 3 days after the murder to gauge the defendant's cognitive function?
Correct.
But you did not do that.
No.
Now, there were also hundreds of emails that he sent to dozens of women. Did you review any of those?
No.
Would you expect someone who scores in the 2 to 3 percentile from memory to have a difficult time dialoguing with over a dozen women about various things and remembering the day-to-day of what he's talking to them about?
Perhaps.
Let's move on to head trauma. You went through a series of events that you believe are head trauma. You said that when he was 10, he was running to catch a ball and broke his tooth on a metal fence and got a lump on his head.
Correct.
Okay. Is that also could be called a goose egg?
Maybe.
It falls down, hits their head, a little swelling, put some ice on it, kid runs off to play.
Well, it also could be a hematoma.
Okay, which is swelling
Yes.
with a little blood in.
Yes.
Okay, and they didn't take him to the hospital.
Correct.
Nothing seemed wrong. He was able to walk and able to talk and function.
Correct.
Now, at 11, he caught a football and was hit so hard he got woozy. Okay? Did they take him to the hospital for that?
No.
And again, he's able to walk and talk and eat, and there's no medical concern from getting hit with a football that will cause his parents to take him to get medical care.
Correct.
And you'd expect loving parents to take him for medical care if they had concerns.
Right. Well, I think also the concern for, especially now in terms of football injuries in 2024 is quite different than it was 20 years ago.
So let's talk about that. He wasn't in an NFL,
No.
and he wasn't some big-time football player.
Well, he played 4 years tackle football.
But that's not, I mean, he's not 4 years, right?
I'm sorry?
4 years is all that you know of.
Well, that's a long time.
Okay. But again, during those 4 years of football, there's no indication that he's having any kind of head problems or memory problems or cognitive problems that he needs treatment for.
Well, he's hit hard many times. He plays hard. So, again, it was a different era, a different time.
Okay, well, I mean, he's 30 years old. This isn't 40 years ago that we're talking about, right?
No, but we're talking 20 years ago.
Okay, so, but to my question was, doctor, was he ever taken for any kind of treatment as a result of any injuries he got in those 4 years of playing football?
No.
And you'd agree from the time a kid starts walking, they constantly are falling. Bumps on the playground, sports injuries, that's not uncommon.
Correct.
Now, you also mentioned with his head, regarding his head trauma, he got into 2 accidents. And that's according to the defendant, correct?
Well, both the defendant and subsequent also the father and mother reported.
So let's talk about that first accident.
Mm-hmm.
Doesn't go to the hospital. Not taken to the hospital, correct?
Correct.
Second time he goes, he gets a CT scan.
Correct.
So they check out his head to make sure there's no injury, no bleeding.
Correct.
And actually, his sister, who's a radiologist and trained to read CT scans, reviewed that CT scan and confirmed there was no damage.
Well, I think I'm not sure she reviewed it, but she called and they said there was no bleeding.
Okay, so again, normal, no follow-up care.
Correct.
And when he was jumped in jail, there was actually a CT scan performed, and that was normal as well.
Correct.
And in fact, the only thing they gave him was Flonase.
Correct.
You're familiar with Flonase?
I'm not sure.
It's a spray to treat stuffy noses, allergies. Is that
Okay.
correct? You don't know.
Well, they did a head protocol on him,
All right, and
head trauma protocol.
and again, CT scan was normal,
That's correct.
and the only thing he gave him was Flonase.
Okay.
But you don't know. You're not sure what Flonase is. Is that what you're saying?
Well, I'm not sure exactly what they did at the time, but that's correct.
Okay. Now, at age 20, he actually overdosed and had a normal CT scan. Is that correct?
Correct.
So, as far as you're concerned, all the CT scans he's had are normal with no hemorrhaging, meaning no bleeding.
Correct.
So tell me, doctor, in your review of the records of the CT scans and of talking to his family, what history did you find of actual brain damage in the records?
So the fact that a CT scan was performed so many times on him with multiple head injuries, we know that the CT scan is a measure which basically tells you whether or not there's any bones which are fractured and whether or not there's bleeding. But it doesn't go beyond that. And beyond that, there was no test performed. But again, to the extent that there were so many head injuries and there are so many CT scans that were performed over time, as I mentioned, there's certainly a history of synergistic effect of head injuries that Mr. Wilson suffered.
Okay, let's talk about that. I want to break that down a little bit because it's a lot of big talk, but I want to break that down. So you would agree that if somebody goes into the emergency room, or emergency department as it's now called, if they were to go in and say that they bumped their head, you would expect a CT scan would be performed, would you not?
Perhaps.
There are certain protocols that medical doctors would follow when there's a reported injury.
Correct.
And you would agree that when someone gets in a car accident, there would be specific or certain protocol that professionals would follow to determine whether there was any type of injury.
That's correct.
So the fact that he's had multiple CT scans does not mean that he's had multiple brain injuries.
Well, the only reason they would do the CT scan is to follow the protocol of head injuries.
Right.
So he's had multiple head injuries.
Well, let me ask it this way. If somebody goes in and gets an x-ray for a foot that's injured and it's not broken, you wouldn't say that if they had 6 x-rays for their foot that it must mean they have a broken foot, right?
No, but what it would mean is the fact that there's indication that there may be some abnormality, something wrong, and there certainly could be some indication of residual problems.
But you haven't seen any evidence of issues with any of his CT scans.
That's correct.
So you're making an assumption that because he's had numerous CT scans, he must therefore have some type of brain injury because of these various falls or injuries.
Well, I'm just saying that the CT scans were performed because of suspected brain injury. The fact is that there's a history of multiple brain injuries due to a variety of different circumstances, and that is something that one certainly would make a consideration in terms of what their brain functioning may be.
Okay, so you're using the term brain injuries, but the CT scans don't support any brain injuries from what you've seen.
Again, there's no fracture and there's no bleeding, but that doesn't mean there's no brain injury.
Okay, but my question is, again, none of these records actually show a brain injury. There could be, but they don't show it.
Well, the test is as sophisticated as what it can do.
Okay, but according to the test that you are able to review, There's no,
Objection argumentative.
he's not answered the question.
Oh, you can ask your question.
The question again, doctor, is these CT scans, there's no evidence that you've seen of the brain, of any brain injury.
They were normal, that's correct.
So, some falls in sports, 2 car accidents led you to the conclusion he suffers from synergistic head trauma.
That's correct.
And you believe that this head trauma plays a significant part in his brain impairment.
That's correct.
And again, you found no records of any evidence of brain impairment.
Objection repetitive.
Sustained.
All right, now I want to go through his demeanor when you're testing him. Do you see any signs of paranoia?
No.
Any signs of delusions?
No.
Any signs of hallucinations?
No.
Was it psychotic?
I'm sorry?
He wasn't psychotic.
That's correct.
No psychotic symptoms that affected your testing.
That's correct.
In fact, you had a discussion about his mental health.
Correct.
And he told you that he had struggled with mental health his whole life.
Correct.
Did he tell you he had struggled with behavioral issues?
Correct.
Did he tell you he'd been kicked out of school for selling drugs?
Correct.
He told you he was diagnosed with bipolar.
Correct.
He told you he had depression and mania,
Correct.
but he was unable to give you any specific examples of mania.
Correct.
And again, with the DSM, there are very specific requirements to be diagnosed as being in a manic state.
Correct.
And he didn't give you any specific examples of a depressive disorder.
Correct.
And in fact, you didn't ask him any details.
That's correct.
You just took, again, what he was telling you.
And the records, correct.
And your job is to test his brain and his cognitive functioning.
Correct.
He also told you his mind wasn't working well.
Correct.
You didn't ask him to clarify what that meant.
Well, I mean, he said that he has difficulty thinking, difficult with clear thinking, thought processes.
And that could potentially be from the medication he's on.
Well, it's possible, correct.
You took pretty much everything he told you at face value because your job was to be there for testing.
Right, and it's corroborated by the records.
And let's talk about the testing you conducted. You would agree that there were some tests where he got tired and gave up.
Correct.
So while you may not say he's malingering, that affected his scores on those tests because he got tired and gave up. He wasn't able to complete the test.
Well, I wouldn't use the word tired, but I would use that he was unable to complete those tests.
So him being unable to finish the test, or shutting down, or deciding to finish the test, that counts against him.
Correct.
You tested for memory issues, and you indicated he's in the second percentile.
Correct.
So out of 100 people, he's the second worst.
Correct.
How would you expect someone to function in their lives with this kind of memory impairment?
It's difficult.
You would expect that people might observe these things and it might be noticed by others.
Maybe.
Where in the jail records did you find issues of him not remembering things?
Not noted.
In fact, there's places in the jail records that indicate his memory's intact.
Correct.
His parents never reported memory issues.
Again, my testing was very specific. There's various different components of memory. Some of them are actually average, above average, and others that are quite impaired. So again, there's a breakdown of different tasks, different activities.
Sure, but his parents never reported memory issues.
Correct.
You also tested for working memory,
Correct.
and that involves, again, the prefrontal lobe
Correct.
cortex. And you found that on this frontal lobe executive functioning, no tests were normal.
Well, again, on complex On complex behavior, that's where there was the greatest breakdown.
Okay, but you, if I recall, you stated in your deposition that every single one of these frontal lobe executive functioning tests were abnormal.
Correct.
Nothing further.
Just a couple of questions.
All right.
Did you ask Mr. Wilson's parents for any records or anything that they may have?
Yes, I did.
And did they tell you that, as a matter of fact, their home had burnt to the ground by fire and took everything with it?
Objection outside the scope.
Overruled.
Did they tell you that?
Yes, they did.
So they don't have any records, not through any fault of their own, but they may have had some records at some point in time.
That's correct.
Now, his sister is a doctor. She's a pediatric radiologist.
Correct.
Do you know if she ever tried to help Wade by ordering any PET scans or MRIs or any more complex testing to determine whether or not he had any brain injury?
She did not.
In interviewing his sister and his parents, did you make a determination that at some point in time they had a very close and loving family?
Yes.
But that started to break down at some point, somewhere around 16?
Correct.
Now, the prosecutor asked you questions about whether or not his conduct was appropriate, Mr. Wilson's conduct was appropriate in making a judgment to back into a parking spot or to leave when a law enforcement officer showed up. Would you agree with me that his conduct certainly wasn't appropriate when he killed 2 women and beat another one?
Correct.
At some point in time, I think in your testimony you mentioned that you were informed that the biological mother had mental health issues.
Correct.
Did anybody get into the nature and extent of those issues?
The Candy Wilson mentioned that she was doing drugs while pregnant. And
With
that,
Wade?
yes. Yes.
But you didn't have a chance to talk to the biological mother, did you?
No, I did not.
So you don't know how severe her mental health issues were?
That's correct.
Is it possible that her mental health issues could have been passed on to her child?
Absolutely.
Now, the prosecutor also asked you if you had had a chance to see, read or hear any of Mr. Wilson's statement to law enforcement, and you told her you had not.
That's correct.
So you don't know whether or not he was telling the truth or lying, and it had played no part in your determination that he may have brain trauma.
That's correct.
It wouldn't be relevant in your consideration, would it?
No, my evaluation was independent.
Okay. So you wouldn't need input from all these other sources to make that evaluation?
That's correct.
I don't have any further questions, thank you.
No, Your Honor.
All right, you can step down, sir. So, ladies and gentlemen, it is after 12:30. It's a good time to break for lunch. I'll wait for him to step down and then we'll... All right, so we're going to break for lunch. It's about 12:35, according to that clock. So what I would do is have you come back here at 1:45, give you a little extra time to get in and get something to eat and get back. Just remember my earlier instructions. Don't discuss anything, even among yourselves or with anyone else about this case. Don't do any research, look up anything, watch any local news, read any local newspapers. With that instruction in mind, you are excused, follow the bailiff, and you're excused for lunch to 1:45.
All right.
Please be seated. So how many more witnesses do you have? 17. 17? Oh. Okay.
I just couldn't wait to see the look on your face.
That's okay. I can adapt. One, okay. And then I have to have a discussion with Mr. Wilson as well on whether or not he wishes to testify or not. Just think about that over the lunch period, and we'll have that discussion when we come back. Make sure you talk to your attorneys about that. But again, they can't tell you you can or can't. They can give you advice, but ultimately it's your decision. All right? With that will be...
One thing, Mayor, we did decide that we're not going to object to the photos being introduced, so I don't know if that'll change his decision about testifying or not, but just wanted to put that out there.
So which photos you're talking about, or exhibits?
I believe they're of his childhood. Is that correct, Mr. Shirley?
Okay. Just make sure they're marked and identified as with numbers.
That's your copy anyways.
And I can let y'all do that over the lunch period. Just get them marked by the clerk, and those can be admitted by stipulation. Anything else?
May I approach the clerk?
Yes, absolutely. That they don't delineate between the two separate counts of first-degree murder. I don't know if that's by design, or I know the verdict form does, but I didn't know in the instructions if it was required to address the individual counts.
Could we get back to you after lunch about that?
Okay. I don't know if you had any thoughts.
I was wondering that too, and the quandary of what if there's different recommendations for each count.
Okay. And I know there is an instruction under a guilt phase regarding single defendant, multiple counts.
Sure.
That has some language in there, but it's not in the standard that I saw, and it's not in these, but it's something to consider because you have two separate counts of first-degree murder that we're dealing with separate victims.
And they can make separate recommendations based on the aggregate.
Right. All right. With that, we'll see you back here at 1:45.
Yes, sir.
Let the record reflect the state's president, defense counsel, the defendant are all present. We ready to proceed?
Yes, Your Honor.
Defense ready to proceed?
Sure.
Okay. Over the lunch break, now you said you have one more witness. Is that correct? Ms. Shirley, sorry. You have one more witness?
I do.
Okay. And have you had an opportunity to discuss with Mr. Wilson whether he wants to testify or not in this case?
I have.
All right. And Mr. Wilson, you had an opportunity to talk to your attorneys about whether you want to testify or not testify. Is that correct?
Yeah.
Okay. And have you made a decision as whether you want to testify or not?
Yeah.
And what is that decision?
I don't know.
Okay, very well. Is anybody forcing you not to testify? Okay. You're making that decision of your own free will? Okay, very well.
The only other thing I'd want to mention to the court is we had some photographs that we had intended to have Mr. Wilson identify. The state was kind enough to stipulate those into evidence. However, in discussing that with Mr. Wilson, because they depict other family members that he doesn't want brought into this, I have left them with the clerk as our Exhibit B, and we're not going to be seeking introduction.
Okay.
I want the clerk to go ahead and maintain those anyways. I don't want them back because it still might be part of proceeding in the future.
Okay. All right.
It's just going to be an exhibit that's not admitted.
So it's Defense Exhibit
B.
B. Okay. They'll be marked as such and submitted to the clerk
Yes,
as marked exhibits, but not admitted at this
Yes,
point.
sir.
And that's of your own decision because Mr. Wilson doesn't want them admitted with the other family members depicted in them?
Yes, sir.
Okay, very well.
I would just ask that Mr. Wilson
Yeah.
on the record agrees.
That's fine. Mr. Wilson, you're in agreement with that?
Yes.
Okay, very well.
The one other thing, I don't think we actually addressed, we've been addressing confessions and various things throughout the course of this trial. During the defense's opening, they did concede to two of the state's aggravators. I just want to make sure that Mr. Wilson was in agreement with that.
That's fine.
strategy as well.
That's fine. Mr. Wilson, you heard the opening statement by defense counsel. You were in agreement with that, sir?
Yeah.
Okay.
Well, just so we can be specific, you understand the aggravators they're talking about, that you were on probation at the time the event occurred,
Yes.
and the fact that there were two simultaneous deaths,
Yes.
or contemporaneous.
Okay,
That's fine.
very well. Anything else?
No.
All right. And I saw you did get a revised version of the final instructions emailed out. Just have you had a chance to look at those yet?
I did.
Okay. Any objection to those
No,
at this
sir.
point? Okay, we'll go through a formal charge conference after we're done, but then, all right. Let's bring in the jury then.
Just out of curiosity.
Yes, sir.
Is it the court's intention to try and resolve this case in its entirety today?
I'm going by what you all have left to present, and so it kind of depends on where we are. I don't know how much longer you all have in terms of your presentations or closing arguments. So I guess we'll see.
It's just, my only concern is that one of your brethren kept us in the courtroom until 11:30 one night because he didn't want to sequester the jury, which I certainly understand. I'm just not sure at what point in time we would have to sequester the jury.
Okay.
Obviously,
I do thank you for bringing that up.
if we had done closings and instructions, you're going to have to sequester them, or you're going to have to let them go however long they're going to go.
Now, at the beginning of the trial, I did inquire whether you wanted to have the jurors sequestered or if you wanted to waive sequestration. We can have that conversation again, but by implication, are you indicating you would want them sequestered or would you waive sequestration?
Well, let's wait till the time comes so I have an opportunity to talk to Mr. Wilson.
Very well.
It's his trial, so.
I understand. State, any input on that?
Not at this point.
Okay. Well, we'll cross that bridge when we come to it if
Yes,
we come to that, okay? All right. Ready to bring the jurors in then?
Yes.
All right. Please be seated. Ladies and gentlemen of the jury, welcome back. I hope you all were able to get some lunch. By a show of hands, was there anyone on the jury who was not able to follow the court's previous instructions about doing any research, looking up anything, or discussing anything about your service as a juror on this case? Seeing no hands, we're ready to proceed.
We'd call on Dr. Mark Mills.
Okay. All right. Dr. Mills, if you'll face the clerk, raise your right hand.
Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
You may take the stand.
Just watch your step.
Good afternoon.
Good afternoon, Mr. Shirley.
Would you please tell the jury your name?
Yes, it's Mark Mills, M-I-L-L-S.
And what is your profession, sir?
I'm a psychiatrist and forensic psychiatrist.
Okay. What is a psychiatrist?
It's the kind of physician that studies disorders of the mind, disorders of behavior, disorders of affect or emotional state, and disorders of thinking.
What's a forensic psychiatrist?
The person who uses that knowledge in courtroom proceedings such as this, criminal trials where issues of intent or illness may be relevant, and in civil trials where issues of injury or mental state may be relevant.
Do you have a doctorate?
I have a MD, yes, sir.
Okay. And so obviously you have schooling. Would you give us a brief synopsis of your schooling?
Sure, briefly. Attended and graduated University of California, Berkeley, 1967. Then attended and graduated Harvard Law School, 1970. Returned to Berkeley for pre-medical education and attended Stanford University School of Medicine, 1971 to 1975.
And what year did you receive your MD?
1975.
And was that in California?
Yes.
And is that degree good here in the state of Florida?
Well, the medical degree, I mean, my graduate degree is good. You have to get licensed someplace. I've been licensed in California, Massachusetts, Washington, D.C., Maryland, and in Nevada, and I maintain my Nevada license.
Florida also?
No, not in Florida.
Okay. What do you have to do to practice here in Florida?
Well, I mean, pretty much you have to do the same thing you practice anywhere in psychiatry. You have to have a medical degree, have to have completed an accredited residency, have to take in the relevant examinations, and in my case, I'm board certified both in psychiatry and in forensic psychiatry, so I took those examinations as well.
Okay. Have you been tendered as an expert in the court of law anywhere in the United States?
Literally hundreds of times in many states and in many federal jurisdictions.
Does that include Florida?
It does.
And what kind of matters do you testify to?
Well, issues of competence to stand trial, criminal responsibility, sanity or insanity, fitness to be executed, a variety of issues like that, generally, of course, involving serious mental states.
In this particular case, you were appointed by the court in order to assist Mr. Wilson's defense team, is that correct?
Yes.
And were you assigned the task of determining whether or not Mr. Wilson had any mental health disorders?
That's correct. That was the task that you and your colleague, Mr. Hollander, asked me to consider.
Okay. What did you do in order to be able to render an opinion if you have one?
I have one, and the answer is I attempted to interview him on 3 occasions. One of those was moderately successful, and 2 of those were largely unsuccessful. I reviewed the records. You heard Dr. Eisenstein describe the records that he reviewed, and I reviewed essentially the same group of records. I also interviewed perhaps a few more witness statements. I interviewed the jail medical records, which are 500-600 pages at least, although in general they're not particularly productive. I spoke to the adoptive parents, mother and father, and to the elder adopted sister, the radiologist of whom we've heard some testimony.
Okay. In addition to speaking with the radiologist, did she provide, or did we provide you with a letter that was authored by her?
Yes, you did.
Okay. And did you take that into consideration in determining your diagnosis?
I did, because it was both, I thought, perceptive and useful in describing her adopted brother's background.
May I approach the witness, please?
You may.
Dr. Mills, let me show you what's been marked as Mr. Wilson's Exhibit A.
Yes, sir.
I think it's already been identified by your predecessor on the bench, or on the stand, but can you tell me, is that the letter that I've referenced?
It is.
Okay. And you read that in its entirety?
I did. Although it's not trivial, it's not particularly long.
All right. And that was a significant part of your consideration for his diagnosis?
Yes, sir.
May I approach?
You may.
We'd like this admitted as our Exhibit A, Judge.
Any objections?
Yeah, no objection.
Admitted.
Judge, I wanted to publish that for the jury, but it's not going to work on that device. I have 14 copies that I can let them all read at the same time, so we don't waste any time, and then we'll just gather the copies back.
Okay. Any objection? Okay.
And I'll apologize to the jury in advance for the small font. Let's give him just a minute, Doctor. they're all done, Judge.
All right. Have all the jurors had an opportunity to view the exhibit? All right, you can hand it back to the bailiff. And for the record, all the jurors nodded in assent that they had been able to look at the exhibit.
Yes, sir. Thank you. All right, Dr. Mills. One thing you just said, you looked at hundreds of pages of medical records, jail records, but they weren't particularly useful. What do you mean by that?
Well, as you know, all kinds of individuals write in jail records reflecting all kinds of level of training and sophistication and skill. Additionally, jails are primarily designed to contain and control, so it isn't that they are oblivious or uncaring about mental issues, but they as a group, those who write in jail records, are not particularly skilled or interested in those issues unless they're causing significant behavioral disruption. So very often one can wade through hundreds of pages of jail records and not learn very much.
Okay. Were there things in the notations in the jail record that you found were of value to you?
Sure. I mean, first of all, as Dr. Eisenstein indicated, there are a number of diagnoses that are in the jail records, and that reflects at least the suggestion, if not more, of some kind of significant psychiatric or mental health or mental illness situation. Secondly, again, as he indicated in his testimony, there are ongoing indications of a variety of pharmacologic treatments. There's indication of antidepressant medication, of lithium carbonate currently. Previously, there has been treatment with antipsychotic medication. There have been a number of antidepressant medications. And again, as we've heard testimony, there's no doubt that such medications suggest that a number of people on the jail treatment team have believed that Mr. Wilson was psychiatrically impaired or psychiatrically ill, and that his condition warranted ongoing medications. Jails as a group, and I visited scores literally of jails, tend not to treat with medications unless they need to, because one, medications are expensive, two, medications require monitoring, and three, medications have potentially significant side effects. So good clinicians avoid medications unless there's a fairly clear-cut indication for the need for treatment.
Were you aware of whether or not Mr. Wilson is, at the time at least that you interviewed Mr. Wilson, he was on medication?
Yes, he was on medication at the time that I saw him.
What medicines?
As I recall, I know he was on the lithium, which he had just recently started, and I believe he was on one of the antidepressants, Paxil, 40 milligrams per day at bedtime.
What's the lithium for?
Lithium is a so-called mood stabilizer. It's been around since the late 40s, early 50s, found out by a psychiatrist named Jonathan Cade in Australia, and has been used to dampen down the mood swings that often accompany bipolar disorder.
Now, the time you did get to talk to Mr. Wilson, how long were you with him?
On the first occasion, I was with him a little more than 2 hours. Then I returned, and Ms. Perez was with me on that occasion. Then I returned with her that afternoon to continue my evaluation, and he basically said he actually didn't come forward. He told the jail staff that he was not going to continue his evaluation. I remonstrated gently and said, is there a way that perhaps I could go back and perhaps you could ask him again to come out? They kindly did that. He again refused, so he didn't come out. And that was, let me check my notes here, but that was in the end of last month, the end of May. Then I came back, that was May 29th. I returned a week or so later in order to evaluate him, and that was on June 14th, and thought that he might be more forthcoming. And in fact, I spoke to you and suggested that perhaps you might encourage him to be more forthcoming. And I know you talked to him, your client, And indeed, I was hoping that he would come out and we could start talking. He did come out. He made primarily eye contact with Ms. Perez, although he looked over at me occasionally and spoke with me occasionally, but indicated he did not want to go forward. We had additional colloquy. I then left because he seemed more comfortable speaking with Ms. Perez. She then asked me to come back. We all agreed we would go forward, but he was very concerned that there were jail staff outside. We were in the lawyer room you previously heard described, with a glass partition between him and Ms. Perez and myself in a slot where you could pass documents. And he indicated that he was very concerned that jail staff was outside his portion of the room and they were overhearing his comments. So he asked me if I would go talk to them. I did. I explained that he was very concerned. In fact, I perceived him as frightened. And could they back away, please? They agreed to do that. He said then finally he was still too uncomfortable to proceed, and so we did not.
Okay. Did you have an opportunity to have him perform any testing like Dr. Eisenstein had described?
Yeah, I mean, as a psychiatrist, I don't do a lot of testing, but I was tutored in the administration of various so-called personality tests. I say so-called because although they're called personality tests, the Minnesota Multiphasic Personality Inventory and the Personality Assessment Inventory, they're really tests of major mental illness, tests of psychopathology. And I asked Ms. Perez to administer one, to watch him, basically just giving him the piece of paper, say, read the instructions and answer the questions. And she had done that, and I got that score, that test back and scored it. And then I asked him, which he did, to do the personality assessment inventory. So we had two psychological tests which were administered in the presence of either Ms. Perez or myself, and which were subsequently scored.
And what did his scores indicate to you?
His scores indicated that he was non-compliant, that he answered the questions, that's kind of partial compliance, but that he invalidated each test by exaggerating symptoms that most people do not have, or most people do not have to that same degree. So, in effect, he said, wow, I've got every symptom in the book, and of course, every symptom in the book is many too many symptoms. Even people who are seriously ill only have some symptoms.
Okay. Well, it doesn't sound like you gleaned a lot of information from him, yet, but you did talk to his parents, did you not?
No, I did, but let's go back. I mean, I certainly gleaned information that he could, when he chose to, listen to a question and pay attention, that when he chose to, he could make eye contact and articulate a reason for responding or not. 3, that throughout his time with me, he appeared very wary, very watchful, concerned about who was listening or might not be listening. So I had a sense of excessive vigilance or hypervigilance, maybe even of paranoia. And so I gleaned those psychiatric impressions pretty solidly even after the first couple hours of the first session. And those impressions were bolstered or added onto even by his non-compliance in the second and third session.
Did he ever express any delusional aspects?
Not with me. I mean, he indicated that the guards were listening. You know, the guards might have been listening. I couldn't rule that out. I mean, he didn't tell me that little green men were listening. So they weren't obviously delusional. On the other hand, when I went out to speak with the guards on the third session, they were well away from the door. They were talking to one another, and they didn't appear particularly interested in what Mr. Wilson was saying to me. So could it have been delusional? Possibly. Was it clear-cut delusion? No.
You mentioned little green men. Were you aware that Mr. Wilson, at points in time in his history, had experienced hallucinations?
Well, I know that's been reported. He has never told me that. So he did tell Dr. Eisenstein that, and so I'm inclined to believe that he has experienced hallucination. it's complicated in his case because obviously hallucinations, particularly auditory sound hallucinations, voices, are a common concomitant of psychotic illness, of major mental illness. On the other hand, visual hallucinations are a frequent concomitant of many street drugs, particularly the hallucinogens like LSD, sometimes amphetamines, and sometimes drugs like MDMA. So all of these drugs can cause hallucinations, and occasionally recreational drugs cause auditory hallucinations. So the presence or absence of a hallucination per se doesn't tell us very much. What matters is there a recurrent pattern? What do the voices indicate? I mean, are they persecutory? You're a bad person? Are they critical? Are they self-injurious? Hurt yourself, kill yourself? One has to make further inquiry. Sadly, at least insofar as my interactions with Mr. Wilson were concerned, he never did that with me.
Okay. You heard Dr. Eisenstein's testimony about numerous head injuries over his youth and into his adulthood. Were you able to glean the same information from your interviews?
No, I mean, I was able, well, yes, if you mean the interview with his parents or adoptive parents, no, I was not able to glean it from him.
Okay, so you got that same information from his parents?
Yes.
All right. And did you make note when you were going through the medical records that there were CT scans that were performed?
I did. In fact, we heard both on direct and cross-examination of Dr. Eisenberg some colloquy about that.
Now, are you familiar with CT scans?
Sure.
Have you seen CT scans before in your practice?
I've seen them. I've reviewed them. I've reviewed the reports for them. CT is computerized tomography. It's a series of X-rays taken from multiple perspectives. It's combined into an overall scan, and then those scans are read by a radiologist, a neuroradiologist, or a neurologist typically.
Now, are they valuable in determining whether or not there's brain trauma?
Well, they're valuable in determining whether there's acute and substantial brain trauma. So if Mr. Wilson had a fractured skull, if he had acute bleeding, the CT is the best way to detect those kinds of gross injuries very rapidly. On the other hand, for more subtle injuries that don't involve significant bleeding and may involve issues to the brain parenchyma, to the brain tissue, they are relatively insensitive methods of learning about that kind of injury.
What type of testing would you expect if somebody was going to conduct those examinations?
Well, the best high-resolution scan for anatomical lesions these days is the MRI, and so for significant but minor cumulative injuries, the high Tesla MRI is by far the best method for learning about the nature of those injuries. High Tesla, high-resolution scans can reveal so-called axonal, shearing, breaking of the long part of the brain cell, and can also reflect any other kinds of minor issues of blood flow or even brain parenchymal death. So MRI is clearly the best scan for that. For issues of brain function, brains obviously, like the rest of the body, metabolize. They take in sugar and oxygen and convert that to energy and obviously carbon dioxide. And so there are scans that look at metabolic activity in the brain. Those scans are particularly called PET. Those aren't very high-resolution scans, but they're very good at looking at what part of the brain is active and what part of the brain is not so active.
Did you have an opportunity to determine whether or not there had been any PET scans or MRIs done of Mr. Wilson?
Well, I asked that question of his parents, and of course, most of the time when I spoke to his parents, the elder sister, the radiologist, Wendy, was also there, and they all indicated that they were unaware of any of those scans ever having been used for Mr. Wilson. So I don't know for sure they're correct, but assuming that they are, no such scans have been given to him.
Okay. Well, why don't you tell us what information you were able to obtain by your interviews, by your your interview of Mr. Wilson, his parents, his sister, the information you gleaned from the records, and your discussions with Dr. Eisenstein.
Sure. Well, in overall, I mean, I think the evidence is that Mr. Wilson was adopted at a very early age and appeared to function as a normal member of the family from the age of his adoption at an age of a few months until sometime in around, it's from my notes here, in around 2007. His mother and his father both report that he became, over that summer between school terms, he became increasingly isolated, reclusive, hostile, paranoid, different, significantly different. On her own, Mrs. Wilson said, look, I've had 2 other kids, 2 daughters. I understand boys and girls are different, but I've had 2 other kids, and sure, they change around adolescent, but they didn't go, if you will, from Dr. Jekyll to Mr. Hyde. They didn't go from day to night. They didn't go from active member of the family to a reluctant, scared, hostile participant, occasionally only in the family. So she describes a very significant change.
Were you aware that his biological mother may have had mental health issues?
I learned that. I hadn't known that. I learned that from, I guess her name is Candy, from Mrs. Wilson, the mom.
Okay. And is that something that can be passed on to a child?
Well, it's significant information. The most serious psychiatric illnesses, of course, are the psychoses, are schizophrenia and bipolar disorder, paranoid disorder, schizoaffective disorder, that group. And for the psychotic illnesses, the heritability is very high, so that, I mean, if a mom or a dad has it, the likelihood of a child having a psychotic illness goes from about 1%, which is the general rate in the population, potentially as high as up to 50%. Depends on the nature of the illness and the study, but there's a huge increase in the likelihood of manifesting such illnesses if one, let alone 2 parents, have significant psychiatric disorders.
There's no way for you to be able to tell or test whether or not Mr. Wilson actually obtained this mental illness from his mother, though, is there?
No.
Okay. So did you make any diagnosis or determinations based upon the information that you had?
Yeah, my diagnosis and belief is that Mr. Wilson has some kind of psychotic disorder. Sadly, because he was not particularly forthcoming with me, I can't characterize it very well. Generally, when I testify, I have more information both from the evaluee, both from the defendant in a case like this, and I have more information from prior hospital records, from Baker Act hospitalizations, from other psychiatric hospitalizations, and I can characterize that disorder pretty well. Here we've heard about mood swings that could suggest bipolar disorder. We heard about a diagnosis of schizoaffective disorder in the JO records. There's a good study going back to really my time in medical school called The Stages of Mania, which says, 1972 was the date of the study, you can't distinguish acutely between schizophrenia, bipolar disorder, and schizoaffective disorder. So I don't know exactly what Mr. Wilson has, but I think it is very significant, and I think it is a psychotic level illness, and his degree of paranoia we haven't come to all the examples yet, but some of the examples the parents told me about are quite striking. I'll give you one, that at some point Mr. Wilson's mother, Candy's father, perished, and that the family moved into his home. And in the morning, everybody would get up, and I guess people would go to school, and she would, of course, Mrs. Wilson would go up, would make breakfast for the family, and would open the curtains, and the house would sort of be functioning. Well, Mr. Wilson, as a kid, and he was 15 or 16 at this point.
That's Wade Wilson.
That's Wade Wilson, yeah. As a kid, age 15 or 16, would go around and systematically close the curtains. And at some point, probably the first or second time, Mrs. Wilson recalled saying, well, why are you doing this? What's wrong? What's going on? And he said, there are people out there. And she said, okay. And he said, they're going to harm me. And she said, are you sure? He said, they're going to harm you too, Mom. They're going to harm the family. And he was very upset. And this happened more than once. That is, he had an apparent belief that others were intending to harm him and the family for reasons that were never specified. Now that sounds, frankly, not only paranoid, but delusional. It isn't just that he was frightened or scared, but he had turned that fear into an entity or a group of entities who were planning to harm him and the family.
Okay. How would that psychotic behavior manifest itself into a 25-year-old Wade Wilson?
Well, I mean, in psychotic disorders generally, you have disruptions in thinking, you have disruptions in affect or in emotion, you have disruptions in functioning. So as a younger person, you function primarily in school. As an older person, we function in work. So Mr. Wilson has never had enduring, productive, successful jobs. He hasn't had long-term significant emotions. His social functioning beyond work has been, frankly, crimes and jail time. He is not functioning well. Although we heard that his high school transcript and his grades were pretty good, and he was roughly in the middle of a class, we also heard from Dr. Eisenstein that he has significant neurocognitive disorders, some of which are quite focal, although quite specific. So that's a problem. His emotions, we heard from the family, and we heard again in the brief letter from the sister, that his emotions were up and down, that he was often very depressed. The jail records are unambiguous that he says he's depressed, that he's seeking medication, that he wants treatment. I think his emotional states are dysregulated. They don't follow the way emotional states ordinarily should.
But does it appear from the record and your conversations with the family that Mr. Wilson was able to obtain the treatment that he desired?
Well, I mean, he got some treatment in jail and witnessed his present level of medication, but he never got adequate assessment any time, near as I can tell. That's one of the problems with his situation and with this sad case, that no psychiatrist or psychologist as a team has ever systematically diagnosed him, begun him on a course of medication which he stayed with and which he tried, and no one has ever been able to determine if he really would respond to medication over a long period of time or not. The Paxil he's on is moderately effective for people with classic depression. He clearly has something beyond classic depression, whether it's a major depressive disorder or dysthymic disorder. His depression or his emotional state is more badly affected than those with typical depressions, and his thinking is very clearly disrupted. We heard Dr. Eisenstein describe the kind of specific thinking disruption that he suffers from, but his thinking is, if you will, messed up beyond ordinary thinking. This is not somebody who's just burnt out because he did some bad drugs when he was in high school. This is somebody who's had significant thought disruption going back even before, even just contemporaneous with high school, before he was abusing drugs.
And with this psychotic behavior that he exhibits, how would ingestion of controlled substances affect that?
Well, and you can't really answer that question. The broad answer is it affects people individually, and just like psychotic symptoms vary person to person, and in fact, even with one person over time, the ingestion of drugs affects people variously. We know certain drugs, cocaine, amphetamine, are activating, tend to make a person more volatile, more short-tempered, angrier, so that would be true with those drugs. The opioids as a group tend to make people more relaxed, more passive. We know that cannabis or marijuana tends to make people more passive in general. And we know that for people who use a lot of cannabis early on, there are major neurocognitive consequences. A New Zealand study about 5 years ago demonstrated that the person who uses marijuana heavily at ages 13, 14, and 15 loses between 10 and 15 IQ points by the time they're 18 or 20. That's a major reduction in cognitive skills. So each of these drugs affects people differently, and each of these drugs affects individuals differently.
Now, you heard Dr. Eisenstein's testimony about the chronology of trauma to the head. We'll call it trauma to the head.
Fair enough.
We don't have enough testing or anything else to determine how substantial any trauma to the brain was. But did you take into consideration the head trauma?
Yeah, I mean, look, he may or may not have had significant head trauma. We don't have clear evidence about that. But we do know, and we didn't get there in Dr. Eisenstein's testimony, that there are neurocognitive disorders associated with the psychotic disorders. So people with schizophrenia in particular often exhibit changes, particularly changes in frontal lobe functioning as part of their illness. And that's been around, that knowledge has been around 35 years, that people with schizophrenia or schizoaffective disorder or psychotic disorders have significant neurocognitive problems, particularly frontal and prefrontal lobe problems, and those problems are things like perseveration. So that the finding, the significant finding, what was it, 7 standards of deviation below the mean, that kind of finding could be accounted for just by his psychotic disorder, with or without any kind of brain trauma.
Okay. May I have a moment?
You may.
You mentioned a term, perseveration.
Perseveration?
I've mispronounced it twice today. Perseveration. What exactly is that?
That means you keep doing the same thing repetitively and ineffectively. So that, I mean, I think as Dr. Eisenstein was explaining, if you have a card sort and you initially get the program right, you figure out it's a number or it's a design, or I've forgotten what the other one was, and then you assign new cards to that correctly, and then all of a sudden you lose that and you don't figure out what's going on, and as you persevere, you go forward with the old unsuccessful pattern, and that's perseveration.
Based on the information that you have, I think you told us before that he hasn't had a team work on him, a psychologist and a psychiatrist working together, maybe with a neurologist. Is it possible to fix Mr. Wilson?
I doubt that. I think it's possible to diagnose him better. I think it's possible to give him medications which would help him function significantly better. I mean, first of all, it's impossible to address the tragedy that brings us all here. That's happened. But beyond that, we can't fix him. We can't give him an IQ of 140. We can't make him a modern-day Einstein. We can't fully address these problems, but we can address some of them probably.
Okay. I don't have any further questions. Thank you. Oh, may I?
Yes.
You're appointed by the court to assist us in our defense. Is that correct?
Yes.
And you get paid?
I hope so. I haven't billed yet, but it's my intention that JAC will pay me.
Okay. That's a state agency?
Yes, here in Florida.
Yeah, the same one that pays Dr. Eisenstein?
Yes, and hopefully you too.
Okay. And what is your hourly rate?
$400 an hour.
Do you know if you have exhausted your initial time?
I don't believe I have, but I haven't even calculated it yet. I mean, the initial, I thought we would be done with trial last Friday, and one of the things I needed to do this week was to calculate my time, but I still haven't done that.
Do you have any idea, can you at least estimate how many hours you have in on this?
I think I estimated in my deposition something like 20 plus some travel time. It's somewhere around there.
I don't have any further questions. Thank you.
Good afternoon, Dr. Mills.
Oh, good afternoon, Ms. Miller.
I just want to clarify something the defense just asked. He asked if you were appointed by the court. The defense actually sought you out and chose you to be their expert. Is that correct?
I don't actually know the precise order of it. I think Ms. Perez called me and said, would I be willing to take an appointment? And I said yes. And
okay, go ahead. I'm sorry.
thank you. And, how the system works beyond that, I do know that ultimately JAC signed off on it. But exactly who said what to whom when, I don't know.
So defense has their own mitigation expert, Wendy Perez, who's sitting here in court. Is that correct?
Yes.
And she helps to get doctors for this case, and then the court orders payment of those doctors that are chosen.
Yeah, I think you're missing the JAC step in there, but fundamentally what you're describing is correct insofar as I know.
Okay. Now, you've worked exclusively as a forensic psychiatrist for the past 37 years.
Yes.
And you've testified on approximately 15 to 20 capital cases?
Yes.
And you're currently working on 5 or 6 capital cases?
Yes.
All for the defense?
Yes.
And you haven't had a regular practice seeing your own patients since about 2007?
Well, I don't mean to be quarrelsome, but my forensic practice is my regular practice.
Sure. A private. You don't have a private practice where patients come for therapy or for you to prescribe drugs?
Yes, although many of my engagements are private in the sense that it's not through a state agency or the DOJ or any other kind of agency. It's a private attorney or a private party retains me.
Okay. Now, in defense for capital?
Pardon me?
Defense for capital. Only defense attorneys?
No. I've done plenty of prosecutorial cases.
I'm talking about for capital cases, sir.
For capital cases, no. They've been all defense cases.
All defense. All right. Now, you mentioned you're not licensed to practice in the state of Florida.
That's correct.
So if the defendant took medication or needed medication, you won't be able to prescribe it?
No, I could call a colleague and suggest that she or he prescribe medication, but it would be her or his ultimate decision.
Now, it's my understanding that prior to meeting with the defendant in this case, you did not want to review materials. You wanted a blank slate.
Yeah, and I explained that to you in our deposition, which I guess was on Saturday.
Well, and I appreciate what you explained to me, but I'm asking questions so the jury now can understand the questions that I'm asking you. So I'm asking them for their benefit, not for mine. But when you met with him, you only knew basic information about this case.
That's correct.
So you didn't know a whole lot about the facts and details before meeting with him.
Yes.
And when you went and met with him the first time, he was somewhat uncooperative.
Well, he was initially cooperative and he agreed to do the testing, but then when I began asking him more information, he became, from my perspective, more guarded and ultimately hostile, and then indicated he wanted to stop with the questions.
He wasn't trusting of you, you didn't feel?
That's how it appeared to me. That's correct.
You felt he was somewhat paranoid?
Yes.
But there were no statements he made to you suggesting that. It was just his behavior, correct?
Well, his statements were saying that, he hadn't engaged in the alleged conduct here. That was a statement that struck me as obviously aberrant, where A, he had been, at that point he had not yet been convicted, but B, I had heard there is very substantial evidence at that point.
So that's an adverse comment. That's something that's not correct, but that's not paranoid, correct?
Well, it certainly may be paranoid. It's not delusional.
Okay. Now, he wasn't talking nonsense.
He was not.
He wasn't agitated in an abnormal way.
That's correct.
He exhibited no indications of mania.
He did not.
Now, the second time you went to meet with him, you indicated that he was very concerned about jail staff listening.
No, that was the third time.
Okay, so let's talk about the third time. He was very concerned about jail staff listening.
Yes.
And you would agree that a meeting where you're supposed to be getting personal, very personal information from somebody, that confidentiality is of the utmost importance.
Yeah, I think in general that psychiatric, particularly forensic psychiatric evaluations should be confidential, and that's why I acceded to his request to talk to the jail staff who was there and to encourage them to move away from the door, as I did.
So as far as him wanting that privacy and that confidentiality, that's not an abnormal request.
No, again, but you can, I mean, if you say, Doctor, I'm a little concerned that the staff might be listening, that's one thing. If you say, I don't want to go forward, and I say, how come? Staff could be listening, you know. The manner in which the comment is made or the issues are presented varies considerably. And although there was a rational component, I mean, nobody wants confidential material discussed in public. On the other hand, there was a irrational kind of hyper-wary sense that I need special treatment here. Something is not right. I was hired to try to help him.
You agree that you were in the court facility when you conducted this interview, or the jail?
The court facility.
You would agree that it's actually very echoey.
It's very what?
It echoes. So there's a big echo to it.
Not where I was, but I mean, I guess there are multiple rooms there. I didn't see it as very echoey.
You have to speak up. Would you agree?
Well, he was right next to the slot, again, as Dr. Eisenstein described, so I mean, I could hear him pretty well.
Now, you indicated that you did MMPI testing and PAI testing.
Well, I indicated that Ms. Perez did the MMPI. I administered the PAI, but that's correct.
Okay, so he was given both inventories,
Yes,
and both are personality inventories.
yes, and as you've heard me describe, they're both tests really of psychopathology.
And I'm just going to ask you, I'm asking you very specific questions, so I'd ask you just to limit your response to what I'm asking. But as far as these tests go, are they both accepted testing among the psychological community?
Yes,
And these are tests that you perform consistently in your line of work.
yes,
And you conducted these tests, or the Wendy Perez did, and you determined they were invalid.
yes,
And so because these tests were determined to be invalid, you weren't unable to give any clinical interpretation to these tests.
that's correct.
And these tests can be invalid by someone with a really low IQ.
Yes,
However, the defendant doesn't have a really low IQ.
that's correct.
The test can be invalid because of a different linguistic culture.
Yes,
And you're unaware of the defendant having a different linguistic culture.
no, on the contrary, I mean, I think he has the same linguistic culture.
And the test can be invalid because of a different just culture in general.
Less likely, but yes,
And there's no indication that the defendant comes from a different cultural background.
correct.
The test can also be invalid because of exaggeration.
Yes,
And after these two tests were completed, that's when he refused to meet with you any further.
yes,
And you were unable to get any other information directly from him.
no, remember, the testing was concluded, one before I ever saw him and the second one at the end of the first session. I was able to get some information in the third session, but not anywhere near as much as I had hoped.
And the information in the third session, what indications in that third session did he give you with regard to his mental illness?
Well, regard to his mental illness was his extreme wariness about going forward without the jailers moving away, and even when I arranged to have them moved away, he still wouldn't go forward. That was pretty extreme. It was, to my mind.
So that's the additional information that you got.
You cut me off, ma'am. I'm sure you didn't mean to. But to my mind, that was an indication of his enduring paranoia.
Other than how he acted, was there any other information that he gave you during that meeting?
Well, I mean, other than the death, I mean, how did you enjoy the play, Mrs. Lincoln? I mean, if something is fundamentally wrong with the way he's interacting, that's a serious problem.
Other than his interaction, did he tell you or say anything else during that session to you regarding his mental health?
Let me take a quick look at my notes, and I'll answer the question as best I can. Well, he started off by saying he refused to answer any more questions, even though Ms. Perez had asked him, how you doing? And he said, I'm doing okay. And then she said something like, how's it going with the attorneys? And he started on a kind of a diatribe, an angry critique of them. So that wasn't relevant to my particular observations, especially except that he seemed unusually critical And it was my understanding by this point that there had been some recent interactions between counsel and client that had been somewhat positive. At least that's my understanding from Mr. Shirley. So I was surprised by that. Again, it made me wonder about his level of paranoia. It wasn't dramatic. Again, it wasn't like Little Green Men, but it was something.
During this third meeting, did he tell you anything about his mental health?
Fundamentally, no.
Thank you. Now, you mentioned about the jails, and you questioned basically the competency of mental health staff in Florida jails.
No, not mental health staff. Staff.
Okay. And you talked about how the records and note-taking is lacking. in
Often.
jails. Now, you also said you've been to numerous jails and toured them, is that correct?
Yes, I've done that too, yes.
Have you toured any of the mental health sections in Florida jails?
Only at TGK.
Okay. And did you tour that to see what type of treatment they were offering?
No, I toured that to speak with the director and obtain records on one of the individuals who was there.
Have you ever sat down and looked at Florida inmate records to see how often they're prescribed medication when they request it?
No, but again, I've probably seen the records of 30 serious felons in the last 10 years in Florida. So, I reviewed carefully those mental health records to the extent that they exist.
Okay, so based on these 30 records, it's your belief that inmates are under-medicated?
No, not that they're under-medicated. It's my belief that, sometimes they're under-medicated, sometimes they're probably over-medicated, but it's my belief that the quality of the records is by and large not particularly good, and that the jail staff overall is not so interested in mental health issues, as I testified.
And that's your belief in your review of these 30 people in the state of Florida?
Yeah, I can either base it on studies or on my experience. I haven't seen a study that looks comprehensively at psychiatric treatment in Florida jails and prisons, although I would welcome that. But I have some now, after all these years here, some basis on which to make a observation or two.
Now, someone who is a drug addict, you would agree that they often seek medications?
Sure.
And did you review the jail emails where Mr. Wilson is constantly requesting drug information?
No.
So you're not aware of his medication request and wanting to know about side effects and what they might do for him?
Well, I've seen that in the jail medical records, but I haven't seen your question was about jail emails.
Correct.
I haven't seen that in the emails because I haven't reviewed those emails.
Now, in the jail records, you would agree that Mr. Wilson he refuses medications.
He has refused medication. He has sought medication. Yes, both.
And again, I'm just going to ask that you answer the question that I ask and not expand, please. Now, when he first came to the jail, he was actually on no psychiatric medications, correct?
Yes.
Okay. Now, you're familiar, doctor, with the DSM-5.
Well, as you correctly said earlier this morning, the DSM-5 has been superannuated. It's been replaced by the DSM-5 TR, which was copywritten 2 years ago in 2022. So that document you're holding is no longer current.
Now, this one, though, that I'm holding, though, the criteria for schizophrenia hasn't changed in the last 2 years. Is that correct?
Well, that's because the one you're holding is 7 years old or 8 years old, whatever it exactly is, and the criteria has changed in DSM-5 TR.
So if I may approach, Your Honor.
You may.
For the record, I'm going to approach and show the doctor some criteria for various mental disorders. Doctor, you agree that the DSM, the most current, is what's used to diagnose patients?
Yeah, you're talking about the DSM-5 or the DSM-5 TR?
DSM-5 TR, the
Okay.
most current.
Yep.
Okay, I'm going to ask, these came from the DSM-5 TR. I'm going to ask that you just take a look at these and tell me if you recognize these. I'm going to mark them as demonstrative aids, 1, 2, and 3.
Okay. I recognize these.
And do these appear accurate?
Those, due to my recollection now, there are pages of criteria for each one of these, and I don't have them memorized, but I certainly understand the content of them.
Okay. So, and do you have your DSM-5 TR book with you?
No, I don't. It's a little heavy to carry around.
All right. So I want to start by talking about the diagnoses that you made for the defendant in this case. You would agree that many of the things that the defendant says throughout these medical records are self-reporting.
Well, by definition, if you say it, it's a self-report. It may be accurate, it may be inaccurate, but it's a self-report.
So there's not some blood test or some confirmation. It's just him reporting, I've got these disorders. That's self-reporting, correct?
That's self-report. But staff obviously can observe and make observations. I mean, if somebody is hunched in their cell,
Sure.
that's different than engaging in a conversation.
And we'll get to that. We'll get to the observations because I would really like to hear what things you found in the record to support your diagnosis. So we'll get to that. You indicated on Friday in your deposition that you had diagnosed him with schizophrenia or schizoid affective disorder. Is that correct?
No, schizoaffective disorder.
Schizoaffective disorder. Those are the two you diagnosed with him when we talked on Friday, correct?
That's correct.
Now today it sounded like you were expanding it to bipolar or an adjustment disorder or some other type of disorder. Are you going to stick with the schizophrenia and schizoaffective?
I'm not sure I understand your question. First of all, adjustment disorder is a totally different category. I mentioned psychotic disorders. So I think psychotic disorder is the broad, correct category, and that would not include adjustment disorder. I personally think bipolar disorder is not as probable as schizoaffective or schizophrenia, and since I can't be more precise, that's why today, after thinking about it some more, I just said psychotic disorder.
Okay, so let's go through schizophrenia. I've marked this as a demonstrative aid, exhibit number 1, Your Honor.
Okay, are you any objection to these being admitted as demonstrative aids?
If they're demonstrative, they don't have to be admitted.
Right, they won't be admitted as
Okay.
evidence, just as demonstrative aids. Okay, so let's go through the DSM-5 TR's version for schizophrenia and what there must be for a diagnosis. Let's talk about delusions.
Okay.
You mentioned that you learned of delusions from his mom and closing the window. Is that correct?
Closing the curtains.
Closing the curtains, all right. Any other delusions that you learned of?
Yes, from the father I learned that he had told his father that there was something noxious or problematic or serious or explosive in the garage, and his father kind of poo-pooed it, and that conversation recurred. So ultimately, the father called the police. The father and the police went through the entire garage, and there was nothing untoward or unexpected in the garage. So that would be another delusion.
Okay, now, with regard to that delusion, did you find out if these delusions last for a 1 month or more period?
Well, from the context of the conversation, they had occurred recurrently over months, if not even years. So I think they certainly fit that portion of the criteria.
Okay, so let's talk about the garage incident. They actually called the police for that incident, correct?
Dad did, yes.
And did they tell you about any other times they had to call the police for that garage incident?
Not for the garage incident, no. But of course,
so the garage incident was really a one-time thing.
No.
Objection, Your Honor. She's interrupting his answer.
Well, sustained, we finish your answer.
Thank you, Your Honor. No, I think the garage incident was another aspect of there's something out there that's harming me and the family, and yet when examined carefully, there was no such something out there. So I think that's a continuation of the same harming delusion that he has harbored for months or years.
But again, there was no other indication that police were called based on that specific delusion.
Yeah, that's true, but it's irrelevant. But you're correct.
Okay. Now, moving on to hallucinations, I think you mentioned that Dr. Eisenstein told you that he reported hallucinations.
No, I think I said that Mr. Wilson reported to Dr. Eisenstein, and then Dr. Eisenstein told me, so that Mr. Wilson reported hallucinations. I didn't get that from him, and I didn't see him acting in a way that suggested that he was experiencing hallucinations.
And I'm going to ask that the witness be limited to answering my questions. He's giving very long narrative answers, adding a lot of information in to the questions I'm asking.
He was just correcting her because she mischaracterized his
I've heard the objection. Just remind the witness that you must be responsive to the attorney's questions.
Thank you, Ron.
With regard to hallucinations, what specific hallucination are you aware of that the defendant was experiencing?
I don't know. As you heard Dr. Eisenstein say on his direct, he didn't ask more, and I didn't glean that or gather that material from Mr. Wilson, so I can't characterize his hallucinations beyond that, other than acknowledging that he had them.
Okay, so again, there's not any specific thing that you can point the jurors to with regard to a specific hallucination that the defendant had.
That's correct.
Now, going on to disorganized speech, did you find any evidence of disorganized speech?
No.
And any evidence of grossly disorganized or catatonic behavior?
Not that I'm aware of.
Any negative symptoms, diminished emotional expression, or avolition?
Yeah, I think probably, I mean, first of all, you only need 2 of the 5, and I think we've already gotten the 2 from my perspective with the delusions and the hallucinations. But beyond that, I think the negative symptoms of social withdrawal, I would use the term, the psychiatric term, anhedonia, without the ability to take pleasure, depending on drugs for some kind of balm or soothing, I think that all suggests negative symptoms, and his going from sort of being averagely interactive to being reclusive and isolating himself either in his room or in the house or whatever.
You would agree, sir, that drugs also can cause some of these delusions or hallucinations?
They can.
Now, I want to go on to your further review of the record. You reviewed the affidavit and application for the arrest warrant from the state's discovery. Is that correct?
Yes.
And that was 11 pages.
Yes.
Did you review the statement made by Joshua Lukic, who called 911 regarding the defendant telling him he had just killed 2 women?
Yes.
And when did you review that? Over lunch?
No, I think I reviewed it yesterday afternoon.
Okay. And did you listen to the 911 call?
No.
Okay. Do you think that if in the statement to Lukic, he actually told him that he killed 2 women, right?
Yes.
And if the defendant said he just killed the devil, that would be delusional.
Yes.
And he said he killed 2 women, and that would be accurate, so not delusional, correct?
Yes.
And there was nothing that he said in his statement to Mr. Lukic that would cause you to believe that he was delusional at the time.
That's correct.
Now, did you review the statement of Stephanie Johnson, who was with the defendant throughout the evening and morning of the murder?
I believe I did early on, I mean, in the last few weeks, but not recently.
Okay. Now, when we met on Friday, you indicated you hadn't reviewed those statements, correct?
I think, yeah, I just didn't remember, but I think I had reviewed them previously.
Okay, so Stephanie Johnson, who was she?
She's, the witness who was, I can't even remember exactly, but I did review it.
Okay, so you don't remember, but there was nothing in her statement that indicated that Wade Wilson was hallucinating prior to killing the 2 women.
Nothing that I found in there, that's correct.
And there was nothing in that statement that indicated that he was suffering from delusions.
Correct.
And you would agree that a delusion isn't something you just pop in and out of. So he wouldn't be non-delusional and then an hour later delusional and then an hour later non-delusional.
That's correct, except particularly people who are paranoid very often don't discuss their delusions with anybody. In fact, to the extent that Mr. Wilson has delusions, I couldn't get him to discuss them with me, even though he knows I'm part of the defense team.
Now, you in Stephanie Johnson's statement, though, you saw no evidence of paranoia.
That's correct.
And did you review the statement of Melissa Montanez and her interactions with the defendant on October 6th and 7th?
I read her, 50-page, 60-page deposition, yes.
And when did you review that, doctor?
Oh, a couple weeks ago.
Now, when we met on Friday at your deposition, you indicated you had not reviewed that statement.
No, that was a mistake on my part.
Okay, so now you're saying that you reviewed it.
Now I'm saying, I am saying.
Okay, so, and who was Melissa Montanez?
She was the woman who was also assaulted in this series of sad events.
And did he appear to be hallucinating when he beat her up?
Not to her, but of course, I mean, if you're really in apprehension of being seriously injured, you're probably not wondering so much about what's in his mental state. You're wondering about how to protect yourself.
Okay, but again, doctor, there's no evidence of hallucination when he's beating her up.
That's correct. I mean, look, had there been such evidence, this case would have been an insanity case. This is not an insanity case.
Okay. And you actually, you're aware then that they actually agreed to meet at that Mila Spa.
Yes.
And you're aware that they later agreed to meet at Joe's Crab Shack.
Yes.
Now, did you review Shayna Williamson or Don Griffin or Amy Slobodzin's statement regarding what they witnessed?
I did not.
And did you review the statement he made to Timothy McCormick after the defendant murdered Diane Ruiz and Kristine Melton?
No.
And did you watch the video of the defendant's interaction with the officer?
No.
Don't you think that interaction might be important to gauge whether he was experiencing any hallucinations or delusions?
If one was only interested in his mental state at that moment, absolutely. If one's interested in his mental state more longitudinally over time, I don't think it would have made much difference. I mean, the evidence from my perspective is he's had serious mental illness for a long, long time. Whether it flared up in and around the time of these tragic events is a different question, and I don't have an opinion about that. I just believe that he is chronically mentally ill, chronically and severely.
Well, doctor, you indicated that you actually had a hard time getting information for this case because, number one, the defendant wasn't extremely cooperative. Number two, there weren't records outside the jail medical records. And you would agree, and you said, I think in your testimony, that the jail medical records had limited value.
Yes to all of that.
So, but you're saying that you didn't think the incidents or the situations surrounding the crime were that important for a diagnosis of schizophrenia or schizoaffective disorder?
A diagnosis over the months and years of his life. That's correct. I mean, look, they are obviously directly relevant to what occurred here, and to the extent that had there been such strong evidence, this would have been, as I indicated, an insanity defense case. This is not an insanity defense case. The evidence apparently was very clear. The jury deliberated and reached a conclusion relatively quickly.
Now, doctor, did you listen to a statement where he confessed to the murder?
Yes.
And did you find that he was hallucinating?
Not at that point, insofar as I could determine. I mean, his response seemed without hallucinations or frank delusions.
Okay. And it appeared that in that statement that he gave 3 days later to law enforcement that he was able to appropriately answer the questions.
Insofar as I know, perhaps. I mean, in some cases, the evidence is not very clear.
Now, you reviewed the jail medical records.
Yes.
And you would agree that most everything in those records was either self-reported or there wasn't anything at length regarding symptoms that the defendant had.
Well, and you know, I mean, it seems to me you're turning around my statement. I said that one of the problems with these records is very often jail records aren't very interested in describing an individual's mental state. You're right. I mean, so they're not very long, very detailed statements of observations about his appearance or style of interaction or whatever.
And those kinds of observations and those kinds of notations are a critical component of diagnosing someone with a psychotic disorder.
They certainly can well be, except we have other significant information about a seemingly okay kid who becomes very reclusive, who starts doing drugs, who starts getting significantly arrested, whose crimes appear to be escalating, and who appears to be having other difficulties, correct?
And I'll get to that. I just want to go through step by step the jail records and the various records you reviewed. Now, would you expect to see over a 10-year period of someone who suffered from schizophrenia to have numerous Baker Acts?
No, it depends so much on where they are. I mean, if they were living on the street, yes. If they were living in an affluent, educated home, perhaps not. So, you know, it really depends on what's occurring around them. Obviously, in Mr. Wilson's case, he's also spent a fair amount of time in custody. So once in custody, he's not going to be Baker Acted out of custody.
But you saw no significant notes in those 10 years of records regarding symptoms of schizophrenia.
That's correct. But again, you've heard me say now twice that oftentimes jails are concerned with security and control. They're not interested in somebody's mental state, so they're not making systematic observations, let alone drawing conclusions from those observations about an individual's mental state.
But again, I just want to answer to that question. There was nothing significant in 10 years of records to show symptoms of schizophrenia.
I think that's accurate.
Now, as far as family information that you relied heavily on, he was actually only Baker Acted once, by his father. Is that correct?
Yes.
And his dad called because he found drugs.
Yes.
And he was actually released the next day.
Yes.
And a teenager who would be Baker Acted for a serious mental illness like schizophrenia or schizoid affective disorder, you would not expect them to be released the next day. Is that correct?
Well, I mean, here's the problem with your question, that we don't have those records. We have the parents' recollection of what occurred. And I asked Ms. Perez, as soon as I first learned this information from the parents, I said, in effect, gee, can't we get those records? And she said, I tried hard. That mental state, that mental health center, I should say, is no longer in business. Those records are no longer available. So we don't know what transpired to have him released relatively quickly.
Okay, so, but at the end of the day, to just be released the next day would be unusual. You would agree?
It depends how he appeared, and it depends how the staff took the indications for his initial hospitalization. Without the records, it's very hard to draw any firm conclusions.
Now, you would agree that reclusiveness could be associated with drug use?
Yeah, except that the sequence is wrong here. Yes, I mean, it could be, but the parents describe his reclusiveness preceding his returning to high school and then later abusing drugs. They could be wrong, of course, but that's how they perceived it.
So, reclusiveness can be associated with drug use.
It can be, yes.
Becoming uncooperative can be associated with drug use.
Yes.
And in fact, the defendant told Dr. Eisenstein that he had been using drugs very heavily at the age of 13.
Yes.
And his sister believed he was taking amphetamines.
Yes.
Amphetamines can cause mood changes.
I'm sorry, say again?
Amphetamines can cause mood changes.
Of course.
Amphetamines can cause paranoia.
Yes.
And you agree the family was able to give general information, but not a lot of specifics due to a lack of any type of records.
Yeah, I mean, I don't know if it's lack of records or lack of recollection or the emotional trauma of what was occurring, but for whatever reason, they did not have good specific information. They had very clear impressionistic sense of what had occurred gradually.
So you were provided no mental health records by the family?
Correct.
No medical records by the family?
Well, and again, we heard from Dr. Eisenberg that those records, to the extent the family may have had them, there was a period where there was some kind of fire and they lost what may have been significant records.
So they were able to provide no medical records to you?
Yes.
No prescription records?
Correct.
And you actually determined he was grossly paranoid and apparently psychotic?
Yes, I still believe that.
Okay. And the family of the defendant, the mom said that he was different than the sisters, but the sisters had no use of drugs, correct?
Insofar as I'm aware, correct.
And you looked at his school records.
Yes.
He got mostly A, B's, and C's other than math.
Yes.
And he got expelled for selling drugs.
Yes.
It was not for hallucinations or paranoia.
Correct.
And you talked to Dr. Eisenstein.
Yes.
And he told you that the defendant had been suicidal.
Well, he told me that the defendant told him that he had been suicidal, correct,
And suicide can be a sign of depression.
of course.
Suicide can be a symptom of drug use.
Yeah, I mean, generally the intermediate step is depression, but yeah, it can be.
And you would agree that these hallucinations that Dr. Eisenstein reported to you, he didn't give you any details about them.
That's correct.
And the symptoms in which you base your diagnosis, other than observing some paranoia, are not ones that you observed or heard firsthand from the defendant.
That's correct.
And many of these symptoms are not in the jail records.
True, for the reasons we've discussed, yes.
He actually, the defendant reported to the investigator that his diagnosis was ADD.
Well, he may well have that, but yes, but it hasn't been fully explored.
Okay. And in fact, his family, the school records don't support a diagnosis. There's no diagnosis in the school records.
That's correct.
And none of the actual facts, the witness statements of the case that you reviewed, show any evidence of hallucinations or delusions.
In and around time of these events, that's correct.
And you're sticking by your diagnosis today as some sort of psychotic disorder, specifically schizophrenia and schizoaffective disorder. Is that correct?
Well, when you say sticking with your diagnosis, that sort of demeans it. I mean, I spent some hours trying to come up with the best understanding of his diagnosis as I could, given the admittedly limited records that are available to me and his uncooperativeness. That is my best understanding of his psychiatric condition, but I'm not sticking with it. That's the diagnosis that I came up with after spending some time thinking about it.
Okay, so you're testifying here today that it's either schizophrenia or schizoaffective disorder.
Well, and let's just call it generally a psychotic disorder, yes.
No further questions. Thank you.
Doctor, let me clear up something. You've been licensed or practicing as a psychiatrist or forensic psychiatrist for 50 years, have you not?
Only 49, I think.
49. What types of other engagements have you had during those 49 years?
Well, I was the Commissioner of Mental Health in Massachusetts, so I had 32,000 employees when I was 36 years old, and I ran the state's largest single agency. I was the chief of psychiatry at the largest psychiatric hospital in North America, the West Los Angeles Veterans Administration Medical Center. We had about 500 inpatient beds and did more than 200,000 outpatient visits a year. I've been the director of 2 psychiatry and law programs, one at Massachusetts Mental Health Center with Tom Gutile, and one at the UCLA Neuropsychiatric Institute in Los Angeles. And I've been an assistant or an associate or full professor both at UCLA and at Columbia University in New York, also at Georgetown and at New York Medical College in New York.
Did you testify at the request of numerous judges in the state of New York?
I have in federal cases, yes, sir. I did a couple of national security cases, and then I've been a judge's expert in Virginia with Chief Judge on a case of involving competency to be executed. I was the district court judge, federal district court judge's expert in a double homicide in Los Angeles.
You aren't licensed in the state of Florida, but you don't have a clinical office here in the state of Florida, do you?
No, and look, I mean, as you well know, laws change jurisdiction to jurisdiction. So, it might make sense to have a different law license in Florida than in Virginia or in Georgia. But psychiatric disorders, medical conditions, don't vary when you drive from Georgia to Florida or from Georgia to West Virginia or whatever. So the rationale for medical license is quite different than the rationale for a legal licensure.
In the type of practice that you have now, you don't need a license.
Well, yeah, I need a license somewhere, but I am licensed. I mean, every state has its own additional requirements. The more licenses you have, the more additional hoops you have to jump through, and you have to pay a licensing fee, the more licenses you have. I could theoretically have 10 licenses. No, thank you. One set of hoops is enough.
Nevertheless, you've been permitted to testify as a forensic psychiatrist in numerous jurisdictions here in the state of Florida.
Yeah, many times. That's correct, sir.
Okay. The prosecutor asked you a couple of minutes ago about school records. There wasn't any mental health information in the school records that you saw. As a matter of fact, the only thing that was in the school records was basically his grades. Isn't that correct?
That's correct. I mean, it's a one-page document, as we've already heard testimony about, and there's not much more there except, you know, he sort of did averagely in a class of 600, a pretty good size high school class.
Presumably there are records, but you didn't have access to them.
Correct.
Did you think that it was important to your diagnosis in order for you to review the various witness statements that were either taken by law enforcement or taken in depositions?
No, I mean, I did. I wanted to review the other victim in this mess, and I did. But in general, I did not think it was important because I'm talking about something that's long term, and that, you know, sadly, whether Mr. Wilson's profoundly bad behavior was occasioned by his chronic psychiatric disturbance or the use of illicit medications and drugs, or both, I can't opine, but I can say that he does have the chronic psychiatric disorder.
Okay. The prosecutor asked you a minute ago, she kept talking about whether or not this was delusional or whether or not this was delusional. Did you read the statement, the transcript of the statement that Mr. Wade Wilson gave to the detectives on October 10th, 2019?
Yes.
Okay. And in that statement, he mentions having anal sex with Ms. Ruiz prior to killing her.
Yes.
You recall that?
I do.
Well, if they didn't have anal sex and he's reporting that they did, is that delusional?
It could be delusion. It could be braggadocio. I don't know. I mean, without asking him more, it's very hard to know. But it certainly would be inaccurate if it didn't occur.
How about running her over 10 to 20 times? What if that didn't occur? Is that delusional?
Again, it could be delusion, it could be braggadocio, but it is certainly inaccurate and needs to be evaluated further.
Or when he was talking to the detectives and they were asking about his feelings toward his girlfriend, when he told them that he loved her, he would never kill her, I would never even do anything. I don't know, I could never say, but I probably would kill her. And what is that?
Well, that's, I mean, it's fascinating. B, it sounds at the least confused. And C, it's oddly self-destructive. We haven't talked about everything I think I've learned in this case, but at one point, the parents describe how their younger daughter was trying to give Mr. Wilson a haircut, and she asked him to take off his shirt, and he had or his hoodie, and he had his shirt literally stapled to his arm. Well, why would you do that? It's obviously painful and self-destructive. I don't know the answer because I couldn't get him to really talk to me, but it suggests, you know, significant disturbance. Most people don't staple their clothing to their body.
Okay. How about the tattoos on his face?
Well, I mean, they're disturbing and they're disfiguring, I think, but I'm an old guy. I mean, there are some people who like skin decoration, but I would say most people would be off-put by those tattoos.
All right. Did you see a picture, booking photo of Mr. Wilson?
Yes.
Okay. And he didn't have any of those tattoos on his face?
None.
I don't have any further questions. Thank you, sir.
All right.
You would agree, doctor, that telling a lie is not a delusion?
It could be a delusion, or it could be a lie, or it could be both.
Okay. Thank you. No further questions.
All right.
All right, you can step down, sir.
Thank you, sir.
All right. It's all right, ladies and gentlemen, it's 3:20. I'm going to take an afternoon break. Let's all go back for about 10 or 15 minutes. Be in recess. Just remember my earlier instructions.
All rise.
Let me see. All right, let the record reflect state's present, defense counsel, and the defendant are all present. Please be seated. All right. Oh, are we ready to proceed?
Oh, I'm sorry, yes.
I didn't know if, okay.
State's ready, Judge.
All right, so procedurally, we'll call the jury back out, or you said you have no more witnesses, and Mr. Wilson, and I apologize, I know you're talking, and I'll give you more time if you need it, but Mr. Wilson's maintaining his decision not to testify, correct?
Correct.
Okay, and
I'll
then
just stand up, and when they come in, I'll rest.
you'll rest, and then the state's going to call their witness in rebuttal? Okay. All right, then are we ready, and do you need more time to talk to Mr. Wilson? You can if you want.
No, I'm good.
Okay. All right, then are we ready to bring the jury back out? Let's bring them out. All right, please be seated. All right. Mr. Shirley.
Sir? Oh, I'm sorry. At this time, on behalf of Mr. Wade Wilson, we would rest our case.
All right. State, any rebuttal?
Yes, Judge. Say we'd like to call Dr. Michael Herkoff.
And sir, if you'll just face the clerk, raise your right hand.
Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
You can take the stand. You may proceed.
Thank you, Your Honor. Okay, good afternoon, Doctor.
Good afternoon.
Would you please introduce yourself to ladies and gentlemen of the jury by telling them your name?
Sure. Michael Herkov, Herkov, as in violin.
Now, I refer to you as a doctor. What exactly is it that you're a doctor of?
I have my PhD in psychology.
Could you please describe for us what your qualifications are that allows you to do the work that it is that you do?
Sure. I got my undergraduate degree in psychology at Baldwin Wallace College outside of Cleveland, Ohio. I received my master's degree in clinical psychology from University of Central Florida in Orlando. My PhD in psychology from Auburn University in Auburn, Alabama. I then did an internship at Eastern Virginia Medical Center in Norfolk, Virginia. I then did my psychology residency at the University of Florida College of Medicine in Gainesville. I did postdoctoral training, means after you get your PhD, in neuropsychology at the Gainesville VA, and I did training in forensic psychology at the University of Florida College of Medicine.
You indicated neuropsychology. What exactly is neuropsychology?
You heard some of that, the study of brain-behavior relationships. Neuropsychologists tell us how the brain works. It doesn't tell us so much about the structures of the brain, but how the brain is functioning.
You also mentioned forensic psychology. What exactly is that?
Forensic psychology is that interface between psychology and the law. It's where psychologists, neuropsychologists, clinical psychologists bring in information about psychology to places like this so that people who have to make decisions can use that information.
Fair enough, Doctor. Now, are you licensed here in the state of Florida?
I am.
All right. And what exactly is a board certification?
Board certification is, it may surprise you, but a licensor just establishes basic qualifications. Board certification is expertise. It shows that in your particular area. So a physician actually is licensed in Florida as a physician. He or she shows their specialty by being board certified in neurology or surgery or radiology.
You board certified in anything?
Yes, I'm board certified in clinical psychology by the American Board of Clinical Psychology, American Board of Professional Psychology, and I'm board certified in neuropsychology by the American Board of Professional Neuropsychology.
Now, we talked a little bit about forensic psychology. Could you please describe for ladies and gentlemen and jury what your experience was in regards to forensic psychology?
Sure. So I went through the training program at UF in forensic psychiatry, psychology. They actually have a program there that teaches psychiatrists how to become forensically trained, and I went through that program in psychology. As part of that, I ultimately began supervising and teaching within that program, so I was on faculty in that program. I became the director of forensic psychology at the University of Florida College of Medicine, and I was the chief of forensic addiction psychology at the University of Florida College of Medicine.
Now, did you do any evaluations in criminal or civil court while a faculty member at UF?
Absolutely. UF it's one of the rare places. It actually has its own forensic division. So the things I'm doing today, I did when I was on faculty at UF.
Now, did you also serve as a chief forensic addiction medicine at the UF College of Medicine as well?
I was, yes.
Could you tell us a little bit about your occupational history, Doctor?
Sure. So after I finished my residency at UF, I was brought on to faculty at the College of Medicine, Department of Psychiatry, where I became a tenured associate professor. So I was at UF from 1990 until 2003. In 2003, I left UF, and I went to the University of North Florida in Jacksonville to run their psychology graduate program. People are getting a degree in psychology. And then I got recruited back to UF in 2009. I was at UF in 2009. When I came back in 2009, I had two appointments. I had one in the College of Medicine where I saw patients at UF Shands Hospital. You are familiar with UF Shands. And then I also had an appointment, what we call at Florida, up the hill in the College of Arts and Sciences, Liberal Arts and Sciences, where in the Department of Psychology, where I actually had PhD students who were becoming psychologists, that I supervised them, their research, and I taught in that program.
Now, what roles or titles have you had at the University of Florida, Doctor?
I have been the director of the human behavior course in the medical school, which means I was responsible for teaching the medical students all about human behavior in the first year of their medical training. I was the director of forensic psychology. I was the chief of forensic addiction medicine. I was the director of addiction psychology. I was the program director for a program called UF Cares, where we would bring in physicians who were having some sort of concern about their ability to practice, and we would evaluate them physically, skill-wise, and mental health-wise to see what the problem was and if they could practice. And I started a program at UF called the UF Power Program, and that was a program that was designed for professionals, mostly physicians, but some attorneys, who were very good at what they did, but they never learned what you're supposed to in kindergarten. That's how to play nice and get along with others. And so they were disruptive in the field, and so we fixed them.
Now, you also indicated that you did some teaching as well. Is that correct?
Yes.
Okay. Could you please describe for us when that began?
Sure. So in the College of Medicine, I told you I was the director of the human behavior course for the medical students. I taught students in the PA physician assistant program. I taught nursing students. I taught undergraduate students. I had a course called the Neurobiology of Addiction that I taught. I then, at UNF, I taught abnormal psychology, how to make diagnoses. I taught substance abuse. I taught psychology and the law. I taught ethics. I taught a bunch of courses. When I came back to UF the second time, I taught into graduate school. So when I came back and I taught in liberal arts and sciences, I didn't teach undergraduates anymore, only doctoral students. And I taught two courses, which we'll be talking about extensively today. One is the cognitive assessment course, sort of the neuropsychological tests we're talking about. I taught that course. And then I taught what we call the personality assessment course, which specifically deals with psychological issues, specifically tests like the MMPI that we'll be talking about today.
And Doctor, have you had the benefit of listening into Dr. Eisenstein's testimony here today as well as Dr. Mills's testimony?
I did.
Okay. Now, we've also heard from these doctors as it relates to psychological tests that they administered, specifically the Wechsler Adult Intelligence Scale, the PAI, and the MMPI. Are you familiar with those tests?
I'm familiar, and I taught those tests. I taught those tests in the graduate programs I talked about. I have taught the PAI. I have taught the MMPI. I have published on the MMPI. I have given seminars on the MMPI. So yes, I'm familiar with all those tests, not in terms of only administering them. I've given thousands of those things. I mean, in terms of everything I've done at UF.
Okay, now we're going to get into that a little bit later, but I'd also like to ask of you, have you conducted any research as it relates to your background and training experience in psychology as well?
I have. At UF, you have to see patients, you have to do research, and you have to teach. It's a busy place. And so I have a little over 40 publications on various psychological tests, various psychiatric diagnoses, depression, PTSD, effects of substance abuse on brain functioning. So yes, I've about 40 or so publications.
Okay, I'd like to talk to you a little bit about your experience, Doctor. Could you talk to us a little bit about your clinical experience and what exactly that is?
Sure. So at UF, my primary assignment when I got there was UF Shands Hospital, Shands Teaching Hospital, which you're probably familiar with. I worked on the inpatient psychiatric unit from 1990 until 2003. So saw adult inpatients with a variety of conditions, from depression to schizophrenia to schizoaffective to bipolar to dementia. I mean, UF is what we call a tertiary care center, which means a lot of times people around the state will send cases to us where they say, yeah, let's send this to Shands. And so we see everything. There's probably, I mean, relatively few diagnoses I haven't seen in my career. I also worked on the adolescent inpatient unit. So we had a unit specifically where adolescents who need to be hospitalized were brought in. I worked on that for that period of time. I worked in our outpatient clinic, so seeing patients come in off the street who have, more people like you or I who have depression or marital problems. I worked in our EAP program, our employee assistance program. I worked in the consultation and liaison service, which means when psychology or psychiatry would go to a different floor. So if you're on the surgery floor and you're having some mental health issues, we would come down and evaluate you. I worked at the UF Substance Abuse Treatment Program. UF, again, is one of the few universities we have our own substance abuse treatment center. I was a neuropsychologist there, so I evaluated people cognitively, mostly with impaired professionals, doctors, nurses who had a substance abuse problem. They came in, they got their substance abuse problem fixed, but then the question was, well, okay, have they done any kind of damage to their brain where they maybe can't practice anymore? So I worked in that. I have worked, I had a contract with the Department of Juvenile Justice where I would evaluate adolescents who had gotten into trouble with the law in some way. before they got sent to a program. So I'd have to evaluate them and say, hey, do they have mental health needs or cognitive needs that need to be taken into account when they go to that program? I've treated outpatients from older age children all the way up to people in their 70s and 80s.
Now, currently, what exactly are you doing in a clinical setting?
So in 2013, I left the Department of Psychiatry and started my own clinical practice, but I kept teaching until about 2019, right before COVID, and I didn't go back to teaching after that. And so I have my practice right now, and that's all I do.
Okay, now, how much time would you say evaluation and treatment is of your various patients?
So it varies over time, but I'd say right now about 30% of what I do is what I'm going to call patient care, evaluating and treating patients. About 70% is medical legal work, and about 10 to 15% is consultation. And you're going to say, well, that's more than 100%, and that's true. But it goes back and forth.
Now, you indicated that 70% was forensic reviews?
Yes,
or
medical
evaluations?
legal work, yes.
Okay. Now, how much of that would you say is criminal versus civil?
Again, it changes. These days, most of what I do is civil, but I do some. Could I give you an accurate percentage? No, but I will tell you clearly the bulk of what I do is civil.
Now, do you do referrals for both plaintiff and defense?
Yeah, it doesn't matter to me who asked me to see the person. I'll see your person.
Okay, so if it's criminal, do you do work for the state as well as for the defense?
Absolutely, of course.
And what types of patients have you evaluated and treated over the years, doctor?
You know, in the 30 years that I practice, I've seen close to 10,000 patients, evaluated or treated 10,000 patients with virtually almost any diagnosis that you could think of, from schizophrenia to anxiety to ADHD to conversion disorders. I mean, it's, again, maybe there's a couple I haven't seen, but not many.
So mood disorders like depression or bipolar?
Oh, absolutely, of course.
So how about psychotic disorders such as schizophrenia?
Oh, yeah, psychotic disorders and bipolar disorders, they usually end up in a hospital. So, yeah, there was a bulk of what we saw at U of Shands.
Did you see anyone with grief?
Oh, yeah, so a lot of grief. In the EAP program, outpatient, yeah, a lot of people with grief and loss.
What about brain injuries?
Sure, that's as a neuropsychologist, that's what I do.
And anxiety disorders?
Absolutely.
And thought disorders?
Yes.
What about substance abuse?
Sure. Yeah, I've published in substance abuse. I said I was the chief of forensic addiction medicine and the director of addiction psychology at UF.
Now, specifically as it relates to substance abuse, did you have an opportunity to treat any adolescents as it relates to substance abuse?
Absolutely.
And what types of things did you note when you began to evaluate individuals, specifically adolescents with substance abuse?
So the substance abuse with adolescents is actually a little tricky. So a parent would bring their child in and say, you know, he's acting differently. He's not doing well in school. He's sullen. His behavior's changing. And I say, well, have you thought about, is he using alcohol or drugs? No. We know it's not that. It's something else. I say, okay, just to be safe, let's get a drug screen. And more often than not, when you see a problem in an adolescent where they have a dramatic change in behavior, the first thing you better start thinking of is substance use.
So when we're talking about substance abuse, is it common for the child to become reclusive?
Absolutely.
Paranoid?
Paranoid, argumentative. I mean, you'll get the story. He was such a nice, and then now he's this. Absolutely.
So perhaps maybe even delusional?
Yeah, depending on the substances you take, absolutely.
Okay. What about hallucinations? Is that possible as well?
Sure. I mean, a lot of, if you're using LSD, if you're using mushrooms, even if you're using amphetamine, you can hallucinate and look very psychotic when you're on drugs. Absolutely.
Now, doctor, have you ever testified or been admitted as an expert here in the state of Florida?
Oh, sure, lots of
times. As it relates to psychology matters?
Yes.
And what types of things have you testified in?
Neuropsychology, brain injury, substance abuse, psychological problems, grief, fitness for duty, a variety of things.
Now, you previously indicated that you do evaluations in criminal matters as requested by the state as well as the defense. Is that right?
I do.
Now, do you know who retains you to have an impact on your findings?
Absolutely not.
I mean, does the person who's retaining you have an impact on your findings?
No, I was just asked by the state to evaluate somebody for insanity, and I found the person insane. I mean, it doesn't matter who refers them.
And did you in fact find him insane?
I did, just on Monday. Last Monday.
Now, what type of experience do you have, if any, as it relates to testifying in death penalty cases, Doctor?
I've testified in death penalty cases, both for the state and for the defense. I've done work for a group called Capital Collateral, which is this agency that's funded specifically that does death penalty appeals.
Okay. And have you found mitigators for defense?
Of course.
Now, were you asked to perform anything or do anything in this particular case?
Yes.
What were you asked to do in this particular case?
To get involved, to evaluate Mr. Wilson, and to provide some information in terms of this sentencing about mental health or cognitive issues.
Now, what did you do to answer the questions regarding whether or not there was any type of emotional or cognitive or other factors that would be relevant as it relates to the current issues that we have in this case?
I reviewed records, and I interviewed Mr. Wilson.
When did the interview of Mr. Wilson take place?
Took place on Wednesday, this past Wednesday, which would have been the 19th.
And when you met with Mr. Wilson, could you please describe for us how that came about?
How it came about?
Yes.
I was asked to see him, and I came down to see him.
Okay. And did you ultimately meet with him?
Did I meet with him?
Yes.
Yeah, absolutely, at the core facility.
And did he, when he met with you, did he indicate to you how much time he was going to spend with you?
Yeah, when we first started off, he was very candid. He said, look, I know that the state has asked you to see me. You're here, working for them. I have my guys working for me. I'm going to give you 15 minutes, and that's it. And I said, okay, I'll take whatever I can get. But we ended up talking for over an hour.
Now, you also indicated prior to actually sitting down or after sitting down with Mr. Wilson, you indicated that you reviewed a series of records.
I did.
Okay. Could you share with us what exactly it is that you reviewed?
I reviewed a lot. So I had, before I met with him, I had reviewed police statements, I had reviewed investigative report, I have reviewed medical records when he was incarcerated, I had reviewed some statements, a statement by Ms. Johnson and a statement by Mr. Testica, am I saying his name correctly? Testica, his biological father. That's what I had done before I had interviewed him.
All right. Did you also, after you had an opportunity to meet with Mr. Wilson, did you have an opportunity to watch the video of Mr. Wilson when he spoke to detectives?
I did.
All right. And did you also have an opportunity to watch the body cam of Mr. Wilson when he was talking to Officer Tim McCormick?
I did.
All right.
This is outside the restaurant? Is that the officer?
That is
Yeah,
correct.
Correct.
Yes. And also, did you have the benefit of reviewing the school records?
All after this, yes.
And then apparently there was a timeline that was conducted by and through Mr. Wilson's adoptive mother. Did you have an opportunity to review that?
I did.
And did you also see the records regarding his admittance to the Lee County Hospital?
I did.
And you indicated that you had gone ahead and reviewed the incarceral medical records. Is that right?
Correct.
Now, there was almost over, 600 some odd pages in that?
Yeah, it was well over a ream.
Okay. Now, did you also have an opportunity to review the emails that Mr. Wilson had gone ahead and written specifically between himself and a young lady by the name of Kaylee Bogaski, a lady by the name of Andrea Lopez, Erica Bonpastoli, Hannah Hall, Alexis Williams, Jessica DeHanica, Brooklyn Gilly, Riley Texas, and Mr. Steve Wilson.
I did.
Now, did you also have an opportunity to review some of the statements of the witnesses in this case, specifically of Ms. Melissa Montanez,
Yes.
and Ms. Stephanie Johnson, Mr. Jason Shepard, Ms. Amy Slobogian, Joshua Lukic, Mr. Stephen Testaseca, and then Mr. Tyler Klusner. Is that correct?
Yes.
All right. Now, did you also have the benefit of reviewing the defense investigative reports in this particular case as well?
I think there were two.
Yes. And did you review a letter that was written by Mr. Wilson's sister, specifically Miss Wendy Wilson?
Yes.
And did you also have the benefit of reviewing a letter from the mother that was only consistent of one page?
Yes.
And did you review the test data that we heard extensively about this morning from a Dr. Eisenstein?
Yes.
And did you also review the raw test data of a gentleman by the name of Dr. Mark Mills?
I did.
And lastly, Doctor, did you have the benefit of reviewing the depositions of Mr. Eisenstein as well as Mr. Mills, or Dr. Mills, excuse me?
I did.
All right. Now, all that information that you had the benefit of reviewing, is that important to you?
Sure it is.
Why?
Well, because, I mean, not all information is equal, but information, what we call collateral data, gives you a context how to evaluate somebody, not just in terms of what they tell you or what you see at the time, but what's the larger picture.
Now, when you talk about the collateral data, you indicated it's more than what the client is telling you. Now, why is it important what the client's telling you important to compare with the collateral data that you've received?
Well, because what a person tells you may not be correct. It may not be correct because they're simply misinformed. I've asked lots of people if they have a problem, they say they don't. I've asked people if they have a problem, they say they do, and they don't. They may also be trying to deliberately either exaggerate or minimize what's going on. And so what they tell you, you want to be able to take that, okay, what did other people see?
So if someone were to tell you that he was charming, cool, polite, in a good mood, that type of thing, you would also compare that with whatever you had the opportunity to review in the discovery in this particular case as well. Is that right?
Absolutely.
All right. Now, is any information more valuable than any other, doctor, that you had gone ahead and reviewed in this case?
Yeah, I think it varies by what you're doing, but I think in a case like this, seeing the body cam footage of his interaction with the police officer the morning, the day after this had all happened was very important. Having about 13 years, 10 years of medical records was important. Having the psychological test data from Dr. Eisenstein, who's kind enough to send it to me, was important. Because what it allows me to do is look at the exact same data he sees and to form my interpretation. It's sort of like an x-ray where your physician, she sends your x-ray to another orthopedic doctor and he reviews it. And so we're seeing the same thing. So that type of data in a case like this was important. I think probably on a scale was at the top of what I reviewed.
Now, why is the actual video at the time around this murder, why was that important?
Well, because none of us was there. And so we have to rely on what people tell us happened there, which is valuable and we do all the time. But when I have the opportunity to actually see it with my own eyes, then I'm there. And I get to really form some opinions, not as a police officer describing somebody's behavior is great, but he's a police officer. I'm a clinical psychologist. I look at things and ask things differently. So being able to see it is invaluable.
Now, you indicated that you had received the raw data for the testing that was conducted in this particular case.
I did.
Why is that raw data important to you?
Because I get to see exactly what Mr. Wilson said. I get to see the scores. I get to see the pattern of scores. I get to see the x-ray. I get to look at it and say, Okay, is that a fracture? No, it really makes what Dr. Eisenstein and I do no different, other than his interview. But he's got the data. I'm assuming he did the testing correctly. I have no reason not to, and so I've got his data.
Now, during the course of your opportunity to sit down with Mr. Wilson and review the extensive records in this particular case, as well as all the various statements, the videos and emails and all the other discovery, voluminous matters in this particular case, did you form any type of opinions and make any findings in this particular case?
I did.
All right. Let's talk about your first opinion in this particular case. Does Mr. Wilson suffer from any type of psychotic disorder like schizophrenia or psychoaffective disorder, or from any type of mood disorder?
He does not.
Okay. Now, doctor, we talked a little bit about the DSM-5 TR. What exactly is the DSM-5 TR?
This is the DSM-5 TR, all 1,034 pages of it, and it is the diagnostic and statistical manual. So what it does is it sets the diagnostic criteria for every disorder, okay? A lot of times we use terms in our everyday language, I'm so depressed, or he's schizo, or my sister's bipolar. Well, this tells us what that is, and it has specific criteria. And the reason it has specific criteria is so that clinicians follow it, and so that when I talk about depression, it's the same as Dr. Jones talking about depression. We don't each have our own definitions of depression. These signs and symptoms just weren't thought up by people sitting around having a couple of drinks. It's based on clinical and research data. Over the years, we are now in DSM-5 TR. You heard before the DSM-5 is different from DSM-5 TR in diagnostic criteria. It's not. The diagnostic criteria, the symptoms for depression are the same. What's changed is the text revision. They've updated some of the research, but the diagnostic criteria is the same. And so the DSM has to be followed. Otherwise, depression is whatever I say it is.
Fair enough, doctor. And in preparation for your testimony today, did you also have an opportunity to go ahead and present and prepare a series of slides for us that would basically demonstrate for ladies and gentlemen of the jury what your opinions and findings are in this particular matter?
I did.
Okay. Judge, let the record reflect, I'm sure the defense counsel increasing mark states demonstrative number 2. They have been previously shared with defense counsel over the break.
You may.
Doctor, I'm handing you composite demonstrative states exhibit number 2. As you take a look at those items and those slides, do you recognize those?
Yes, these are slides I prepared.
Very well. So these would assist you in your testimony here today?
Yes, and explain to the jury, for sure.
Any objections?
No.
All right, you may.
This is Mr. Hollander.
Now, doctor, as we're looking at this, this is the diagnostic and statistical manual for mental disorders that you just previously described for us.
Correct.
And this is an authoritative text that you rely upon in order to go ahead and diagnose and treat various patients and evaluate them. Is that correct?
Yes, this is the authoritative, and by that I mean this is the standard for making diagnoses.
Now, we had discussed your opinion that Mr. Wilson does not suffer from a psychotic disorder like schizophrenia or a psychoaffective disorder. Is that correct?
Correct.
Now, as we're looking at the second portion of your demonstrative aid, why do we not have any evidence of any schizophrenia or psychoaffective or bipolar disorder?
Sure. So Well, just going through the history, there is no indication in any of the medical records that I reviewed from the incarceration, going back to 2013, of the psychiatrists, psychologists, mental health counselors employed by the state of Florida in these facilities that made a diagnosis of schizophrenia, bipolar disorder, or schizoaffective disorder. If there is, I'd like to see it because I could not find it. Now, there is a mention in there where Mr. Wilson says that he was diagnosed with bipolar disorder when he was younger. That's what he says. But that's not what he was, they never came up with the diagnosis. He was diagnosed with major depression, he was diagnosed with anxiety, and he was diagnosed with an adjustment disorder. So he was diagnosed with some things, but not these diagnoses. And as you have heard from testimony today, these are serious diagnoses. These are not something that you're just going to sort of miss. And so that whole time there was no history of any of that. Now his family makes some statements about him being bipolar, and I'm not attacking their credibility at all. But part of that comes from Mom's outline of his behavior, and it's 4 pages, and she has like one entry for 2002, 2003, 2004. She has May, his 10th birthday, September. I mean, this is hardly a detailed timeline. There is one reference in here in 2007. During the summer, he was changing, quieter, wanted to be alone, always worried about his freckles, took him to a specialist about his jaw. He said he was in constant pain, diagnosis normal. Symptoms of bipolar by Dr. Wilson, family doctor. I don't have any of those records. There's no indication that he was ever treated for a bipolar disorder. You treat that very differently than you treat something else. If you have a schizophrenia or you have a bipolar disorder, you tend to get noticed and you tend to get hospitalized. If you're delusional, if you're bipolar manic, and we may talk about what mania is in a little bit, you tend to get noticed. We have no hospitalizations. One, and you heard about this before, one Baker Act when he was 13 or so, it's hard to get the exact age so we don't have the record, after Dad found drugs, Dad called the cops, police came, he ran away, they took him to the Appalachia Center, which is up around Tallahassee, kept him overnight, he went home the next day. If somebody is schizophrenic, which means they're delusional, they're hallucinating, or they're bipolar, where they're manic, first of all, that's not going to go away in 12 hours, and you're probably not going to go home. On a Baker Act, they can keep you for 3 days, and they're going to keep you for 3 days and watch you. So I don't know. First of all, I don't even know if that happened. I'm not questioning this, but I have no records about that. But that's the only hospitalization anytime on this. And that occurred, of course, at a time when he was using drugs. We talked about the years of the records where there's no signs and symptoms, but there's also specific examples where he's denying these symptoms. If you look at a record from 9/17/18, he denies mania. So a specific denial there. 10/23/17. It's getting bad. Denies auditory visual hallucinations. Likewise, denies paranoia, panic attacks, mania, and any symptoms of an obsessive compulsive disorder. So it's not just that nobody ever noticed these things. People ask him about it, and there's no record of it anywhere in the file. And then, of course, none of these diagnoses that we've talked about today can be made in the face of substance use. None of them.
Why not?
Because the DSM says not. If you put up the criteria, you will see that every one of these diagnoses says the same thing. And the same thing it says is, I'm just going to read it to you. the disturbance is not attributable to the physiological effects of a substance. Because if somebody is on amphetamine, they can hallucinate, they can talk fast, they can be hyperverbal, they can have delusions. Nothing about schizophrenia is due to the amphetamine. So you can't make it, and it's the same for almost every disorder. Everyone we've talked about today, for sure.
So you made mention of bipolar disorder.
Yeah.
When we're talking about bipolar disorder, what is your concern as it relates to bipolar disorder being a diagnosis for Mr. Wilson?
So for a bipolar disorder, you have to have a series of these constellation of these symptoms. You probably can't see it because I can't see it from that far, but it's closer here so I can see it. But you have to have at least 3 or more of these where it goes from 1 to 7, and they all have to occur at the same time. Like for example, one of the one of the issues is decreased need for sleep. Well, maybe I couldn't sleep last night because I was worried about coming down here and having to testify in front of everybody. Okay. But did I also show grandiosity? Or did I also show, was I also more talkative? So there has to be, these symptoms have to show, it's called a distinct period of time of expansive, elevated, irritable mood for at least a week. You have to see these for at least a week, not for a day, but at least for a week. And I couldn't find anywhere in the medical record that any of these symptoms had been established for a period of time that would meet the DSM criteria.
Now, you also pointed out as it relates to bipolar disorder there at the very bottom that the episode is one that's not attributable to a physiological effects of substance abuse.
Correct.
That was something that you previously mentioned.
Yeah, that's right, for the exact same reason.
And then when we get to psychoaffective disorder.
Schizoaffective disorder, excuse me, it's the same thing. Again, it's a constellation of symptoms. This is even more specific than it is for schizophrenia in terms of you have to have periods of both a mood disorder, like depression or mania, and then you have to have symptoms of schizophrenia in between it. So it's even more specific. And I didn't find, first of all, I didn't find that diagnosis made anywhere in the record. I saw schizophrenia and referred to, but it was under history, and it would be where somebody would report it, but I didn't see him treated and diagnosed using this criteria by anybody who saw him in those medical records.
Would that have been a self-report?
About his history would have been for sure, but I didn't see anybody documenting it and make that diagnosis saying, based upon this, he's got this, this, and this, so we're making this diagnosis. I didn't see that.
And why is that important?
Because it establishes if the diagnosis is there or not. If somebody comes and tells you, hey, I've got bipolar and I've been on XYZ medicine, you may say, okay, let's continue on that medicine without ever necessarily seeing those symptoms in that person. And I think that's what you have here, because up until this time, when this event happened, there was no mention of any of that and an actual denial of that in the medical record.
And we also lastly get here to schizophrenia.
And I think you went through some of this in previous testimony about the criteria, and is there evidence of the criteria that was met? I didn't see any evidence of delusions in the record. And you were asked, well, if somebody says something and it's not true, is that a delusion? No, that's not a delusion. If somebody tells you something that's not true, it's a lie. A delusion is a fixed false belief that the person maintains even when given incontrovertible data. So my delusion is that the government is hiding microphones in my refrigerator to spy on me. And you say, no, look, Michael, we just did sweeping. And I still believe it. Me telling you that I don't know, that I never break the speed limit, that's not a delusion, that's a lie. Okay? And so there's a difference. And if a person knows what they're telling you isn't correct, it's not a delusion anymore. There's no evidence of any delusions. I was in the same room, I think I was, at the core where you evaluate people, where they have this big, thick piece of glass and this little square, a little circle like this where you talk through, and a little pass through on the bottom. I'm older, so maybe it's my ears, but I have to speak loud in there. I can hear people in the hallway. I can hear the correctional officers when they walk by. To think that they might be listening to what you're saying, that doesn't even approach a delusion. I think that, yeah, that's probably true. So no evidence of any delusions, no evidence of any hallucinations, denial of hallucinations in the medical record, as I've read to you. No disorganized speech anywhere. And so none of these symptoms are present. And remember, they have to be present for a specific period of time, not just today, for a specific period of time that DSM talks about. And so I didn't find those symptoms. And even if those symptoms were present, were those symptoms, could you rule out that it wasn't due to the effects of a substance? And I don't think you can.
And once again, we get down to the bottom, and that's one of the concerns that the DSM-5 has as well. It talks about the disturbance is not attributable to the physiological effects of substance. Is that right?
That's correct.
Now, doctor, as it relates to your second opinion in this particular case, does Mr. Wilson have a long history of substance abuse?
He does.
Now, when we're talking about substance use, you'd also come up with a slide reflecting your concerns as it relates to Mr. Wilson's seeking of substance, using of substance. Is that right?
Correct.
And why is it of concern to you as it relates to Mr. Wilson's mental health?
Well, because she knows that she first started noticing changes in his behavior around 13. That's in her note. Mr. Wilson, in my interview, told me he was a drug addict since he was 13. As I told you before, parents are oftentimes the last one to know that the kid is using. And so while the mother, I believe that she noticed these behavior changes, and then when he gets into school, he starts getting into trouble. What's he get in trouble for? Selling drugs. I think if you wanted to look at the more logical explanation, is, in my professional opinion, is it more likely that this is an emerging schizophrenia or an emerging bipolar disorder, or is this the effects of the drug use? In my professional opinion, you're seeing the effects of the drug use. And the drugs that he used, talks about cocaine, mushrooms, acid, meth, at various points in his life. So that all of these drugs can affect cognitive functioning, mental status, hallucinations, delusions.
Now, we had also talked about the psychological raw data in this particular case that you also had the benefit of reviewing. Is that correct?
I did. And let me just add one more thing on there. If you look at the mental health records from the incarceration after this event, they have there of a mental status change in him. And if you read it, he's confused, he's not making sense, acting very bizarre. Okay. They take him to the hospital. The hospital diagnoses him with acute respiratory failure, and he tests positive for fentanyl. Okay, so that's a good example of drug use even while he was incarcerated, and drug use affecting mental status.
Now, as it relates to the psychological test data, was Mr. Wilson over reporting his mental health symptoms?
Absolutely.
Okay. What leads you to believe that?
So he was given a test, as Dr. Mills talked about, the MMPI. MMPI is the most frequently used psychopathology test, primarily because it has two sets of scales. One set of scales that tells you what the symptoms are: depression, anxiety, schizophrenia, etc. But another set of scales that are called validity scales. It tells you how the person approached the test, right? Because psychological self-report is valuable. I mean, you want to ask somebody how they're doing, find out how they're doing, ask them. but it's also manipulable, right? If you have a broken leg, they're going to take an x-ray. It's going to show an x-ray either broken or not. It doesn't matter how you feel about that. But when it comes to mental health symptoms, if you're depressed, you can say you're not depressed. And if you're not depressed, you can say you're depressed. And so people, it's almost a natural reaction. If you're taking the MMPI because you're going through a child custody evaluation, where it might determine whether you get custody of your child, you're going to have a tendency to kind of minimize your psychological problems, right? If you're in a situation where your mental health, in a criminal situation where your mental health symptoms may be of some benefit to you, you may exaggerate your symptoms. So while the MMPI, so Dr. Mills used an interpretive report on the MMPI. And if you go to the next one, this is the interpretive report. And the MMPI, I teach the MMPI, published on the MMPI. I love the MMPI. So it says that the profile is invalid. Okay, and that's true. It is invalid, but it's invalid in the sense of what you can make from the clinical scales. But if you read what it says, and you can maybe read it, so I'll read it to you. It says, this profile is invalid because the test taker generated an excessive number of infrequent responses to the MMPI 3 items. This level of infrequent responding is uncommon, even in individuals with genuine, severe psychopathology. Okay. Go down, and it says, in addition, he provided an unusual combination of responses that is associated with non-credible memory complaints. Now, you have to keep in mind, that interpretation wasn't arrived at by Dr. Mills, and it wasn't arrived at by me. It was arrived at by the test publisher, who simply took those responses and compared it to a database of thousands of people who responded to the MMPI. And so that's telling that the MMPI is, that at least in this situation, when he took the test, he was exaggerating his symptoms. So if he's telling you something, you have to be careful how much credence you give to that unless you have some other data to support that.
So in evaluating someone who has these psychological systems, I mean, you rely upon something beyond just self-report. Is that what you're telling us?
Well, you have to. I mean, that's what the test is for. You absolutely, especially in a forensic setting like this, collateral data is essential.
Okay. And there are ways in order to go ahead and test that. Is that right?
Correct, and you just saw one of them.
And how familiar are you with this MMPI?
I mean, I've published numerous articles on the MMPI. I taught it for 10 years at UF. I'm familiar with MMPI 1, MMPI 2, MMPI 2RF, and now MMPI 3. So I feel like I know the MMPI.
Very well. Now, you also, when we're looking at this protocol validity, are those your interpretations of the test?
They are not. They are, like I told you, the test publisher that doesn't have the proverbial dog in the fight. They're just telling you what their data shows.
Now, let me ask you, as it relates to your next opinion, doctor, did you have an opportunity to determine whether or not his mental health history would be consistent with any type of adjustment disorder with mixed anxiety or depressed mood or anything along those lines?
You know, those are diagnoses that were given in there by the people that he saw. I think it would make sense. An adjustment disorder is a psychological reaction to a stressor. You're incarcerated, that's a stressor. He certainly, I mean, it's clear. He reports depression and anxiety throughout his mental health records. I mean, that you need to be aware of. That for sure. But the other stuff, no.
And so that'd be consistent with someone who was actually incarcerated, correct?
Correct.
That they would be depressed.
Yeah.
Okay. Now, does Mr. Wilson have any type of frontal lobe brain damage that would account for his behaviors? That you're aware of, that you've actually had the opportunity to observe or review in any of the records?
after viewing the records, the raw psychological test data, is my professional opinion, within a reasonable degree of psychological probability, he does not.
Now, as we're looking up here at the screen, we have no history of brain injury. How did you come to that conclusion?
Well, we've heard the term today a lot of places, his history of head injuries, okay? And we have been given examples of playing baseball, he got a bump on his head. Those are not head injuries. I mean, if you have kids that get bumps on heads, if you yourself may have had bumps on your head, that's not a head injury. When you're playing football and you get hit, you may feel woozy for a lot of reasons. You may have got the wind knocked out of you. Just because you played football for 4 years in high school doesn't indicate that you've had any kind of a head injury. He reports 2 motor vehicle accidents, which I don't have any records of. Defining a head injury, defining a traumatic brain injury, is also defined in his DSM. There are specific symptoms you have to have at the time of the event. Now, I don't know Mr. Wilson's family. I didn't talk to them. But everything I've heard about them says that they're good, caring people. It's hard to imagine that if there was some concern that there was something strange with their child, that they wouldn't take him to get evaluated if they thought that he had some sort of a head injury. We have no records of a head injury. We have a reported CT. We haven't seen it, but we have reported CT beforehand. And the statement was, well, if they had a CT, it must have been a brain injury. No, it would be done to rule out. So if you went to the ER right now and said, I have a throbbing headache in the side of my head right here, they're going to do a CT to your brain. Why? To make sure you don't have a tumor. That doesn't mean that they think you have a head injury. They're going to get the CT and they're going to say no. He had a second CT, at least one that we do know. This is when he reported headaches and a pressure in his head, is what he says. They take him to Lee Memorial or somewhere here, I think maybe a mobile, I forget how it works. They do a CT of the brain and it comes out negative. Okay, nothing there to support this, and he gets put on Flonase. I'm not a physician, but Flonase is often used for sinusitis and people who have those kind of headaches with allergies. I don't know, but the idea was they did not say brain injury. In fact, it says normal brain CT. So there's no evidence anywhere so I have a hard time when you say, well, he's a history of head trauma. I can't agree to that because I don't have evidence of it.
And you also indicated you had an opportunity to review the incarcerative medical records that did not indicate any cognitive problems. Could you please expand on that, Doctor?
Yeah, so part of what they do here is that they do mental status examinations on you, that they're looking to see if you have these problems. And there are numerous medical records that nowhere in the medical record did I find that he was demonstrating memory problems or cognitive issues. You say, well, maybe they're not looking for that, and you might have it and somebody doesn't notice. Granted. But if your memory's at the 2nd percentile, you're going to notice that. That is really impaired. And in fact, the medical records that you do see indicates memory intact. So I didn't see any evidence of a diagnosis of a traumatic brain injury or of what they call a neurocognitive disorder, something wrong with how you think, anywhere in the medical records before and after this event.
And Doctor, as it relates back to this particular case, you indicated that you had the opportunity to view the actual or listen to the actual statement that he gave to detectives.
I did.
Now, you also had the opportunity and benefit of going ahead and reviewing the various police reports as it relates to the facts and circumstances in this particular case. Is that right?
I did.
Now, did you find that in his statement that he gave to detectives that he had any cognitive problems relaying to the detectives what actually happened?
There was I didn't see anything where he reported memory issues with this. His reporting of things in many ways matched up with what other witnesses were saying, Miss Johnson, or the person at the Mateo graphic, I forget the name where he went to. There was no significant discrepancy. He was able, to say in there how when police were looking for him, he was watching them and knew where they were when they were searching for him. So there was no indication of any memory impairment anywhere that I saw.
And lastly, doctor, when you referred to neuropsychological testing results were not consistent with a neurocognitive disorder, what do you mean by that?
That I don't think that the neuropsychological test results show a brain injury and certainly not a frontal lobe injury.
Now let's talk about those a little bit. I think you had the benefit of listening to Dr. Eisenstein, who gone ahead and conducted a series of cognitive testing upon Mr. Wilson. Is that correct?
Correct. So I had the benefit of the raw data. So what Dr. Eisenstein sends to me is all the forms, his scores, how he did on it. And then I was able to take those scores and put them into a graph for you so that you can see them, to try to make sense of it all. Okay. What you see there, and it's so hard to see, I wish it was better, but when you see the line at the bottom is at 25, and the red line at the top is at 75. And those are percentiles. So the easiest way to explain the data to you is in percentiles, right? And you heard this a little bit. A percentile is how do you match up to other people. So if you're at the 99th percentile, you are better than a line of everybody on the earth, 100 people. You're 99, you're better than the 98 people behind you. If you're at the first percentile, there's nobody behind you. You're at the very bottom of it. We typically call the average range, where most of us fall, okay, most of us are average, between the 25th and the 75th percentile. So when you look at these scores, we're going to see that Mr. Wilson's general IQ, that's the first one, average range, just like everybody else. The second one is his verbal comprehension. That's his ability to use language. That's smack dab in the average range. His perceptual reasoning, his ability to figure out like puzzles and things like that, that's a little low. That falls into the borderline range, 6th percentile, so that's a little low. His working memory, which is a frontal lobe measure. Working memory takes place, it's your ability to temporarily hold information and process it. So like, when I tell you a list of things and want you to manipulate it, that's where your working memory is. His score there is in the average range. And his processing speed, how fast, you can respond to things and pay attention to things, is in the average range. A very important component of frontal lobe function. So when we look at these things, we have these test scores within the average range. Now, when we get over here at the bottom, we have some pretty impaired scores. I mean, I'm going to be honest with you. We have memory scores that range from, I think, the 5th percentile down to the 2nd percentile. Those are impaired. There's no doubt about that. We'll talk a little bit more about those later, but just keep that in mind, that those scores are falling at the 2nd percentile, which means out of 100 folks, he's at number 2. There's only one person below him. So this is the general cognitive testing results. And then Dr. Eisenstein was good enough to do some specific tests on frontal lobe functioning. So as neuropsychologists, we can test different parts of the brain. We know that the memory is in your temporal lobe, and so we have special tests that can do that. We know that ability to be flexible in your thinking is more frontal lobe. And so we have a wide variety of tests. If you go to the next slide.
And that's where we're talking about the executive functioning tests that Dr. Eisenstein had gone ahead and had Mr. Wilson perform. Is that correct?
Yes. So there are a couple of tests that he did. The first one is the working memory. We talked about that. That's in the average range. The next test is a digit span test, which is your ability to focus. You have to, I repeat digits to you, 1, 5, 7, 9. You have to say it back to me. Then I say 1, 5, 7, 9, and you tell them to me backwards. And then I say 1, 5, 7, 9, and you tell them to me in order. Very complex cognitive functions in the average range. Another test in the average range is a test called similarities, very frontal lobe. I tell you, how are a bicycle and a car alike? They're both transportation. And then it gets harder. How are poverty and wealth alike? So it goes, but it really requires your brain to synthesize, because you have to know poverty, you have to know wealth, and you have to be able, how are these things the same, because they sound pretty different to me. In the average range, and then arithmetic. Arithmetic is not just a math test, so it's ability of working memory. So the test is relatively simple, the math is simple, but I'll say to you, you know, John went to the store, he bought 2 dozen eggs, he bought 4 onions, 2 cans of soup. How many items did he buy altogether? And you have to remember what was said in all that. The math is simple, you just add them up, but to be able to remember all that. Everything is in the average range. He does score particularly low on a test called the Wisconsin card sorting test. That's the one Dr. Eisenstein described to you, where you have to match things. He did pretty low in that, no doubt about it. So we have a particular frontal lobe test that he did not do well on.
Is there a concern there, Doctor?
Well, it could be. Let's go to the next slide.
Very well.
Dr. Eisenstein was concerned about frontal lobe executive function, which is reasonable. And so he gave a specific battery of tests called the Dellis-Kaplan Executive Function System. All of these tests are designed to test one thing: executive frontal lobe functioning. Okay. And we heard before that Mr. Wilson didn't score in the average range in any of those. That's not correct from the data. He actually scored in the average range on almost all of them. And in fact, he scored in the high average range. One of the tests, man, my eyes are getting so bad, I need to get glasses. Okay. The fourth one in, 1, 2, 3, 4, trial is called letter number sequencing, which means you have to have numbers and letters randomly placed on a page. And you have to go 1A, 2B, 3C, 4D. You have to have cognitive flexibility. You have to be able to switch back and forth. That test is well within the average range and almost in the high average range. So I have to take that result and I have to compare that to the one I showed you on the previous page, the Wisconsin card sorting test, where he did poor on a test that measures perseveration or ability to switch back and forth between things. And so when I look at all of these tests together, okay, there is not a pattern of frontal lobe dysfunction. You heard Dr. Eisenstein say that you would never make a diagnosis based on one test. And so I have to look at, do I have a pattern here of executive function deficits? And the answer is, on the testing, no. And then do I have a pattern of executive function deficits outside of the testing? So when I look at this testing, I do not see evidence of a clear frontal lobe, any type of frontal lobe impairment. Yes, there's a test that he does poorly on. But you know, the fact of the matter is, this is data. If you give a battery of neuropsychological tests to college students, they will fall into the low range on 1 or 2 of them. It's just how it is. That some things you're good at, some things you're not. If I saw a pattern, if these executive function tests were all down low, then I'd be probably telling you something different today. But when I just have 1 or 2, and even on the one where he does the verbal fluency, he's able to give a number of, when you ask him to give you a list of words based on the first letter they start with, he does fine. When you tell him that to give you animals, he does poorly, very poorly, I can't, that doesn't make neuropsychological sense. It makes much more sense that he got tired, or he said, the heck with this, or something else. But remember, in neuropsychological testing, you can't be worse than your highest score. You can be better than your lowest score, but you can't speak smarter than you are, right? You just can't do that. And so when I see these average test scores, to me, it indicates that we don't have an issue here.
So if you take a test and you ultimately decide, you're either too tired or you stop, and could that affect your scores?
Absolutely. I mean, of course it does. Sure.
Now, lastly, Doctor, I wanted to ask you about whether or not you formed an opinion as to whether or not his memory and executive function test scores are consistent with his behavior.
Are what?
Are consistent with his behavior.
They are not.
And why do you say that, Doctor?
Well, we talked about this a little bit, but somebody with that severe executive function issues, they have a hard time functioning in their life. I mean, operating a motor vehicle, taking care of themselves. If you have memory at the 2nd percentile, I think on one of the tests Dr. Eisenstein gave him, he told you he fell 7 standard deviations below the mean. Remember that? So 1 standard deviation below the mean puts you at the 16th percentile. 2 standard deviations below the mean puts you at the 2nd percentile. 3 standard deviations below the mean puts you at the 0.1 percentile. I don't know how you get to 7 standard deviations below the mean. That would be such, it's almost an impossible score. How could that be? No tables I know go down that low, because you can't be 7 standard deviations below the mean. How can that be, and how could you even interact? When you look at his memory, we don't see this. This would be catastrophic memory impairment, right? It would be catastrophic. It would be noticed by somebody in the last 10 years.
And you didn't see any catastrophic memory issues with Mr. Wilson in this particular case?
No memory issues at all.
And even when he sat down with detectives and relayed to them exactly what he had done and described the events to the detectives, you indicated that that was consistent with the information that the detectives had. Is that correct?
Absolutely.
So that would be consistent with your conclusion that he did not have any memory deficits.
Correct. I mean, the emails to these people are very detailed from what they talked about before. I don't see anything.
Why is no evidence of mania or psychosis important to you as it relates to inconsistencies of data and behavior, Doctor?
Because you might not notice somebody in prison who was depressed, right? Parents may not notice a depressed child because he's just sort of quiet and stay. Teacher may not notice a depressed child. They'll notice a manic child because his behavior is going to be in their face. It's going to be disruptive. There is no indication of that to meet the criteria anywhere that I could find in the record that I reviewed.
You didn't notice any of that in the police interview with him?
I did not.
And you didn't notice any of that on the police body cam that you observed with Officer Tim McCormick?
No, he's actually very coy and focused there, right? I'm here to meet my girlfriend. What are you talking about? Puts the window halfway down, and then when the officer starts saying, I'm just waiting for my buddy to get here. Can you shut the car off? And that's when he skedaddles.
You also indicated that you relied upon witness statements such as the one to Joshua Lukic, as well as Miss Melissa Montanez, as well as Miss Stephanie Johnson. Yes. And would those also be indicatives of you didn't see any evidence of any type of mania or psychosis in those statements?
I didn't, in anything I reviewed.
Now, lastly, I believe we'd already discussed that you did not observe any evidence of any type of executive function brain damage in any of the records. Is that what you're telling us here today?
I did not. I just showed it to you.
What about the events surrounding the murders?
I did not.
How did you come to that conclusion, Doctor?
That there was nothing, I mean, while the behavior was aberrant, I mean, it was something that we wouldn't do, the behaviors were planned in a sense, right? That I can't find the school. Can you help me find the school? Oh, it's over there. Yeah, I looked, I couldn't find it. Can you show me? I mean, afterwards, fleeing, the going to the friend, hey, I just killed some people, I need to get out of town, calling some people, hey, I need some help, hiding from the police, all of that is relatively good planned behavior. I mean, maybe you wouldn't do it, but it's not this impulsive, I didn't know what to do.
And now, last line that you had there was life functioning. What evidence or no evidence did you find of executive function, brain damage, and life functioning? What do you mean by that, doctor?
I don't have any problems with him doing adult daily living activities. He drives, he's able to interact with people, he's able to socialize when he goes out to the bar. He's able to interact. There's just no evidence of this frontal lobe damage that we've heard about.
And was he able to seek help when he needed it?
For sure.
Especially after he did something bad?
Correct.
May I have a brief moment, Judge?
Yes.
Yes, Doctor, I have one last little question for you. You indicated back in your training experience, did you have an opportunity to become involved in and familiar with the jail mental health treatment of individuals?
Absolutely, I did.
Could you please describe for us what your experience is in relation to that particular area?
Sure. Back in the early 1990s, the state of Florida got sued by the Department of Justice because they weren't providing adequate mental health care to people in jails. And so at that point, as part of the settlement with the federal government, they started out of the governor's office a program called the Correctional Medical Authority. And what the Correctional Medical Authority did would bring people like me, consultants, psychiatrists, psychiatric nurses, and we would go into the prisons and jails, and we would review the medical records. We would talk to the inmates to make sure that the inmates were getting adequate medical care. The state of Florida was doing it so that they wouldn't get sued again, but also to do the right thing. So I have been in reception centers, correctional institution jails all over the state, reviewed hundreds of these files. And I can tell you that the mental health people that the state of Florida employs are licensed. They're responsible for the same ethics and standards that I am. And so I would expect them to be able to see a bipolar disorder there, or to be able to see a memory disorder or something if it's there.
Why is it important that inmates get the appropriate care while in custody, besides obviously the jail being sued?
Well, because first of all, you want to do the right thing, right? I mean, we're compassionate people. If you have a problem, we want to help you. But secondly, if you have a patient, an inmate that is bipolar or that is schizophrenic and untreated, they're going to be a significant behavior problem. We talked about that they're interested in control. Well, part of that may be true, but those are two populations you better control.
And why is that?
Because they'll be disruptive. Imagine a schizophrenic inmate who was having delusions on the cell block or anywhere else. It would be horrible.
Would you consider that to be a safety concern as well?
Oh, absolutely, for everybody, not just for the inmate, but for the people around him.
Now let me ask you this, doctor. As it relates to Mr. Wilson's medication history, did you have an opinion as it relates to that?
Yeah, so Mr. Wilson's medication history up until he was arrested for this consisted only of an antidepressant, almost always Celexa. When he came into jail at this time on this, he told the staff that he was on a variety of these medications, and they started those medications. I don't have any, we say he's been on these medications. I don't have any record he's been on anything but Celexa and maybe another antidepressant up until he came in for this event. And I don't have any medical records that he ever sought treatment when he wasn't receiving it from incarceration.
Okay. I have no further questions for this witness at this time, Judge. Thank you.
All right.
Judge, can we approach for a second?
Okay. Say 15 minutes. Just leave your notebooks here. Mr. Shirley, Mr. Hollander, if y'all will just wait.
Kevin.
Let the record reflect the jury's exited the courtroom. You can be seated for just now. So, Mr. Shirley, just record the jury's out of the courtroom. State's present, defense counsel, and defendant are present. Tell me what it was.
I think we can handle it on cross-examination, but I need to talk to our expert first.
Okay.
Okay?
Okay. So, give you 15 minutes.
That's
See where we are.
That's fine.
Okay. Then we'll be in recess for 15 minutes.
Thank you.
All right. Let the record reflect, state's present, defense counsel, and defendant are all present.
Judge, when I approached the bench earlier, what I was asking the court to consider is
Yes.
allowing us rebuttal. I understand that's.
I'm aware of it.
That's discretionary with the court.
It is provided for in Florida case law, so I am aware of Sir Rebuttal.
So that's what we were asking for. I don't know how close we're going to get to where we need to be in just cross-examining this witness. But
Well, let's finish that part of it, and then we can address whether or not you want to do Sir Rebuttal.
yes, sir.
Sir Rebuttal, is my understanding of the law on it is that if there are points brought out during the state's presentation and rebuttal, new points,
Right.
then the defense may rejoin those in Sir Rebuttal
Right.
by their own witnesses.
Yes.
Is that what your understanding is?
Yes, sir. It's very finite.
Okay.
Thank
All right. All right, then. Are we ready to call the jury back in, and then are you ready to do cross-examination?
Yes. State's ready, Judge.
Okay.
Yours entry.
All right, please be seated. All right, Mr. Hollander.
Afternoon, Doctor.
Good afternoon, Mr. Holland.
Say evening. Just a few questions. You are not an MD, a medical doctor?
I am not.
You testified earlier that you met with Mr. Wilson for over an hour?
I wrote down an hour and 5 minutes.
Okay. Did you do any testing yourself?
I did not.
You said that you're in private practice now?
I am.
Okay. You do mostly civil. What type of work do you do for civil?
So as a neuropsychologist, it'd be traumatic brain injury. Somebody was involved in a motor vehicle accident, or they had a fall, and do they have a brain injury? I will do things such as post-traumatic stress disorder. Somebody had something happen to them. They were attacked, or they were in an accident. Do they have PTSD? I will see people for grief. They've lost somebody, and how are they coping with that loss? I mean, those are general areas.
When you deal with people who have suffered traumatic brain injury, do you or can you, since you're not an MD, can you request brain scans?
No, I would have to have a neurologist or another physician. I could ask a physician to, but I don't know how I would do that. No.
Okay. Do you review brain scans in your practice?
No, I don't review the scans. I review the report of the physicians with the physicians. But no, I don't look at actual films.
Do you request MRIs instead of CAT scans, depending on the nature of the injury.
How to request any of those? Usually they will come to me. So even when I was at UF, I don't request an MRI. It would be that somebody had a fall and here's their MRI and let's do some neuropsych testing on them.
What type of criminal cases? What type of criminal practice?
So it's varied over the years. When I was at UF, we had our training program. We did a lot of competency because the good training cases. Now I would say that I mostly do, last 10 years probably sanity mostly, some competency, some mitigation.
Do you do any court-appointed cases for a criminal, I guess it would be defense?
Well, so I had a recent competency where I was appointed actually by the judge, so to report to the court. That was a Volusia kind of case. That was competency. So that was, I guess, is that what you're asking me?
Yeah.
Yeah. Not a lot of those.
Not a lot?
No.
Okay, how many have you done?
Oh, I could never tell you the number, but.
Well, since you went into private practice.
Again, I don't keep those kind of records. I could tell you that would be the smallest number of what I do.
Okay. Does that mean that the rest of your criminal cases you're privately retained?
So when you mean privately retained, most of the time I'm asked by the state or the public defender's office. There are some times where there is a private defense attorney who will ask me to get involved. So I've had some of those, but those are also rare. Usually it's part of the government legal system.
What is your hourly rates or for your professional services?
So it's different for civil and criminal. For criminal cases, it's $3.50 an hour for everything, except for travel, which is $200 an hour.
And civil?
Civil is $4.50 an hour for everything. Travel is $300 an hour, and any kind of testimony or a deposition or trial is $600 an hour.
Is that both civil and criminal?
No. It's, I can if you want me to, but no. For criminal, it's the $3.50 flat rate for everything except travel.
Okay, so it's $600 for testimony in the civil cases.
Yeah, deposition or trial.
Okay.
And it goes up.
How many hours have you put into this case?
So I had a couple of hours reviewing some records, maybe 3 or 4 hours before I came down on Wednesday. Wednesday I was given a big stack of records to review. So Thursday, so mostly Thursday, Friday, and Saturday I did mostly this. Friday, as you know, I was in all the depositions that took place, and then Saturday. So I've been, this is not an exact figure, but I'm probably somewhere around 20 hours since if we add it all together.
When were you first asked or introduced to the case, brought into it?
I don't know. There might be an email, or I didn't bring that information. I was contacted though several months ago that I might be asked to get involved in the case if there was a conviction and there was any kind of this type of hearing. But I don't have an independent recollection of that, but that's likely what would have happened.
Okay. Now, you said you, as part of your preparation, you reviewed records?
I did.
Okay. You said you reviewed school records. How many of those did you say review?
I think there are 2 pages of them. Leon County School Board.
That's Tallahassee?
Yeah, Leon County's Tallahassee. I think those are the same records that Dr. Mills and.
Is there anything, were you expecting more records from Leon County?
I don't know what to expect. I got these on Friday during the depositions. Before that, I wasn't aware that that these records even existed.
You said you interviewed Mr. Wilson on the 19th of June?
I did.
Okay. You see anything in there where he apparently knew who you were? Did you see anything in there indicating he was lying?
That he knew who I was.
Well, first off, he knew who you were, right? He told you, I'm going to talk to you for 15 minutes. We're done.
Well, the way it usually comes in, I say, hey, look, Mr. Wilson, my name is Dr. Herkov. I've been asked to do an evaluation on you by the state. I go through all the parameters. Hey, look, this is forensic. I'm not your treating doctor. Nothing you tell me, don't say things off the record. So whether he knew, I'm sure you told him I was coming. I mean, somebody must have told him I was coming. It was arranged with the jail. But that's typically what I do in the beginning. I explain why I'm here.
Anything during that hour and 5 minutes that indicated he was lying to you?
I didn't get the impression that he was lying. I mean, he was pretty straightforward, at least in terms of what he told me. And I didn't want to talk about the case because I get that, so we didn't talk about that. But his history, again, he says he was bipolar. I don't see that a lie. He says that. I just didn't have the record to believe. But no, I don't think, I didn't get anything where I thought he was lying to me.
Okay. Anything in there where you thought he might be delusional or hallucinatory?
Clearly not. There was no paranoia. There was no delusions. There was no active hallucinations.
You said you reviewed the statement he made to, I think it was Detective Hicks.
I don't remember the detective name, but yeah, I've got yeah, absolutely.
Did you see in there where he said that when Miss Ruiz tried to run away, he ran her over 10 or 20 times?
I did see that.
Did you see the photograph of Miss Ruiz under the bush when they found her?
I did not.
Okay, so you didn't see that her blouse had zero tears, shreds, or anything else?
No, I saw the medical examiner report about the injuries, but no, I didn't see any photos.
You said you saw 10 to 13 years of medical records.
Yes.
Was that part of that stack of records you received?
Yeah, the ones that I saw went back to 2013.
Okay. And they were from what facility or facilities?
Well, I didn't bring the whole stack with me, but it was from places where he was incarcerated.
And he was given lithium?
Not before, no. None of
Before what?
Not before 2019 when he came in for this arrest. All the records I looked at before, all I saw was Celexa. Now, if that's wrong, show me and I'll admit to it.
Okay. And what is Celexa for?
Celexa is what we call an SSRI. It can be used to treat both depression and anxiety.
And that he had that for, how long was he being prescribed that, going backward?
Can't tell you the exact, but for a good part of that time. I don't know if it started exactly in 2013, but that was a common medication that he received.
So somebody, several people along the way decided that's what he needed.
Absolutely. As I said before, I think the depression and anxiety he reports is pretty consistent in the medical record.
In your career, have you ever reached a conclusion or deviated from the DSM, from their classifications?
Well, I'm sure if I did, you're going to point it out to me, but I don't recall. I mean, the DSM is what I use for making my diagnoses.
Well, I understand, And each diagnosis has a certain number of criteria.
Correct.
Have you ever run into a case where you've said, I know that this says this, but I think this?
I don't recall it. I don't recall if I did that.
Who prescribed the lithium and the Paxil?
I can't give you a name, but this would have been the psychiatrist after his most recent incarceration. So after October 8th, 2019 is when I saw those medicines and others being prescribed.
Was it a doctor that prescribed them? Had to have been, right?
I mean, in the state of Florida, I mean, it could be a nurse practitioner, but I'm assuming I think it was a psychiatrist, but I'm assuming that, but I can't give you the person's name. I don't recall that.
And while we're on that, the commission in 1990, all these jails have gone to private providers now, haven't they? None of them have their own employees.
No, but the CMA is still responsible for, I mean, you probably know it was the Costello case that got Florida in Dutch on it. So I don't know what all the dynamics are, but yeah, you're correct. Most of the jails now are being run by private companies who are providing the providers.
And the private companies make their money by saving the jail money, correct?
Well, you're getting into something that's beyond my expertise as a psychologist and neuropsychologist. I don't know the economics of it.
But I thought you were still on the committee.
No, I don't do it now. I've done that for years. I've looked at over the years. No, I haven't done it in several years.
How do you treat bipolar disorder?
A bipolar disorder, like a schizophrenia, is to be primarily treated through medication.
Which medications?
I mean, I'll leave that up to the psychiatrist, but there are a number of mood stabilizers, from lithium to sometimes they use anticonvulsants. There are probably half a dozen so different medications they use to treat bipolar disorder.
Did I misunderstand you that if you're dealing with a bipolar person untreated, they're going to end up in a hospital?
A person in a manic, not every single person, but people in a manic episode are disruptive, and they will be noticed, and they oftentimes end up in hospitals.
And what about in jail?
The jail actually has, in Florida, the jail has hospitals. The jail has places called CSUs, critical crisis stabilization units, where they can go to. They have TCUs, transitional care units, and they have a mental health hospital up in Tallahassee, the correction up at
Chattahoochee.
Well, Chattahoochee is where you go when you're, but there is CMHI, correctional. So they actually have a mental health hospital you can go to while you're in prison and come back. So they have all those things.
They have them, but do they use them?
I've seen people sent to them. I can't tell you the dynamics or the frequency, but they have them. I would assume they use them.
You said that on September, well, let's go the other way. October 23rd of 17, that Mr. Wilson denies auditory hallucinations.
Yeah, I got the note right here.
He was in custody at the time, correct?
Correct. Yeah, for sure.
What happens if he says he is hearing voices?
I mean, a number of things could happen, from nothing to being placed on medication.
Okay. What about on September 12th of 18, he denied mania?
Correct.
And what happens if he admits that he's having manic episodes?
No, if you read that is he's denying a history of mania. If somebody has mania and they're in front of you, they don't have to admit it. you can see it. So this is more, if you read that note, they're talking about his history of mania, not mania at the time.
I may have misunderstood, I apologize.
Yeah.
But if he knows, or if he wants to avoid the effect of admitting something, he could just deny it to you.
Sure, he can deny something that's there or make up something that's not, absolutely.
Do you agree with Dr. Mills's statement that cocaine makes people with psychotic issues more volatile?
Well, I mean, cocaine, again, I think Dr. Mills said you have to look at each individual substance on a particular person because different drugs. But cocaine is pretty stimulating. It can make you psychotic all on its own. If you're psychotic and you take cocaine, it ain't going to help.
Okay. Can it exacerbate?
Yeah, it could. It could, for sure.
Could it make you have black holes for eyes?
I'm sorry?
Could it make you have black holes for eyes? No soul.
Black holes for eyes, no soul. I mean, I'm not sure that's a clinical psychology question.
All right, we'll pass. I get you're complaining that they don't have records. Am I correct? That there's no records to...
I'm not complaining. I'm just saying that the only records that I do have that go back to 2013 don't document anything that's here. The fact that we don't have records before, I'm not complaining. I mean, it is what it is. But we don't have anything that could say other than self-reports.
Well, you also have the adoptive mother. I mean, she made a 4-page sort of report.
I mean, so I have nothing bad to say about the adoptive parents. But, I mean, let's look at her report. 2005, May 11th birthday, September, Deer Lake Middle School, Tallahassee. That's a report for 2005. I mean, 2006, May 12th birthday, September, DLM. I think that may have been, I don't know. I mean, these are 2009, expelled from Childs, entered alternative high school, lives at home, May 15th birthday, September alternative high school, November Pop dies. He was very close to him. I mean, that's what she wrote, but that's hardly a detailed mental health assessment.
Okay. But you incorporated that in your consideration, though, right?
I got it on Friday, and I've certainly looked at it since then, for sure.
And you've seen the sister/doctor's report, statement?
I have, yes.
Okay.
Yes.
There are no, I'll call them old reports from medical facilities where he may have been treated.
Not that I've seen.
So I get the feeling that you basically evaluated the data from Drs. Mills and Eisenstein and just say, I don't agree with it.
Well, I don't know if I looked at the data from Dr. Mills, and we both agree that the MMPI is invalid. We both agree that the MMPI is exaggerated, so at that data, we agree. When they say that he has been diagnosed with schizophrenia and schizoaffective disorder while he's incarcerated, I can't find those diagnoses. So if you show them to me, I'll say, okay, I made a mistake. You're right. I see in there where he reports a history of that. And I see where, and even in the medical records before this, I see where he says he has a history of bipolar disorder, but I don't see any documentations of the symptoms. So I don't necessarily disagree with them. They're both smart guys. They can give their own opinions. I'm just telling you that when I look at the data, I don't see the same thing for the reasons I gave you. And they told you why they found it for the reasons they gave you.
One moment, Judge.
Yes, sir.
Doctor, one last question. Did you personally recalculate the results from Dr. Eisenstein's raw data?
So what I did was I did two things. So on his scores for like on the MMPI, I didn't recalculate anything. I just took the publisher's printout, what they did. So I didn't recalculate that. On the wait a second here. I'm sorry, I got papers all over the place. On the DKEFs, the Dallas Kaplan Executive Function System,
Yes.
I took his numbers and I went to the manual and I looked up the scores, what it would be, and it was the same scores he got.
Okay. And the manual being the DSM, or is there some other?
No, so remember we talked about the test, the Dallas Kaplan Executive Function System? So that has a manual where you say, okay, if it takes the person 18 seconds to do this and they're 35 years old, then that gives you this score, and this score corresponds to the 20th percentile.
Okay.
And so
that's
I got the exact same scores he did.
separate publication from the DS.
Oh, yeah, no, it's for the test, yeah.
All right. Nothing further, Judge.
All right. Anything else? All right, sir, you can step down.
Thank you, Your Honor. Thank you all.
You want to approach and talk about scheduling? Excused yet.
Okay.
All right. Any other rebuttal witnesses for the state? Okay.
We would recall Dr. Eisenstein to the stand, please.
All right. And this is the sir rebuttal.
Sir, rebuttal. Very, very, very brief.
All right. You can come up. Sir, you're still under oath. You can take the stand. All right, you may proceed.
Thank you, Your Honor. Doctor, you've heard Dr. Herkhoff testify here today. Is that correct?
Correct.
And he basically said that he got the same numbers you did?
Correct.
And how do you reach those numbers?
So there's manuals, there's normative data. For example, on the Wisconsin card sorting test, there's norms based on his age. And when I calculated there was 7 standard deviations below the mean, those are real numbers. The level of impairment is so profound that it is beyond what we normally expect. And as a neuropsychologist, we need to explain it. We don't dismiss numbers. We don't dismiss data. We look at it very seriously, and we have to understand how the brain is processing that in contrast or in relationship to all the other data.
So a 7-level deviation doesn't even have, it's so low it doesn't even have a numerical equivalent?
That's correct.
The only other question I've got is, in reviewing the jail records, prison records, all of the other records, presumably everybody has the same records. Were you able to determine whether or not there was any medication that was prescribed for Mr. Wilson during one of his various stays?
Yes, I was.
And what are those medications?
So on 5/18/22 in the medical records, he was given Risperidol 1 milligram. 5/18/22 Invega. 5/18/22 Zoloft. 12/23/22 notation of Depakote. 2/13/23 Cymbalta. 6/27/23 Abilify. Currently lithium. In 2021, he was diagnosed with bipolar and antisocial disorder. He was also given in 2021 Lexapro 20 milligrams, Buspar 15 milligram, lithium 600 milligram, Trilpal and Lamictal. 3/8/22 bipolar versus schizoaffective was in the records. These are all documented in the jail medical records.
I don't have any further questions. Thank you.
Okay. All right, you can sit down.
Can I have the court's indulgence to ask one question of Dr. Mills?
All right. Sir, Doctor, you're still under oath, so.
Thank you. Dr. Mills, you've just heard Dr. Eisenstein testify about various medications,
I did,
and you are a medical doctor.
yes.
And what are those medications usually prescribed for?
Well, the medications like Abilify, Gigadon, Risperidol are all antipsychotic medications. They are used either to treat schizophrenia, schizoaffective disorder, or bipolar disorder.
Okay. I don't have any further questions.
All right, any questions? All right, you can step down.
Thank you, Ron.
We will rest again.
All right. All right, it is 5:45, ladies and gentlemen. So what I'm going to do is let you go home for the evening, come back tomorrow morning at 9 a.m. I know you've heard my instruction before. It remains the same. Don't look up anything. Don't discuss anything about this case with anyone. Don't watch any local news, read any local newspapers, and please follow those instructions, and we will see you tomorrow morning at 9 a.m. Leave your notebooks here. Make sure you get everything out of the jury room. The bailiff will escort you out. Particularly that either party wants the court to address at this point.
No.
Okay. Jury instructions. You can be seated. It's okay. You have a copy of the latest final instructions, everybody?
Not yet, Judge.
Yes, you haven't changed them again, have you? Those are the ones right after lunch? Yes. Yeah, we've been providing a copy.
So I know I raised an issue, and it looked like the state's latest draft kind of addressed it, but I don't know if that's how you all want to do it or what your feeling was. But
I don't think we're going to have an issue with the way that, Mayor Stacy,
yes.
I don't think that we're going to have an issue with the way that Mr. Gardner's addressing it. Because of the unusual circumstances, he split it up into, these are aggravators for this one, these are aggravators for this one, and then the mitigating circumstances apply to both.
And there wasn't language about that, though, about applying to both. Or was there?
It doesn't specifically say that, but maybe we can put that in. He just didn't want to retype all the mitigation language.
I'll read whatever you all agree to, as long as it comports with the law. So I just want to make sure that it's done correctly and that there's no typos.
How about just the sentence, the following applies to both, and then it goes into the mitigating circumstances language.
I've seen it done the way the state originally has done it, even with there's more than one victim. But I've also, considered the fact that you have two separate counts, and so there may be some findings. The verdict form reflects that there could be separate findings as to aggravators and mitigators on each count. It's just I didn't know if the instructions needed to be consistent with the verdict form. I felt like it should, but if I'm wrong, I don't want to force you into doing something that you don't think is proper under the law. But
No, I don't know that it practically it makes any difference, because we're going to obviously argue what we're going to argue. It's just that I think the facts and circumstances between the two homicides are so separate and distinct that the jury could reasonably come to different conclusions about both of them.
they may find an aggravator as to one count, but maybe not as to another, but there may be some confusion if we don't separate them out, is what my concern was.
Yes.
Okay.
I'm sorry, how about each homicide is going to have its own aggravators and mitigators?
That's fine.
That's my understanding. That was the latest rendition, except, well, now, it didn't have each count have the same mitigators, but if they can make a separate finding as to the aggravators in one count, they could also make separate finding as to mitigators.
Yeah, but the aggravators are focused on the facts and circumstances of the individual homicides, and the mitigating circumstances are more universal.
I understand that. I'm just saying I don't know, but I want to make sure that it's not confusing for the jury and accurately reflects the law.
No, and I think that we've come to a little perplexed.
Judge, I'm proposing the following language, which just before we get into the actual mitigating circumstances that have been proposed by defense counsel, the language indicates among the mitigating circumstances for each count you may consider are.
That's fine.
Okay.
That
Okay.
makes sense.
All right. Well, I'll let you all draft that up tonight. If you can email it to the defense and to the court, I can review it tomorrow morning before we come in. And we'll see you all at 9 a.m.
Yes, sir.
Okay. Any other issues the court needs to address before that? Okay. All right. Then we'll be in recess till 9 a.m. tomorrow morning.
Done for the day.